It's 1:14 p.m. The Committee on Judiciary and Civil Jurisprudence will come to order. The clerk will call the roll.
Leach.
Here.
Johnson. Davis. Moody.
Present.
Murr.
Here.
Schofield. Basut. Slauson.
Here.
Flores.
Here.
Quorum's present.
Okay, Comer's present. We're going to go back and finish Representative Van Dever's bill. The chair lays out as a matter of pending business House Bill 4376 and recognizes Representative Van Dever to explain the bill.
Thank you, Mr. Chairman. Members, this is the Asset Protection Trust bill that I laid out prior to going to the floor, and I will just yield to questions if you have them. Not that I could answer them necessarily, but I know that we have some people signed up to testify.
Okay. Okay, members, any questions? All right, thank you, Representative. Mr. King, why don't you come back up? And William Pargerman, our only other additional witness. Is Craig Hopper here? Craig's already taken off? Okay. The chair calls Ben King. Ben, I've got you here on behalf of Ross and Schollmeyer, PLC, and yourself, registered for the bill. Is that correct?
That is correct.
Okay. And I understand, sorry to rush you before we went into session. I agree with you and understand that this is an important bill. I know Representative Schofield had some questions, but he's not here, and so he'll have the opportunity to correspond with you offline.
And I'll be happy to answer any questions he may have or any of the other committee members may have. If you could indulge me, just for 2 points. Sure. That I wanted to make. There was an issue raised with regards to bankruptcy prior to our recess. The bankruptcy code has been extended, does have an extended limitations, and that is federal law that would trump some of the protections offered in an asset protection trust. Also, Texas as a community property state, most asset protection trusts, if I'm not mistaken, Nevada is the only state that is a community property state that also has a domestic asset protection trust. Texas, being a community property state, has some inherent protections for any spouse if that may end up being an issue in a divorce proceeding, which I believe Representative Schofield had raised a question or two on before we had to break. With that, I don't have any additional comments at this time, and I appreciate your time.
Okay. All right. Thank you, Mr. King. Members, any other questions for Mr. King? Okay. And I know Representative Schofield to know you'll probably be hearing from him at some point. All right. Members, no other questions. The chair now calls William Pargerman. Mr. Pargerman, I've got you here on behalf of the Texas Real Estate and Probate Institute and yourself testifying against the bill. Is that correct?
That's correct.
All right, go ahead. The chair will show Representative Basut is present. Go ahead.
I'm the second string behind Mr. Hopper. I want to thank Chairman Leach and the committee members for their attention. My name is Bill Pargerman. I'm a trust and estates lawyer here in private practice in Austin. I hope most of you are familiar with the real estate probate and trust law section of the state bar. I was on that section's trust committee for the first decade of this century and chaired that committee for 4 years. Beginning with the 2009 session, I took over the section's legislative chair on the estate and trust side, and I held that for 3 sessions. Mr. Hopper took that over in the 2015 session, but I've continued to author or co-author the annual legislative update in this area that's presented to lawyers at many seminars around the state. I believe you've been informed at previous hearings that Reptil is no longer in the legislative business, but the Texas Real Estate and Probate Institute, or TREP, has assumed that role. You've previously heard from Lauren Hunt, who is TREP's legislative chair on the estate and trust side. I'm on the board of TREP along with Mr. Hopper. It's been a long-standing concept in trust law that one person can create a trust for the benefit of another person and protect the beneficiary from his or her own folly by prohibiting an assignment of the beneficial interest, effectively preventing the beneficiary from selling his or her interest to another. This is called spendthrift protection. However, it's also been a long-standing trust concept that you can't put property in a trust for yourself and gain the same protection from your own creditors. In recent years, a handful of states have adopted statutes that authorize self-settled asset protection trusts. As Mr. King just pointed out, of the 9 community property states, only one, Nevada, has adopted this type of legislation. The proposal provides that a spouse, former spouse, child, or dependent of the settlor is not a beneficiary of the trust unless the trust expressly says so. This appears to prevent a court from reaching the trust assets for the settlor's child support obligation and may prevent a court from considering the formerly community assets in making a just and right division of the community estate in the event of divorce. As an aside, Mr. King said there's protections already built into Texas family law, but what you may end up having is a battle between the family code and the trust code as to which governs. The proposal makes new rules regarding the application of the rule against perpetuities that only apply to self-settled trust. Under this proposal, if someone transfers assets to a trust for his or her own benefit, an existing creditor must challenge the transfer by the later of 2 years after the transfer or 180 days after the date on which the creditor discovers or reasonably should have discovered the transfer. A future creditor is just limited to challenging the transfer within 2 years. In either event, the creditor bears the burden of proving that the transfer was fraudulent by clear and convincing evidence. Finally, I would urge the committee to consider the fairness of the bill. I heard someone say earlier this bill would promote small business. That really depends on your perspective. If you're a small business with a valid claim against a debtor, and I will finish in one sentence. If you're a small business with a valid claim against a debtor, it's not promoting that business if it finds out it can't collect on a claim from assets that used to be available to the creditor, are still available to the debtor, but now have spent their protection. That's all my testimony. I'm available to answer questions.
Mr. Parkerman, members, any questions for the witness? Okay, thank you both for being here. I appreciate it. Does anyone else wish to testify on, for, or against House Bill 4376? Seeing none, the chair recognizes Representative Van Deaver to close on the bill. The chair will show Representative Schofield as present. Did you say that?
Thank you, Mr. Chairman. I close.
Thanks, Representative. Go ahead.
Thank you, Mr. Chairman. I close.
Okay, members, any questions for Representative Van Deaver? All right, thank you. Appreciate you bringing the bill. The chair will leave House Bill 4376 pending at this time. The chair now lays out HCR 75 and recognizes Chairman Guillen to explain the concurrent resolution.
Thank you, Mr. Chairman. Members, HCR 75 designates the first week of November as Municipal Courts Week in Texas. As we all know, municipal courts play a vital role in preserving public safety, protecting the quality of life, and deterring future criminal behavior. Municipal court staff, including clerks, court administrators, prosecutors, juvenile case managers, bailiffs, and warrant officers, work tirelessly to administer justice in a fair and impartial manner, upholding rigorous standards of professionalism. Municipal courts are the courts that citizens of the public come into contact with the most, and they play a significant role in influencing the public's perception of the justice system. By designating the first week of November as Municipal Courts Week, we can increase public awareness of the importance of these courts in maintaining a just and safe society. This resolution is not only a recognition of the service that municipal courts provide, but it also is a reminder of the importance of these courts in our communities. By acknowledging the crucial role that municipal courts play in preserving public safety and protecting the quality of life in our state, we can encourage more citizens to engage with the justice system and promote a greater understanding of the legal process. I can help answer any questions if you have.
All right, thank you. Members, any questions for Chairman Guillen? All right, seeing none, does anyone want to testify on, for, or against HCR 75? Seeing none, the chair recognizes Chairman Guillen to close.
Thank you, Mr. Chairman. I close.
Members, any questions? Seeing none, all right, the chair will leave HCR 75 pending at this time. The chair now lays out House Bill 4635 and recognizes Chairman Guillen to explain the bill.
Thank you, Mr. Chairman. Members, organized crime can have a destabilizing effect on our communities by undermining the rule of law. For example, by drug cartels, which are a major driver of drug trafficking and human smuggling, illegal use of force, fraud, and corruption. A recent report revealed that they are profiting nearly $13 billion per year on human trafficking operations in the U.S. and throughout Central America. In addition, most illegal drugs and narcotics enter the United States through the southern border, pushed by drug cartels. The consequences associated with the illicit drug trade and related money laundering schemes are enormous. Organized crime also directly affects the public financing capacities of the state, counties, and municipalities, and can obstruct economic development through tax evasion and illicit financial flows. All of this harms the state of Texas and its citizens. Racketeer, influence, and corrupt organization laws, such as HB 4635 in front of you today, provide law enforcement officials with tools to prosecute those who engage in criminal activity as part of a larger organization or enterprise, including transnational gangs. 33 other states have adopted similar laws already. This bill gives law enforcement officials and prosecutors a focused array of legal tools to charge individuals and organizations with a range of offenses related to racketeering and unlawful debt collection. The bill allows prosecutors to seek forfeiture of assets obtained through criminal activity, compensate victims, and to pursue civil remedies against those who engage in racketeering and unlawful debt collection. In addition to other additional tools, the bill updates the definition of criminal street gang, and this bill grants our prosecutors and law enforcement officials with the tools needed to better defend Texans from organized crime. We're working with stakeholders to refine some of the language, and we'll have a committee sub to you as soon as possible.
Okay, thank you, Chairman. Members, any questions? All right, seeing none, you've got one witness registered to testify. You can sit tight right there if you want, Chairman Ginn. The chair calls Mitch Landry. Mitch, good afternoon. I've got you here registered on behalf of the Texas Municipal Police Association for House Bill 4635. Is that correct?
Yes, sir.
Okay, go ahead.
Chairman, members, thank you for your time. Chairman Guillen, thank you for this bill. As you know, criminal organizations are complex and difficult to prosecute. That's why when the federal government decided to take on the mafia, Congress gave them new legal tools to gather evidence and take action against organized crime. Today, you know these tools as the RICO statutes. Members, organized crime is right here in Texas. We need new tools to combat the cartels and criminal street organizations. The bill would be similar to the federal statute and allow prosecutors to pursue the same type of offenses. RICO cases often involve mail fraud, wire fraud, and securities fraud. However, these statutes have also been used to prosecute murder, kidnapping, bribery, and drug trafficking. Other states have already enacted similar RICO legislation. With our proximity to the cartels who are bringing fentanyl over the border and killing our kids, this tool is needed here in Texas. Members, we ask for your support this bill and give prosecutors the ability to catch, fight, and catch the cartels and organized crime in the great state of Texas.
Okay. Thank you, Mitch. Members, any questions? Yes, Chairman Moody.
And my apologies, I probably haven't gone depth on this, but I know I've seen similar conversations in the past on this. What's the interplay with the Attorney General's office and the local prosecutors under this bill?
There is a resource witness here from the AG's office. Not being an attorney, I don't want to get in the weeds on that. They're here, yeah.
Okay. All right, thank you.
Members, any other questions? All right. Yes, Representative Schofield.
I'm at a bit of a disadvantage, Mr. Landry. Normally, I've read all the bills and
Right.
written my notes in the margin. This was 41 pages, and I knew there was a sub coming. But are y'all going to be working with the author to make sure that this is actually aimed at loan sharks and the cartels and not at legally functioning lenders who
That would be our intent.
run afoul of things?
We want to catch the bad guys.
So we're going to make sure we're tightening up the language. Okay, I just want to make.
Yeah, it's
And
a detailed
looking out for it,
40-page
but
bill, yes.
We know where you're trying to go, and we wanted you to get there.
Thank you.
Members, any other questions? Okay, thank you, Mitch. I'm going to call the resource witness from the Office of the Attorney General, Josh Reno. Josh, I've got you here testifying, like I said, on behalf of the Office of the Texas Attorney General on House Bill 4635. Is that correct?
That is correct.
All right. Chairman Moody.
The Attorney General's office would be an investigative agency under the definition in the bill, and I'm just looking at the bill as filed. I know we were talking about something else coming down the pike, but is that correct?
That is correct.
Okay, so how does this set up the interplay between local prosecutors and the Attorney General's office? They can operate independently of one another, or they have to? Can the Attorney General initiate all of these without coordination with the local prosecutor, or how would it work?
I think on the civil portion of the statute and the bill, the AG's office would have the ability to independently work and investigate. But as far as the criminal portions of it, that would still be with the local prosecutors.
Okay. Do our county attorney? Okay. I guess what it then, and I don't want to ask you your opinion on stuff, sorry. Hold on. I'm trying to phrase my question the right way. So on the civil side currently, what county attorneys can get injunctions and all that. There's certain tools available at the county attorney level, right?
I believe that's correct.
Combat some of this activity. Not maybe specific to this, but they have tools. I know we had like a gang injunction in El Paso some years ago.
Right.
Where the county attorney essentially spearheaded that. Former state senator Jose Rodriguez led that effort. Oh, sorry, I apologize. Not in the fine city of Junction, Texas, but an injunction in the courts.
Oh,
I
wow.
was asking a serious question, Mr. Chairman. You take me off track. What level of, I guess, because we have county attorneys doing some of that civil work today, obviously not congruous to this because this is broader, bigger. In most instances, at least that I'm aware of, we always have our local prosecutor request the assistance of the Attorney General's office, and they essentially become, there's an invitation to the table, now assist us with X effort. Under this bill, at least on the civil side, that would not be the case. Is that correct?
That's the way I understand it, is that both the local prosecutor and the AG's office on the civil side.
Independent authority. So that would be a new authority afforded under this bill to the Attorney General's office.
I believe it's correct, yes.
Okay, thank you very much.
Members, any other questions? Yes, from Mr. Schofield.
Hi, Mr. Reno. I'm looking at page 7 of the bill. I remember seeing this last night and it didn't, we're on the subsection 5, we're talking about ordering the forfeiture of the charter of a corporation. And again, I'll be honest, I grew up in New Jersey. We had the mafia. They never incorporated.
Right.
But maybe the cartels do. I mean, maybe they create subsidiaries to try to launder stuff or whatever. How do I know that we're aiming this at, again, loan sharking and that kind of thing, and not at, we think you're engaging in payday lending, and so we're going to sue you and we're going to charge you with crimes under this statute?
I mean, other than the assurances, I don't know if there's anything definitive in the bill that I've seen, and I'd be happy to work and continue to study it. It is a lengthy bill, and I've looked at it.
If it starts making, legal finance companies illegal, then I want to know about it.
And I don't think that that's what this bill does. And I certainly know that the intent and the point of the bill is to go after, cartels and criminal actions, not legitimate businesses. To the extent that you have criminal organizations who are, quote unquote, trying to legitimize, and they're using some of the illegal money and washing it through, quote unquote, legitimate businesses, I think that's the portion of the bill that it's targeting, is allowing prosecutors, AG's office to
More
go
of what they've done with the assets than actually the corporate assets themselves. In other words, it's not the business the corporation is in, it's that they're laundering money through it, or that they've
That's my
purchased money with ill-gotten gains.
That's my understanding, yes.
Okay, well, yeah, all right, thank you.
All right, thank you, members. Any other questions for the resource witness? All right, thank you. Appreciate it.
Thank you.
Does anyone else wish to testify on, for, or against House Bill 4635? Seeing none, the chair recognizes Chairman Guillen to close.
Thank you, Mr. Chairman. Members, I'll make sure we work with the members on tightening up the language and get something back to you as soon as possible.
Okay. All right. Thank you, members. Any questions? All right. Thanks, Chairman. With that, the chair will leave House Bill 4635 pending at this time. Chair now lays out House Bill 4638. Chairman Moody lays out the committee sub to House Bill 4638. And the chair recognizes Chairman Guillen to explain the bill.
Thank you, Mr. Chairman. Members, the Duval County Commissioners Court and the 229th District Court Judge, Valdemar Garza, asked me to file this bill that allows the district judge to appoint an associate judge in Duval County to help combat a backlog of cases in that county that were built up over the last number of years. The cost of this would be borne on the county, not the state. Additionally, this is permissive and not required. The committee sub before you is the ledge council version of the originally filed bill. I can help answer any questions if y'all have any.
All right. Members, any questions? Okay. Thank you, Chair. Does anyone wish to testify on, for, or against House Bill 4638? Seeing none, the chair recognizes Chairman Guillen to close.
Thank you, Mr. Chairman. I close.
All right, the chair will leave House Bill 4638 pending at this time. The chair will withdraw the committee sub to House Bill 4638 and will leave House Bill 4638 pending at this time. The chair now lays out House Bill 4907 and recognizes Chairman Guillen to explain the bill.
Thank you, Mr. Chairman. Members, innovations in technology can open up new economic opportunities to the state of Texas and bring investment as well as good-paying jobs to both the urban and rural areas of our state. Carbon dioxide storage is one of those innovations in technology, and HB 4907 helps pave the way to welcome the opportunities it may bring to Texas. Carbon capture is the process of capturing carbon dioxide from plant emissions and storing, transporting, and reusing the storage. This is not only beneficial for the environment, but also for the economy. This bill introduces key definitions around carbon dioxide storage to the Civil Practice and Remedies Code, and it clarifies that captured and stored carbon dioxide is not a nuisance, and doing so attracts and incentivizes businesses to invest in carbon capture. The bill sends a clear message that Texas is open for innovative business. We're working with stakeholders on clarifying language, and we'll have a committee sub to you as soon as we can.
All right, thank you, Chairman. Members, any questions for Chairman Guillen? All right, and you've reserved your right to close. You've got one panel of witnesses here. I'm going to call y'all up at the same time. The chair calls Lee Parsley, George Hillhouse, and Jack Walker. Lee, I have you here on behalf of Texans for Lawsuit Reform, Register 4, House Bill 4907. Is that correct?
That's correct.
All right, go ahead.
Thank you, Mr. Chairman, members of the committee. Lee Parsley on behalf of Texans for Lawsuit Reform in favor of this bill. This is actually a bill that's somewhat related to a couple of other things you've heard from me on this session, or at least one other thing. The TLR Foundation published a paper during the interim on capturing and storing of carbon and the liability that goes along with that. There are a number of other states right now who have liability sort of dealing with mechanisms. I'm not saying limiting, but mechanisms for dealing with the liability associated with capturing and storing carbon permanently. So it may be carbon that's pulled out of the air. It may be carbon that's captured from a flue. It could be carbon from any source. But the industry is developing worldwide for capturing and storing that carbon in underground reservoirs. We did a paper on that, just talking about what other states are doing to incentivize that, capturing and storing of carbon permanently, because we think, just from our work on it, that it is an industry that's coming to Texas. Whether we like it or not, it's going to develop in Texas, and giving some liability protections is going to help that industry develop. So I think what Chairman Guillen's bill does is something we have talked about before, which is it says the carbon is not a nuisance and therefore can't be subject to a lawsuit that would declare it a public or a private or otherwise a nuisance under the laws of Texas. So it eliminates, if it's like our public nuisance bill in the sense that if you're going to say something is lawfully done, capturing carbon and storing it underground, then at the same time, you shouldn't let someone who wants to impede that process sue on the allegation that it's a nuisance to the public, either because they're like it or don't like it from either a conservative or liberal perspective, right? There are both sides of this argument. So the idea is that those lawsuits would be counterproductive to the state's goal of developing carbon capture and storage to the extent that is the state's goal. Happy to answer any questions.
All right, Chairman Moody.
Sorry, unlike Mr. Schofield, I just try to catch up with all the bills that you set. So I don't know if I read this one fully, but so essentially, industry that's not here yet on its way. Is that what you're saying?
That the industry is here in its nascent form.
Okay, so forward-looking.
Correct.
I guess, ahead of a liability issue related to public-private nuisance.
That's correct.
I know we've talked about broadly the category. We've had a lot of testimony about that.
Yes, sir.
So, just for our edification, a Texas case or an instance in Texas where public nuisance or that a public nuisance suit has been misused against a potential defendant. So what are we protecting against? So where are the instances of misuse of the public nuisance?
The possibility in this circumstance I think could be from either sort of end of the political spectrum. I think there are some on what we call the left side of the political spectrum who don't want to capture carbon and store carbon because they think it just leads to burning more carbon. If we're pulling it out of the air and we're doing something about it, then we'll continue to generate oil and gas and therefore create more carbon. I think there are people on the other end of the spectrum, arguably, who say that they don't think it's a problem at all, that carbon occurs naturally and we're not harming the environment by the production of oil and gas and so forth. And so either of the side of the spectrum, I think, could be incentivized to try to interfere with this industry by filing a public nuisance lawsuit to say that that carbon underground is potentially a nuisance to the public at large because it could do whatever it is they might allege it would do. This bill just says it's not that. It's not a nuisance.
And that's the conversation around this particular conduct, forward-looking. And so I guess the intent of the bill is, there is a fear that this could be wrong, the fear you just laid out, wrongfully used against a potential defendant. And so I'm trying to say, is that fear well-founded? So under current constructs, do we have a Texas instance or a Texas case where public nuisance has been abused against a potential defendant? So are they pointing towards a certain instance where, like, well, look what happened to this one, and so that's why we need this protection?
I don't believe they're doing that in regard to carbon capture. I don't know of a public nuisance lawsuit related to carbon capture anywhere in the nation right now. This is purely a preemptive bill, somewhat like what happened with SpaceX. In order to encourage the development of space exploration from Texas, the Texas legislature enacted a law that gave SpaceX or exploration companies liability protections in Texas, and it has encouraged the space industry. So I think the answer is it's similar to that. It's an idea that if it is the legislature's will to encourage carbon capture in Texas, this would be an element of doing that.
So we haven't had instances of that going on across the country, and is the industry itself has developed more in, I guess, further along in places other than Texas?
It's certainly the liability structure has developed more in other places than Texas. The liability structure that is developing in other states and that is part of another bill here in Texas is to say that if you capture carbon and you put it underground at some point in time, when you cap that site, you turn it over to the state itself, who assumes the ownership of the site and the liability. And there are 6 other states right now who have that in place as an element of encouraging the development of the industry in their states. And so we are somewhat behind on that. We are probably a little bit ahead of the rest of the nation, our research indicated, in terms of the capability to do this in Texas, because we have such a well-developed oil and gas industry, and they have been capturing carbon for a number of years in Texas and injecting it underground for commercial purposes. So we know what we're doing here, and we have a lot of underground facilities that will hold carbon forever, they believe, in Texas. And so the idea is, as I said, to the extent you want to encourage that industry, this would be an element of it to encourage the industry.
Thank you, Lee.
Thank you, Lee. Thank you, Chairman Moody. Members, any other questions? All right, thanks for your testimony. Chair calls George Hillhouse. George, I have you here on behalf of the National Association of Royalty Owners and yourself testifying against House Bill 4907. Is that correct?
That is correct.
Okay, go ahead.
My name is George Hillhouse, and I'm testifying on behalf of myself, a mineral owner and a royalty owner, one of 4.5 million mineral owner and royalty owners in the state of Texas and neighborhood. I'm a 4th-generation mineral owner and a licensed attorney in Texas. I am a proponent of carbon sequestration, but I'm here to testify in opposition to House Bill 4907 in its current form. House Bill 4907 preemptively limits liability to the operator of a GSF, a geologic storage facility. It states, a person may not bring a nuisance action or similar cause of action on the basis that captured carbon dioxide, stored carbon dioxide, or a process associated with capturing or storing carbon dioxide constitutes a nuisance. Under Texas law, what is a nuisance? Well, a plaintiff must show that the defendant, quote, substantially interfered with the use of the land and that the damage to the plaintiff is unreasonable. If the plaintiff prevails, remedies or damages, injunctive relief, and self-abatement, and in the case of permanent damage, lost market value of the property. Now, in HB 4907, what is this similar cause of action? It's undefined. Is it a trespass? Subsurface trespasses are similar to nuisance claims. Are those also going to be disallowed? HB 4907 does not elaborate. Under current case law and the doctrine of, quote, permissible trespass, a mineral owner can be prevented from receiving injunctive relief under a trespass claim. So if House Bill 4907 passes, a mineral owner or operator cannot receive injunctive relief from either a subsurface trespass or nuisance claim or any other, quote, similar cause of action, end quote, whatever that may mean. So what is the real problem? CO2 from a geologic storage facility can migrate through hydrocarbon formations and can cause the precipitation of carbonate minerals and potentially plug flow paths, reducing production. CO2 can also create carbonic acid and cause damage to the wellbores and subsurface production equipment. The effect of this damage is reduced production and increased expense. And this is not just a problem for me and other private mineral owners. The largest mineral owner in the state of Texas is the state of Texas, and it will also be limited by HB 4907. This once-in-a-lifetime $26 billion positive balance that we enjoy and the 2021 record $10 billion in oil and gas production tax revenue is because of our enviable position as an energy leader. So the question is, why would you grant an emerging industry the right to preemptively shield itself from liability from potentially damaging the most productive industry in Texas? I hope the answer is you wouldn't. Thank you.
Thank you for your testimony, Mr. House. Members, any questions? Okay, the chair calls Jack Walker. Jack, I've got you here on behalf of the Texas Trial Lawyers Association against House Bill 4907. Is that correct?
That's correct, Mr. Chairman.
Thanks.
Good afternoon, Mr. Chairman, Madam Vice Chair, members of the committee. My name is Jack Walker. I'm the Vice President for Legislative Affairs for the Texas Trial Lawyers Association, testifying against House Bill 4907. I want to thank, first of all, Chairman Guillen for meeting with us to discuss our concerns with this bill. 4907 seeks to abolish both public and private nuisance claims as they relate to carbon capture. It's a little bit like Groundhog Day. This is the third time I've been in front of y'all this session talking to you about nuisance, second time about carbon capture. I don't plan on repeating anything except I would repeat this. I have met now most of the members of the committee, and I know that this committee is made up of very, very good lawyers. Nuisance is a common law right. This committee needs to be suspect of any law that seeks to abolish these rights and claims under common law. These rights have been in our jurisprudence for centuries for a reason. They are needed, and once they're gone, they're not coming back. This is an untested industry. The process of capturing and storing CO2 is relatively new, and why are we going to rush to abolish well-established common law rights to provide protections to these businesses before we know exactly what we're dealing with? The CO2 we're talking about is not just simply one atom of carbon, two atoms of oxygen. As I've talked about before, it's going to include substances like benzene, toluene, and xylene, and every other dangerous chemical in the carbon chain of petrochemical production. So I want to draw your attention to the definition of captured or stored CO2 because it's very troubling. First of all, it says that captured or stored CO2, not only not a nuisance, it's not a pollutant. Now, benzene, the EPA defines benzene as a hazardous air pollutant that may cause cancer as well as damage reproductive, immune, and neurological systems. Toluene has been defined as a major indoor pollutant by the NIH, and xylene, the CDC has warned that it can cause systemic toxicity by ingestion or inhalation. These are all pollutants in every sense of the word, and this bill as written would define them as not being pollutants, which is contrary to law. Nothing we have faced this far, this session, has tried to abolish private nuisances. What I've talked to you about this far is public nuisance. That is the government's right to bring nuisance claims. This actually abolishes a right for private landowners to bring a nuisance claim in order to address problems with carbon capture. And so what I would say is, if you take a situation where, let's say, captured carbon pollutes a water table. You're not going to get CO2 and water in Perrier and Topo Chico. You're going to get polluted water. And you're taking away the right of the victim, the landowners, and the government, if a public nuisance, to address that harm with nuisance. And the main thing that nuisance does is it allows for abatement of the problem and the issue and damages for future harm. We would ask you to not allow this bill through and to vote against it. And I'm happy to take any questions, Mr. Chairman.
Thank you, Jack. Members, any questions? Okay, thanks for your testimony. Thanks to each of you.
Thank you.
Does anyone else wish to testify on, for, or against House Bill 4907? Seeing none, the chair recognizes Chairman Guillen to close on the bill.
Thank you, Mr. Chairman. I'll work with all parties and see if I can't get you something better.
Okay, all right. Thank you, Chairman. Members, any questions? Okay, thank you, Chairman Guillen. With that, the chair will leave House Bill 4907 pending at this time. The chair now lays out House Bill 3949 and recognizes Representative Rainey to explain the bill. There's a committee substitute. Representative Murr lays out the committee substitute to House Bill 3949, and the chair recognizes Chair recognizes Representative Rainey to explain the committee sub.
Thank you, Chairman Leach and members. Appreciate the opportunity to lay out House Bill 3949. Currently, nonprofits who are designated as 501c3s can enter into an arbitration within its membership. The arbitration provisions do not apply to certain nonprofits. Committee substitute House Bill 3949 allows for those excluded the same benefit as a 501c3 as with regards to the ability to seek arbitration within its membership. We have some witnesses here today that can speak more to this issue. I would like to reserve my thank you for your time in the reserve.
All right, thank you, Representative. Members, any questions? All right, you can sit tight. I only see you've got one witness here who's registered to testify for the bill. The chair calls Alan Laser. Lazor? Laser, I was correct, okay. Mr. Laser, I've got you here on behalf of the Grand Lodge of Texas testifying for House Bill 3949, is that correct?
Yes, Mr. Chairman.
All right, go ahead.
Thank you for your opportunity to testify. I currently serve as effectively general counsel to the Grand Lodge of Texas. The problem that this bill seeks to address is more or less a technical glitch that has occurred in the way the statutes have been written. The Charter of the Grand Lodge of Texas, the current charter, Articles of Incorporation, occurred in 1900, following legislative action in 1899 in this body. The current provisions in the law that allow for arbitration by nonprofit organizations simply didn't address organizations that are as old as the Grand Lodge of Texas. The statutory derivation tables excluded us in 1925 when it became a different statute, and later in the Miscellaneous Corporation Laws Act, and later still in the current Business Organizations Code. So this bill is intended to put us into the category of other nonprofit corporations that may use arbitration to resolve internal disputes. We have a very complex system now. We are moving towards arbitration as our means for resolving internal disciplinary matters among Masons. And this would give us the same protections that are recognized in Texas law by our courts of derived judicial immunity for those who participate in those proceedings with legislative backing.
Okay, Mr. Laser, thank you for your testimony. Members, any questions? All right, thank you. With that, the chair, does anyone else wish to testify on, for, or against House Bill 3949? Seeing none, the chair recognizes Representative Rainey to close.
Thank you, I close.
All right, members, any questions? Thank you, Representative. Chair will withdraw the committee substitute to House Bill 3949 and leave House Bill 3949 pending at this time. The chair now lays out House Bill 1181 and recognizes Representative Shaheen to explain the bill. There is a committee substitute. Representative Slauson lays out the committee substitute to House Bill 1181, and Representative Shaheen is recognized to explain the committee sub.
Thank you, Chairman Leach, Vice Chair Johnson, members. The committee substitute for House Bill 1181 provides an effective approach for protecting our children from pornographic materials on the internet by requiring a publisher or distributor of explicit content that is harmful to children to create an age verification process. Even though access to pornographic materials on the internet has become increasingly accessible to the young, current law does not require online mechanisms to deter children from being exposed to pornography. As a result, age verification laws are being introduced across the nation. Following the successful passage of legislation in Louisiana that became effective January of this year, states like Arkansas, Virginia, Florida, South Dakota, and others have introduced legislation virtually identical to Louisiana's. 7 other states are introducing or planning to introduce age verification legislation as well. Age verification in the internet is now commonplace, as large identity databases are now widely and commercially available and can be accessed within seconds. The vast majority of age verification queries are successfully processed at the first attempt within seconds, and for those not able to be verified against the database on the first try, the individual is prompted to upload their government ID and their age is verified manually. So House Bill 1181 requires a publisher or distributor of explicit content that is harmful to children to create an age verification process in order for that individual to view the website content. For data privacy reasons, the user's data is not retained after verification. Mr. Chairman, I'm happy to answer any questions. I reserve the right to close.
Okay, thank you. Representative members, any questions? All right, thank you.
Thank you, sir.
Got your right to close. You got 2 witnesses who've registered to testify for the bill. Sorry, now 3. You've got Deborah Simmons. If you'll each come up here and join us at the table. Deborah Simmons, Eileen Blakowski, and Ann Newman. Ann might have just registered at the kiosk. It just showed up. So there you are, Ann. Hi. Ms. Simmons?
Yes.
And is Ms. Blakowski here? Okay. Ms. Simmons, let's start with you. I've got you registered here on behalf of yourself, testifying for House Bill 1181. Is that correct?
That's correct.
All right, go ahead.
Okay. I am for House Bill 1181 to require reasonable age verification methods for social media platforms, internet websites, and provide civil liability. It has been suggested to include a severability clause. I didn't get to hear everything that's in or I haven't seen the committee substitute, and I'm assuming that the substitute will also address the definition used for material. In addition, I'm concerned about the introduced version having the age of 13 rather than 17. While the Children's Internet or the Children's Online Privacy Protection Act uses the age of 13 for social media sites, Children's Internet Protection Act provides a more appropriate age standard of 17 regarding minors' access to obscene or harmful content over the internet. Filters are inadequate to anticipate and prohibit access to every new website, every online environment, and each hot link embedded in what is marketed as curated safe portals a lot of times. The peddlers of pornography, child sexual abuse material, and obscene content do not have boundaries in their efforts to expose children and corrupt their young, impressionable, and innocent minds. The American Library Association and allies often preach freedom to read, freedom to access, and freedom to view to circumvent all protective factors for children, including their own parents. Opposition organizations align with the adult entertainment industry in coalitions such as the National Coalition Against Censorship and Every Library to fight all efforts to protect children. This legislation requires necessary safeguards that the industry and their allies refuse to do voluntarily. Texas has a compelling interest to protect minors, and we applaud the efforts of the 88th legislature to pass each and every piece of legislation to that end. Age verification on internet sites is a necessary and powerful solution. Please pass HB 1181.
Thank you, Ms. Simmons. Members, any questions for the witness? All right, thank you. Chair calls Ann Newman. Ann, I have you here registered on behalf of yourself, testifying for House Bill 1181. Is that correct?
Correct.
Okay, go ahead.
I'm Ann Newman. I'm for House Bill 1181. Several years ago, when my granddaughter was in 5th grade, I got the password for her school district, for her school library, an elementary school. We're talking about 10-year-olds. And I logged in and I accessed EBSCO. EBSCO is an internet library resource provider that the state of Texas pays for. I was able to access pornography. Some of my friends were able to access pornography that was hardcore pornography. This is wrong. We need to do something about this. This isn't a First Amendment right, as some librarians are claiming, that children should have access to this. This is a parental right to protect children. In fact, Texas Family Code 151 says parents have the right to direct the moral and religious education of their children. This is against most parents' morality. So I ask you to support and vote for House Bill 1181.
Okay, thank you. And members, any questions for the witness? All right, thank you both for your testimony. Does anyone else wish to testify on, for, or against House Bill 1181? Seeing none, the chair recognizes Representative Shaheen to close on the bill.
Thank you, Mr. Chairman. We have been working with stakeholders through the interim, and since the beginning of session, we'll continue to do that, and we'll work with the citizens that came and just testified as well and show them the committee substitute. With that, Mr. Chairman, members, I close.
Okay. Members, any questions for Representative Shaheen? All right. Thanks.
Thank you, members.
All right. With that, the chair will leave the chair will withdraw the committee substitute to House Bill 1181, and we'll leave House Bill 1181 pending at this time. Done here. Okay. All right. The chair lays out House Bill 4714 and recognizes Representative Cortez to explain the bill.
Thank you, Chairman Leach, members of the committee, Vice Chair Johnson, Speaker Moody. Thank you all for the opportunity to lay out this bill. It's a very, very attractive committee you have here, Chairman. It's an honor to present to you guys. Very attractive committee. So just thought I'd mention that. Most large cities in Texas, such as Dallas, Fort Worth, Austin, Arlington, and El Paso, use electronic recording devices that follow general statute in the government code. However, San Antonio courts operate under a specific statute in the government code, which requires a court reporter in all cases tried before a court or jury. House Bill 4714 will amend government code, putting San Antonio in compliance with the general statute by allowing the governing body to authorize the use of a quality recording device as a substitute for a court reporter. This is a very simple bill, members, as always, one of the best pieces of legislation you'll hear this session. I reserve my right to close, Mr. Chairman. Thank you.
All right, Representative, don't go far. You can actually stay there. You've only got one witness. Members,
copy that.
Are there any questions for Representative Cortez? All right, seeing none, the chair calls Carla Obledo, or Bledo? Obledo? Okay.
Yeah.
Municipal Judge, is that correct?
Yes, sir.
Okay, hi, Judge. Welcome to the Capitol. I have you here testifying on behalf of the City of San Antonio Municipal Court. Is that correct?
Yes, sir.
Testifying for House Bill 4714.
Yes, sir.
Okay, go ahead.
Good afternoon, and I do agree with Representative Cortez. This is a very attractive committee, so thank you for having me here today.
I think we're ready to vote. Let's vote. Yeah, right.
Good afternoon, Chairman Leach and committee members. Thank you for the opportunity to express my support for House Bill 4714. My name is Carla Obledo. I am the presiding judge of the San Antonio Municipal Court. This bill relates, as Representative Cortez explained, to the use of an electronic recording device to report proceedings before a municipal court of record for the city of San Antonio. Specifically, the San Antonio Municipal Court seeks to amend Texas Government Code Section 3000226 and add a provision which allows the court to use a good quality recording device to make a record. As a court of record, the San Antonio Municipal Court is required under Texas Government Code Section 30.00010 to preserve a record in cases tried before the court upon a request of the parties or the judge. The court currently operates on a San Antonio specific statute, Texas Government Code Section 30.00226, requiring the use of a court reporter to report all proceedings requiring a record. The general statute gives the vast majority of municipal courts of record the flexibility to use an electronic recording device or a court reporter to preserve a court record. And as Representative Cortez already explained, what those courts are. We'd like to join those courts to also have that flexibility. The inconvenience of not having a recording device of for court reporting purposes does not align with the defendant's right to due process and can interfere with the defendant's right to speedy trial. The court employs one in-house court reporter at approximately $55,000 annually who provides reporting services for the whole court, but due to court volume is unable to provide services for all dockets. The San Antonio Municipal Court has 4 trial courts. Due to the limitation of being restricted to using only a court reporter for trials and hearings, the court has created an elaborate system to accommodate proceedings before the court. The process is not in alignment with judicial economy or best practices. Contracting for court reporter services has been challenging for the court as well. Due to the scarcity of qualified court reporters, securing reasonably priced services on a consistent basis is difficult. So thank you for the opportunity to address you this afternoon, and we ask for your support with this House bill. Thank you.
All right, thank you, Judge. Members, any questions for the judge? All right, thank you for your testimony. Does anyone else, or are there any questions? All right, does anyone else wish to testify on for or against House Bill 4714? Seeing none, the chair recognizes Representative Cortez to close.
Thank you, Chairman Leach, Vice Chair Johnson, Speaker Moody, and committee members. Thank you for the opportunity to lay out this bill. I respectfully ask for your support. And I do close, and I want to wish you all a happy Easter, you and your families.
Happy Easter to you as well.
Thank you,
Members,
Chairman.
any questions for the bill author? All right, thank you, Representative. With that, the chair will withdraw, the chair will leave House Bill 4714 pending at this time. The chair now lays out House Bill 2333 and recognizes Representative Allison to explain the bill. We're rolling. Yes.
Thank you, Chairman Leach and members of the committee for the opportunity to lay out House Bill 2333. This bill proposes provisions for the creation and enforcement of non-charitable trusts without a definite ascertainable beneficiary. Thus far, it's my understanding that Texas has limited the use of trusts without ascertainable beneficiaries to charitable trusts and trusts for the care of animals. Traditionally, the creation of a trust without ascertainable beneficiaries was disallowed because there was no one to hold the trustee accountable. This issue is remedied by this bill by creating a trust enforcer role under current language. The trust enforcer is someone named by the trust, settler of the trust, to make sure that the trustee is appropriately carrying out the trust's purpose. The Texas legislature in the past has adopted a number of uniform trust code provisions. However, the non-charitable purpose trust provision is noticeably absent. This bill attempts to address that absence. Because such an omission prevents Texans and businesses from having full authority to dispose of their property as they see fit. And this is increasingly the situation as we see a growing number of closely held businesses and corporations that are coming under, or businesses that are coming under the situation that we try to remedy. The bill also contains provisions relating to a specific kind of non-charitable purpose trust, presently called a commercial legacy trust, which can operate closely held businesses that are the increasing subject of this bill, as I mentioned. Without such a trust structure and no family members interested in taking over the business, the company would likely be sold or dissolved. This component of the legislation will protect Texas suppliers, customers, and employees that depend on a thriving company to continue even after the death of its principals. In that sense, a commercial legacy trust has great public benefit, much like a charitable trust. While current Texas law permits a trust to exist for up to 300 years, a commercial legacy trust, as contemplated under this bill, will only exist so long as the business can perpetuate itself and continue its purpose. If operating the business is no longer feasible, the trust assets will be distributed in accordance with the terms of the trust. The bill also contains optional provisions for the creation of a business committee to help provide business acumen to the trustee and trust enforcer. That is kind of the gist of the bill. I know there are witnesses here, and I would respectfully refer you to the witnesses to answer any questions about the bill. They are far more intimately involved and knowledgeable about this subject. I've about exceeded my knowledge of this. So with that, I'd again, recommend you talk to the witnesses, and then I'll respectfully reserve my right to close.
Members, that's a member who is not willing to take questions. Appreciate the directness. Members, are there any questions? All right.
I want to come up with one.
Yeah. Right. All right. You've recognized, or you've reserved your right to close, and we'll recognize that. There are two witnesses. Actually, there are three. The chair calls Craig Hopper. I think Mr. Hopper's had to take off. So is Craig Hopper here? No. The chair calls William Pargaman and Louis Ann Stanton. Ms. Stanton, let's start with you. I've got you here testifying on behalf of Osborne, Hellman, Scott,
Nicely.
Osborne, Hellman, Scott, Nicely, and Stanton LLP, and yourself registering for the bill. Is that correct?
That is correct.
Okay, go ahead.
Chairman Leach, Vice Chairman Johnson, and members of the committee, I really appreciate your time to speak concerning House Bill 2333. My name is Lois Ann Stanton, and I'm an estate planning and probate attorney here in Austin. I am speaking in favor of the bill as it relates to the use of non-charitable trust without an ascertainable beneficiary. Texas is one of only a dozen states that has not adopted trust provisions allowing non-charitable trusts to exist without ascertainable beneficiaries. These trusts are often called purpose trust. While 21 of the state statutes provide that a purpose trust can only exist for 21 years, 19 states have recognized that that arbitrary term of years could greatly limit the benefits of using a purpose trust. In particular, several of the states known for being business friendly, for example, Florida, South Dakota, Delaware, Wyoming, and Nevada, have authorized the use of purpose trust either in perpetuity or for hundreds of years. Florida most recently adopted its statute in 2022 and authorized purpose trust for 1,000 years as a way to modernize their trust law and make Florida competitive for business trust. Many successful entrepreneurs do not have family members who desire or have the ability to carry on the business. These entrepreneurs want to find a way for their business to continue for the benefit of their employees, their customers, their suppliers, and the community in general. If the business is sold to a competitor or a large national company, jobs will likely be consolidated and the business materially changed. The Purpose Trust provides the vehicle to continue the ownership and operation of the business as an independent company in the manner that is best for the community for many years. The first part of House Bill 2333 sets out provisions that would apply to any purpose trust, whether it is formed to conduct a mission or to own a business. In the second part, the bill provides provisions for the creation of a commercial legacy trust. These provisions are patterned after the legislation passed in Oregon. These provisions provide a non-mandatory statutory structure that can guide entrepreneurs considering the use of a purpose trust. These provisions will create a structure that protects the mission of the company, provide mechanisms for enforcement of the purposes, and create enough flexibility that the business can adapt to changes over time. Any business creating a commercial legacy trust have additional terms for the operation in the trust agreement. We are aware that one group has some concerns with the bill as proposed, and we will work in good faith to see if we can reconcile our differences. Thank you.
Great, thank you. Thanks for that. Members, any questions for Ms. Stanton? All right, thank you. The chair recognizes William Pargaman. Mr. Pargaman, I have you here on behalf of the Texas Real Estate and Probate Institute and yourself testifying against House Bill 2333. Is that correct?
That's correct.
All right.
Thank you, Chairman Leach and committee members. Again, my name is Bill Pargaman. I'm here appearing on behalf of TREP. I won't go through the rest of the introduction I previously provided. I would like to point out that due to a firm conflict, Lauren Hunt has taken no part in TREP's deliberations on this bill. Lauren happens to be a partner of Ms. Stanton in her law firm. Okay, it's been a longstanding concept in trust law that a trust is created for the benefit of one or more beneficiaries. These beneficiaries have the ability to keep tabs on the trustee and make sure the trustee is accountable for its actions. As I believe Representative Allison mentioned, we've recognized two exceptions to this general rule. One very long-standing exception is a trust solely for the benefit of one or more charities, and more recently, we authorized the creation of trusts for the future care of a person's pets remaining at the person's death. This bill creates two additional new types of trusts that aren't for the benefit of people. One of the new trusts is one created for a particular purpose without any identifiable individual beneficiaries. So-called purpose trusts usually would have a trust enforcer who would have the ability to enforce the rights that would otherwise be held by a beneficiary. Several other states have adopted this concept, and TREP takes no position on those provisions of the bill. I believe they're the first three sections that are added to the trust code. However, the last two sections that the bill would add to the trust code authorize the creation of an extremely complex and ill-defined special type of purpose trust known as a commercial legacy trust that would be for a presumably legal commercial purpose. It could have a business committee that could instruct the trustee how to act with very little ability of the trustee to object, while the commercial legacy trust contemplates a trust enforcer who could stand in the place of a beneficiary to enforce the purpose of the trust. The bill allows the business committee to fire and replace the trust officer, which effectively emasculates the trust enforcer's ability to enforce anything. Rather, it allows the business committee to act unchecked by any trustee or disagreeable enforcer. Virtually no other jurisdiction has sought to create this level of complex default rules. We believe that using the first three sections to which we have no objection and other statutes that we have, such as our directed trust statute, a settlor could achieve most of the objectives of a commercial legacy trust without its problems and complications. I will try to rush through the rest since I see my time is running out. We're concerned that it may create a new limited liability company or entity that would not require registration with the Secretary of State or the payment of appropriate franchise taxes. We're willing to work with the persons behind this to see if we can reach some mutually agreeable compromise. Thank you.
Thank you, Mr.
And I'm guessing there are no questions.
Well, there might be. Members, any questions? No, you're correct. Thank you both for being here.
Thank you.
Members, does anyone else wish to testify on, for, or against House Bill 2333? Seeing none, Chair recognizes Representative Allison to close on the bill.
Thank you. You see why I referred the questions to people more knowledgeable. It reminds me of, we're all lawyers, back to property, the rule in Shelley's case and the rule against perpetuities that I was promised would never occur again. This comes close to that.
Yeah. Yeah.
And if you remember last session, this committee, we passed an extension of the rule against perpetuities that I thought I'd never have to deal with again, but did, and we see it within this bill. You know, this, I think what's clear is there's a important need that needs to be addressed that is missing in current trust law, dealing with closely held corporations, closely held businesses where there's not an ascertainable beneficiary or successor. That's what this attempts is to address. And we're bent over backwards with the experts to come up with language that addresses any concerns. There's proposed language in the bill, certainly not sold on any of that to address what we need to accomplish. And we'll endeavor to do that and come back with a committee substitute. With that, I close.
All right, Representative Allison, thank you. I think we'll look forward to hearing back. Vice Chair Johnson. Oh, okay. All right, members, any questions? Seeing none, the chair will leave House Bill 2333 pending at this time. The chair now lays out House Bill 148 and recognizes Vice Chair Johnson to explain the bill.
Thank you, Mr. Chairman, committee members. I appreciate the opportunity to talk to you today about House Bill 148, relating to the Texas Medical Disclosure Panel. The Texas Medical Disclosure Panel is responsible for developing the informed consent notices that physicians are required to give patients about medical treatments and procedures. Informed consent is critical for patient autonomy and an important protocol for safe medical care. This information must be delivered in a manner that is comprehensible to the average person so that they can make an informed decision regarding their personal health. The panel membership currently does not include any members who represent patient perspectives in the development of these disclosures. House Bill 148 addresses this by adding 2 new members representing the general public to the Texas Medical Disclosure Panel. The bill also clarifies that among the 3 lawyers that are on the panel, at least 1 must specialize in personal injury trial law and 1 must specialize in health law. The panel continues to retain a majority of 6 physician members. If there are no questions, we have some few witnesses, and I reserve my right to close.
All right, members, any questions for Vice Chair Johnson? All right, seeing none, you've got your right to close. There are 3 witnesses. The chair calls Lisa McGiffert, Kay Van Way, and Ware Wendell.
And call Kay first, please.
Kay, I'm going to start with you.
Okay.
Whenever you get situated. Take your time.
These don't move very Musical chairs.
Take your time.
Okay.
Okay, Kay, good to see you. I have you here registered on behalf of yourself testifying for House Bill 148. Is that correct?
Yes.
All right, go ahead.
Thank you, Chairman Leach and Vice Chair Johnson, members of the committee. I'm here to testify in support of House Bill 148. My name is Kay Van Way, and for more than 30 years, I've represented various citizens of the state of Texas who were minding their own business, and out of the blue, catastrophe struck their family due to a preventable medical error. Notably, in recent years, I represented more than a dozen patients of the now infamous Dr. Death and assisted the prosecution in landing him in prison for the remainder of his life. Since then, I've been involved, in addition to my law practice, in advocating for patient safety so that we can identify the root cause of the medical errors that happen over and over again and try to eradicate them. My clients are conservative and liberal. They're Democrat and Republican. They're rich and poor. Most are well educated. What most of them have in common is prior to undergoing a surgical procedure, they did their homework. They did their best to search the internet and find out what they could. But the truth is, in this day and age, they were likely to find out more about their purchase of a dishwasher or a used car than they could a planned surgical procedure. Likely, you've been there yourself. It's what I like to call naked and afraid. You're required to have a surgical procedure. You're identified not by the car you drive or your station in life, but rather by that wristband on your arm. You're prepared to be wheeled back to surgery, and yet there's just one more minor administrative matter that needs to be handled. That's the nurse with the dreaded clipboard, which contains a long, confusing, legalistic, canned document which every patient has to sign before having the surgery. The information is confusing and devoid of any actual helpful information to help Texas patients understand the real pertinent risks before they decide to consent to the procedure. But have you ever wondered who writes those documents anyway? Well, in Texas, the persons that write those documents are the members of the Texas Medical Disclosure Panel, which is comprised of 6 physicians and 3 lawyers. All of the lawyers represent hospitals and healthcare institutions. So the standard is supposed to be what would a reasonable patient, like you and me and everyone in this room, would consider ourselves to be reasonable patients. What would a reasonable patient want to know? But instead, the Texas Medical Disclosure Panel is comprised of people who want you to know what they, the doctors and the healthcare provider, want you to know. I stand in strong support of this bill because I think it will improve patient safety in Texas. After all, we are all patients. We all should have the right to know and fully understand what we're consenting to and to have a voice. Thank you.
Thank you, Kay. Really appreciate your testimony. Members, any questions for the witness? All right, thank you. Well done. The chair calls Lisa McGiffert. Hi, Lisa. I've got you here on behalf of the patients the Patient Safety Action Network and yourself registered for House Bill 148. Is that correct?
That's correct.
All right, go ahead.
Good afternoon. My name is Lisa McGifford, and I'm the board chair of the Patient Safety Action Network, a national coalition of advocates working from the patient perspective to end medical harm. The Texas Medical Disclosure Panel is responsible for developing informed consent notices, which doctors use to educate patients about the risks and procedures or treatments that they are recommending. And as said before, probably all of you have been in that place to receive that information, and the information varies. Some people get it right before the procedures, others have a thoughtful conversation with their doctor and are able to think about it days and weeks before their procedure. Informed consent is a well-established ethical and legal obligation for healthcare providers and is critical for patient safety, patient autonomy, and decision-making. Yet many patients' recollection of understanding the medical procedure's risk is often low after receiving this information. Patient safety experts believe safe delivery of care is dependent on patient engagement, concise communication from doctors in a language that's understandable to the average patient. We believe that adding public members would assist this panel in identifying what and how to communicate risks to patients. They bring the voice of the reasonable patient into the discussion. This will help, the patient advocate will help to get the panel to deal with the seriousness and probability of specific harms from the patient perspective, not this long laundry list that looks like everything is the same as far as risk. Patient advocate would insist on outside expertise when that does not exist on the panel. And the patient advocate will ground the panel in thinking of how a reasonable patient might receive the information that they're getting. I urge you to support House Bill 148. Oh, one more thing I wanted to mention is the Texas Sunset Commission has an across-the-board recommendation that all panels and committees include public members, and that includes panels like this one that come under a larger agency.
Great.
Thank you.
Thank you, Ms. McGifford. Members, any questions? Thank you. Chair calls Ware Wendell. Ware, I have you here on behalf of Texas Watch, testifying for House Bill 148. Is that correct?
That's correct.
Go ahead.
Thank you, Mr. Chairman. Thank you, Vice Chair Johnson, for this important patient safety bill. When we're talking about informed consent, these are life-altering decisions that we're making. It can be a matter of life and death for the patient. A very quick history lesson. I know that we have a very full agenda today, Mr. Chairman. Informed consent goes back to the Nuremberg Code. That's how important this is. There are barriers for patients to comprehension. One is lack of knowledge, but on the other side of the scale, you can have too much information. You can have analysis paralysis. Finding the right balance, finding the right wording to where that patient can understand the risks of that procedure is so important. This panel, the Texas Medical Disclosure Panel, is public-facing in the truest sense of the word. Their work is about informing the public, but for no good reason, there are no members of the public on this panel. I would point you to the Texas Medical Board. Out of their 19 members, fully 7 of them are public. More than a third of the members of the Texas Medical Board are public. That is good. But we have no members of the public here with the Medical Disclosure Panel. This is about patient autonomy. It's really important for the panel to not just hear from patients, but also their advocates, people who are working with patients often. We feel that this bill will only strengthen the Medical Disclosure Panel and their important work. It will give patients a seat at the table. Doctors will still have the predominant voice, but they will be able to hear the patient's perspective. And with that, I'm happy to take any questions.
Thank you, Ware. Members, any questions?
I just have a quick question.
Yes.
Okay.
Yeah. Vice Chair Johnson.
Kay, can you just tell the committee briefly the consequences of informed consent on a medical negligence case and what impact that has when you sign away everything and something, a medical error does occur, what the consequences are?
Well, when consent forms contain a laundry list of things such as infection, bleeding, heart attack, stroke, death, the forms have become packed with the kitchen sink. And so a patient undergoing a bunionectomy consents to bleeding, and a patient undergoing the clipping of an aneurysm consents to bleeding. But there's no way to really quantify what that real risk is. However, if that risk is disclosed to the patient, it creates a legal presumption that the physician was not negligent. I hope I answered your question.
So what that does, it creates a legal presumption that the patients have to overcome in the event that they have a medical negligence case, based on this gigantic list that they had very little time to maybe review.
Yes, it's my belief that the Texas Medical Disclosure Panel has interest in putting the kitchen sink on consent forms because they get the benefit of a legal presumption.
Thank you.
That's a great bill. Okay. Members, any other questions? All right. Thank you each for being here.
Thank you.
Does anyone else wish to testify on, for, or against House Bill 148? Seeing none, the chair recognizes Vice Chair Johnson to close.
Thank you, Mr. Chairman. You know, House Bill 148 increases patient safety by allowing members to the public to participate in the informed consent process. You know, we're all lawyers up here, and we can talk in lawyerese a lot of times, and my kids will say, Mama, speak in English to me.
Yeah.
And, you know, because we get a vernacular sometimes that we get used to. And the same thing is true in medical terms.
Yeah.
And so this is, I think, a bill to provide more transparency to the public.
Yeah, I
Would
like it.
request your favorable consideration.
I like it a lot. Members, any questions? Okay, thank you. Good bill. Appreciate you bringing it. The chair will leave House Bill 148 pending at this time. All right, the chair lays out House Bill 4283 and recognizes Representative Lopez to explain the bill.
Good afternoon, Chairman and Vice Chairman and the rest of the committee. It's good to spend some time with you today. I got a feeling tomorrow we may be spending a little bit more time together.
Yep, for better or worse.
But that's what we all signed up to do, and I'm glad to be here with you doing it. House Bill 4283 is basically it's a veterans bill to create a recidivism study to try to help our veterans in a veteran treatment court. And that's what's before you today. We care about our veterans, and we say that quite a bit. I would argue that we don't say it quite enough. But indeed, we all, I think, have certainly a place in our heart for our veterans. A promising method of providing a judicial process which is sensitive to certain defendants' specialized needs, the specialty treatment courts, which is what we're here to talk about today, gained prominence around 2000, the year 2000. And specialized veteran treatment courts were instituted in Texas back in 2009 in order to provide a judicial process that takes into account the unique experiences and circumstances of our veterans. These courts provide necessary resources for justice to be served to our veterans, veteran defendants in a way which kind of respects the underlying medical health or perhaps substance abuse issues stemming from their service. And indeed, I think that's an important statement to be made, that they are looking for things that are stemming from their service that may be part of the problem with their condition, judicial condition. While this program is promising, it is relatively new and small. And it is the duty of lawmakers like ourselves to follow through on the work that was used in establishing these courts by making sure they have the resources and the oversight to do the essential work effectively. House Bill 4283 proposes a method or a study to be created to evaluate the recidivism rate of defendants who have successfully completed the Veteran Treatment Court program within the past decade. This study would be conducted by the Texas Judicial Council with the collaboration of the Texas Veterans Commission. These agencies will collaborate with courts on all levels of government. And while these veteran treatment courts, the VTCs, have been shown to be an effective tool in reducing recidivism rates among veterans, more is needed to be able to determine the efficiency in efficacy in the long term. The proposed study will provide valuable data on the success of VTCs in reducing recidivism rates, as well as any apparent patterns in recidivism rates among defendants. By evaluating these rates of defendants who have completed the VTC program, policymakers can then define areas where additional support or resources may be needed. I would ask for your consideration for House Bill 4283, and I do believe there is probably one or maybe more folks that are willing to testify. And with that, I thank you for your time, and I would reserve the right to close unless you have any questions for me now.
All right, members, any questions for Representative Lopez? All right, thank you. Good bill. And you can sit tight. You've got one witness who's registered to testify for the bill. The chair calls Robert Featherston. Mr. Featherston, if you come on up. Mr. Featherston, I have you here on behalf of the Bexar County Felony Veterans Treatment Court and yourself testifying for House Bill 4283. Is that correct?
Yes, Your Honor, that is correct.
Go ahead.
I, too, am an attorney. I'm also a retired naval flight officer. I've been involved with the Felony Veterans Treatment Court in Bexar County since 2017 at the inception of the program. The program is now nationally certified. It consists of 5 phases of therapy over a course of 2 years with an aftercare program of 6 months. We do support 4283. We believe that tracking metrics are necessary in support of continued success in the program. And we respectively request that the chair and the committee members support this bill. And I thank you. Any questions?
Thank you, Mr. Featherston. Members, any questions? All right, thank you.
Thank you.
Appreciate you being here. Does anyone else wish to testify on, for, or against House Bill 4283? Seeing none, the chair recognizes Representative Lopez to close on the bill.
Thank you, Chairman, for your time, and I ask for your positive consideration of moving this bill forward. You know, there's 40 courts in the state of Texas. All of them are run very efficiently, but this is going to try to set a framework for efficiency, increased efficiency. You know, in Bexar County, we're very proud of the work they've done, but they will also admit that there's a lot more work to be done, and this, I believe, gets us on the right track. With that, I close.
Okay, great. Thank you, Representative Lopez. Members, any questions? All right, thank you.
Yeah, thank you.
Appreciate you bringing this bill. The chair will leave House Bill 4283 pending at this time. The chair now lays out House Bill 3249 and recognizes Representative Johnson to explain the bill.
Thank you, Chairman Leach. Members of the committee, I'm glad to bring you House Bill 3249. The request and what this bill would establish is to continue to evaluate courts, their efficiency, and their case workload. I've had this experience personally being an advocate for more district courts in Harris County, Texas. And I will tell you gratefully, the Commissioner's Court has now approved the request for 6 additional district courts in Harris County, but we need 39.3 just to pick up where we need to be in criminal court. We have had 1 new court, the 482nd, in the last 40 years in Harris County. And so we have gone from 2.5 million people to 4.5 million people. And this is work that should have been done over the last couple of decades to not put us in this position of the crisis. The intent of this bill is that normally when we make those requests for courts, OCA will then do the workload data. This bill would say that OCA does it annually for the top 30 counties in the state. And actually, I think we're going to do it twice a year. And that way we can keep up to date and hopefully not have these crises happen in our counties with a court backlog. I would reserve the right to close and happy to answer any questions.
Okay. All right. Thank you, Representative. Members, are there any questions?
Thank you.
All right. Thank you. The chair calls Luis Soberón. Luis, it's always great to see you. Thanks for being here. I have you registered Luis Soberon on behalf of Texas 2036, testifying for House Bill 3249. Is that correct?
That's correct, sir.
All right, go ahead.
Thank you, Mr. Chairman and members. My name is Luis Soberon, here with Texas 2036. Happy to be for the bill. As this committee is well aware, courts across our state, particularly in urban counties, but across the state, are suffering from severe backlogs. One of the key drivers of backlogs is simply not enough of a judicial workforce to handle the drastic increase in filings that have happened over the past few decades. As Representative Van Johnson pretty plainly stated, these reports on the judicial workload that is needed in a given county or in a given jurisdiction, they only happen on request. So whenever a state representative or a local government asks for the data on whether or not we have an actual need for a new court, do we run these analyses? I think a good analogy for what has been happening in the state with our judicial workforce is the saying about how do you boil a frog? You raise the temperature over time and the frog doesn't notice that the water's starting to boil. Something similar has happened in our judiciary. By regularly running these reports, by regularly evaluating our judicial workload, we're going to be able to avoid that problem in the future, raise awareness among local governments that have to ultimately fund the majority of the cost of creating these courts, that these are costs that are deserved, that these are costs we should be able to shoulder to make sure that we don't make the backlogs any worse in big counties. I'm happy to answer questions if you have them, and thank you for your time.
Okay, Luis, thank you for your testimony. Members, any questions? All right, thank you.
Thank you.
Does anyone else wish to testify on, for, or against House Bill 3249? Seeing none, the chair will recognize Representative Johnson to close on her bill.
Thank you. And just to clarify, we're actually going to have these reports run every other year. We're going to do them biennially. I appreciate your favorable consideration, and I close.
Okay, all right, thank you. Representative, members, any questions? All right, with that, the chair will leave House Bill 3249 pending at this time. The chair lays out House Bill 4085 and recognizes Representative Spiller to explain the bill. I think you've got a committee substitute. Is that correct?
Correct.
All right, Representative Flores lays out the committee substitute to House Bill 4085, and the chair recognizes Representative Spiller to explain the committee sub.
Thank you, Mr. Chairman. Chairman Leach, Vice Chair Johnson, members, thank you for allowing me to lay out House Bill 4085. This particular bill amends a section of the Texas Mental Health Code. The current system allowing counties to assess fees against private mental health facilities dates back to the 1990s. It was at least in part originally intended to benefit public facilities. Today, we live in and operate in a very different environment for the delivery of mental health services, one in which the demand for services is growing at a rapid pace that cannot be met by public facilities alone. The state of Texas even contracts with private facilities for services. Because of this, certain patients and hospitals incur filing fees or other costs for mental health hearings and court proceedings. House Bill 4085 helps ensure that mental health providers stay in business and focus their resources on providing care. Additionally, and specifically, House Bill 4085 requires counties to reimburse a mental health facility for court costs if the facility files an affidavit with the court stating that the costs were associated with treatment for a patient provided under a contract with a licensed mental health authority or for a Medicaid-eligible patient, or the facility received no compensation for the treatment of the patient. So, and after consulting with stakeholders, we have this committee substitute to address some unintended consequences and to facilitate an agreement that affects counties and courts. Specifically, the difference is, the first thing is it provided before, talking about probate courts, but probate courts is a somewhat more narrow definition. Sometimes you have constitutional county courts and other county courts at law that administer these type cases and hear these cases. So therefore, the language has been amended to include those, any court under that particular subtitle. And the other has to do with a facility that only receives reimbursement under Medicaid. So that's the difference from the original and the sub. And with that, Mr. Chairman, subject to any questions y'all may have of me, I thank you for your time and respectfully reserve the right to close.
All right. Members, any questions? All right. Thank you, Representative. We've got one panel of witnesses here. The chair calls Rick Thompson, Guy Brittany Dick, and Stuart Archer. Mr. Archer, let's start with you. I've got you here testifying on behalf of Oceans Healthcare for House Bill 4085. Is that okay? Is that correct?
Yeah, yes, sir.
All right, go ahead.
Chair Leach, members of the committee, thank you for the opportunity to bring the testimony forward today, and thank you, Representative Spiller, for bringing this issue forward. I'm Stuart Archer. I'm CEO of Oceans Healthcare, and testifying in support of House Bill 4085. Oceans Healthcare is a Texas-based behavioral health provider, and today is one of the largest providers of behavioral health in the state, with 11 hospitals stretching from Midland, Odessa, all the way through East Texas and the Panhandle. In many of our communities, we're the only behavioral health.
Can you pull the mic just a little bit
for
closer?
sometimes
Thank you.
100 miles. We're also a Medicaid provider and work very closely with the local mental health authorities to ensure that state clients have access to inpatient and outpatient behavioral health care. We also work very closely with law enforcement and court systems to provide inpatient and outpatient care to individuals who've been committed by court to receive mental health services. As we heard earlier, currently counties in Texas are allowed to collect fees for mental health commitment hearings. These fees are passed on to the private facilities where the individual is committed, and we ultimately receive zero reimbursement for these fees. It's a cost we incur to provide access to the necessary treatment for the individuals who may otherwise end up in emergency departments or jail, or even worse, go without services. In each of the past 2 years, Oceans Healthcare alone has incurred more than $500,000 of court fees, ultimately for patients that many times were either indigent, Medicaid, or other payer sources with no reimbursement for these costs. I don't believe there's another provider type in Texas that's required to pay another entity in order to provide services. And we certainly do not pay the court fees in the 3 other states you operate in. Oceans provides an invaluable service for both local governmental entities in the state. There's a significant need for inpatient mental health beds in Texas, and as the state hospitals continue to shift their focus to forensic patients, Texas has the opportunity to utilize quality community providers to care for civilly committed patients. This ultimately keeps patients closer to their homes, families, and provides access to appropriate care. Capacity does exist in our communities. Oceans is ready and willing to expand and utilize our capacity to assist the state in addressing this growing need for inpatient behavioral health services. However, the requirement that private psychiatric facilities like ours pay the court fees associated with the patients we care for, coupled with the low traditional mental health reimbursement rates, is a major impediment to expanding services in other areas of the states. Oceans is a Texas-based company is committed to expanding our presence in the state, and we look forward to working with all of you to establish a regulatory system that promotes access to mental health care for all Texans. Thank you again for the opportunity to provide testimony, and I'm happy to answer any questions you may have.
All right, thank you, members. Any questions for Mr. Archer? All right, thank you for your testimony. The chair calls Brittany Dick. I have you here, Ms. Dick, on behalf of Signature Healthcare and yourself testifying for House Bill 4085. Is that correct?
Yes, sir.
All right, thank you. Go ahead.
Good afternoon. I want to thank Chairman Jeff Leach and David Spiller and this committee for the commitment to providing access and quality care for those impacted by mental health crisis. My name is Brittany Dick, and I'm the Chief Executive Officer of Georgetown Behavioral Health Institute, a private psychiatric hospital facility not far from here. Georgetown Behavioral Health is a part of a larger network of private psychiatric hospitals under Signature Healthcare, which operates 5 locations within the state of Texas to offer high-quality care for Texans when they need it the most. I appreciate the opportunity to speak with you all. I'm here today to support House Bill 4085 to lessen the financial burden of extensive and expensive court costs that behavioral health facilities are forced to pay for their patients in our care. As Ocean CEO Stuart Archer also explained, our facilities are forced to pay for patients whether or not they receive payment for those patients, meaning we are penalized twice for providing high quality and timely care for our fellow Texans at the time that they need it the most. From the time period of February 2022 to 2023, Signature Healthcare paid $250,000 in court costs alone. And in this 1-year time period, San Antonio Behavioral Health paid $200,000 and Georgetown paid $52,000. Those costs, as mentioned before, are even more difficult to absorb because of the growing population that come to our facilities that have no insurance, no Medicaid coverage, and no way to pay. Meaning not only are we absorbing $250,000 costs in court, but also we have uncompensated care numbers statewide totaling 12 million last year. We paid court costs on patients no matter their ability to pay. The mounting court costs we are forced to pay are exacerbated by multiple factors, including uncompensated care, workforce challenges. Signature Healthcare, like all freestanding facilities, provide mental health services, and we get twice the penalty for not only providing care without compensation on these patients, but also the revenue in order to pay for them to be there when they're unfunded. We must still pay the court costs. Layering the considerable workforce challenges this population creates with increased staffing for patients where there is no compensation or additional court cost is a cause of major loss for us. We are in support of the court costs not being the sole responsibility of a freestanding behavioral health facility for the following reasons. We are not the ones initiating the involuntary status. Involuntary status or civil commitment is a legal process through which an individual is deemed by a qualified professional to have symptoms of severe mental disorder and need to be detained for treatment. Freestanding behavioral health facilities receive no additional reimbursement and sometimes no reimbursement whatsoever due to the person's inability to pay. These patients often require additional staffing due to the often volatile nature of their situation. In addition, providers like Signature Healthcare are also asked to testify, which takes them away from direct patient care for those on involuntary status in our large patient populations. House Bill 4085 would provide us much needed financial relief from the $250,000 Signature Healthcare spent on court costs just last year. Thank you very much for your work in mental health, and we look forward to continuing to partner with you guys in the state of Texas.
Okay, thank you, Ms. Dick. Members, any questions for the witness? Okay, seeing none, thank you for your testimony. The chair calls Mr. Herman. Let's go to you, Guy Herman.
Hello. Guy Herman, statutory probate court judge here. I'm against the bill.
Judge, hold on. We've kind of changed things up a little bit where I'm going to say what I see and then you're going to say whether I'm correct or not. So, Judge Herman, you're here on behalf of the statutory probate courts of Texas testifying against House Bill 4085. Is that correct?
Yes, and also for Travis County Probate Court. We incur.
Well, all right.
I don't know if I signed in properly.
You did, but what did you want me to add?
I'm also a court that has. I get cases actually from Oceans over there into my hospitals here in town.
Hold on, Judge. You've done this before.
Okay.
You know how this works. So hold on. I've got to make sure that the record is correct in terms of who you're here testifying on behalf of. I'm going to let you get to your testimony, but I have you here on behalf of the statutory probate courts of Texas. That's
yes, and also for Travis County in my capacity as Travis County probate judge. Individually.
All right. Tell you what, I can't, can I just list in your occupation, you're the presiding judge of the statutory probate court?
Yes, sir.
Okay. And you're here testifying on behalf of the statutory probate courts of Texas and yourself?
Yes, sir.
Is that correct?
Yes, sir.
Okay. All right, go ahead. And you're against this bill?
Well, as originally filed, I will have to say I've never seen the committee substitute, but what's bothersome to me is Travis County and most counties that are in the urban areas are paying somewhere.
We're on the committee substitute. And so you testify on whatever you were prepared to testify on, but I have to make sure that your position on the original bill as filed is against the bill.
Yes.
Okay, go ahead.
It is not uncommon for Oceans to send cases into Shoal Creek Hospital here, Ascension Hospital, and we collect a fee from Ascension for the $602, which is set out in the probate 571.018 of the Mental Health Code as the court costs. You all have set those costs, and we charge those costs. You know, we get bills from Georgetown Behavioral, and we pay those back to Georgetown Behavioral. Travis County does. When we send a person up there, and we do send some people outside of the county to another place when there is no place available. It's troubling to me that the urban counties are expected to be footing the bill of these court costs at $602 and then not be able to collect. I would like to see these affidavits. I've never seen one affidavit whatsoever given by any hospital saying that we provided these services for free and we'd like to have our money back. When this business got started back in the 1990s, these hospitals, and I'm not saying it's these particular hospitals that are here next to me because they were probably not the owners of the hospitals, but the hospitals committed Medicaid fraud, Medicare fraud, and were indicted by the federal government. They were assessed fines, and then they negotiated a reduction of those fines. Instead of paying $30 million, $20 million at one time, they negotiated free, so-called free services for indigents at a certain dollar amount per day. And that's why we are where we are. We spend a lot of money in this county on this services, and we get a lot of cases, as I mentioned, from Oceans. They'll send them to have them at Oceans, and then they'll ship them over to Shoal Creek, and we expect to be paid for that. And whether Shoal Creek collects it from Oceans, that's their business. I don't care. But I'm troubled when we have to foot this bill in Travis County. And now I say I haven't seen the committee substitute. As long as it doesn't change the affidavit idea, if they want to give us an affidavit, I will gladly order money back to anybody that gives free services to anybody.
Okay. All right. Thank you, Judge. Members, any questions? Okay. Thank you for your testimony. The chair calls our final witness on this bill, Rick Thompson. Rick, I have you here on behalf of the County Judges and Commissioners Association of Texas testifying on the bill. Is that correct?
That is correct.
All right. Go ahead.
Thank you, Mr. Chairman. We've worked with Representative Spiller and other interested parties to agree on a reasonable policy in the public interest to encourage private mental health facilities to accept and treat non-insured patients for no or low compensation. The committee substitute balances these interests, and we thank Representative Spiller for working with us on this issue.
Okay. Thank you. Thanks for your testimony. Members, any questions? All right. Seeing none, thank you each for your testimony. Does anyone else wish to testify on, for, or against House Bill 4085? Seeing none, the chair recognizes Representative Spiller to close on the bill.
Thank you, Mr. Chairman. Let me just say, as far as the Judge Herman's testimony, I'm happy to provide him with a copy of the committee substitute. I think he'll find that it addresses the concerns that he may have. I know that some of this stuff was negotiated between some of the stakeholders, including Mr. Thompson's testimony, as evidenced by that with Texas Association of Counties. And some of the problem is that some of these folks, some of these facilities that get Medicaid reimbursement, their reimbursement typically is between $500 and $700 a day. So they're giving up a full day reimbursement just to offset that cost and expense to them. So, and not all the counties, it's a may, when you look at the entire section under 571.018 under costs of under the Texas Mental Health Code, the counties may assess that, and so there are probably about 12 counties that do, but the ones that do are pretty prolific with it, and it's creating a problem. And I know there's been a big stress this session, especially with mental health. Mental health is an issue in my district and throughout the state. We're trying to make it easier for folks to get that treatment and try to do that. And so, like I say, I think we're happy to cooperate, but I think that those issues have been addressed and concerns have been addressed. And so, I just say, subject to any other questions you may have of me, I respectfully close and ask for your favorable consideration.
All right. Thank you, Representative Spiller. Members, any questions? All right. Thanks for bringing the bill. The chair will withdraw the committee substitute to House Bill 4085 and leave House Bill 4085 pending at this time. The chair lays out as a matter of pending business House Bill 955 and recognizes Chairman Dutton to explain the bill. Chairman, I think you've got a committee substitute. There is. All right. Representative Flores lays out the committee substitute to House Bill 955. Members, you'll recall that this is a bill we heard a couple weeks ago, and I use the term heard very loosely.
Yes, right.
And Representative Dutton, Chairman Dutton, has worked on a committee sub and has it back in front of the committee now. Right. So the committee's in front of us, and the chair recognizes Chairman Dutton to explain the bill.
Thank you, Mr. Chairman and committee members. This is the committee substitute reflects what the intentions of the author was and simply put the original version of the bill was not anywhere even close to what I had intended. But the bill, the committee substitute now, generally recognizes what this committee has already come to recognize, is that there are some cases in our court system that simply because of the size of them, they have to be treated differently. And all this does is says that if the claim, total claim, is $50,000 or less, you don't have to go through the cost, both the defense and the plaintiff, of having to hire experts to prove up reasonable and necessary, or to have the challenge to reasonable and necessary. It can be done by affidavits, and that's all this does. Mr. Chairman and members.
All right. Okay. Thank you, Chairman Dutton. Members, any questions? All right. Really?
Yeah.
Oh.
One quick question.
Okay.
All right.
Representative Schofield.
I saw in the BA, Mr. Dutton, that that this would conclusively establish the
reasonable and necessary.
Reasonable, thank you.
Yes.
At this time of day, I can no longer think of the word reasonable. And I just want to make sure there's nothing in the bill that prevents me as being on the other side from countering the affidavit.
From challenging it with an affidavit also.
Thank you, Mr. Chairman.
That's right. In fact, I assumed that would happen, but the whole intent was simply to take, for these smaller cases, take the cost of having experts battle back and forth.
Got it. Okay. Thanks, Representative Schofield. Any other questions, members? Okay, thank you. There's two witnesses who've registered that want to testify on the bill. The chair calls Lee Parsley and Brian Jackson. Is Mr. Parsley still around? Okay. Brian, I have you here registered on behalf of the Texas Alliance for Patient Access, registered against House Bill 955. Is that correct?
That is correct.
All right, go ahead.
Thank you, Mr. Chairman, committee members. My name is Brian Jackson. I'm testifying against the bill in its current form. I do serve as general counsel for TAPA, the Texas Alliance for Patient Access. I also have a private law practice where I represent doctors and hospitals and nurses in medical malpractice cases. If a plaintiff seeks to recover medical bills in a lawsuit, they must prove three things. Those medical bills are reasonable, they're necessary, and that they were the injury that the plaintiff is suing about caused them. Chapter 18, as it currently exists, addresses two of those elements, reasonableness and necessity. It does not address causation. Causation is proved outside of Chapter 18. Right now, Chapter 18 makes it easier to prove those first two elements because a plaintiff can submit an affidavit instead of producing live testimony. This is a more efficient and economical way, and it's a good system. But they still have to prove it. They still have to provide evidence, even if it's in the form of an affidavit, in order to recover those damages. We object to anything that might remove that requirement, that would allow plaintiff to recover damages without providing evidence. I don't think that this bill is trying to do that, but I'm not sure exactly how the committee substitute is changing the existing statute, because right now the statute already allows for an affidavit to be used in order to prove up reasonableness and prove up necessity, regardless of the size of the claim. And so I'm also a little unclear as to who determines that the value of a claim is $50,000 or less. I'm not sure when that is determined or how that is determined. I think that we may end up with a whole bunch of $49,000 claims and never see another $60,000 claim again. But I'm not sure when that determination is made or who makes it as to what the size of the claim is at that time. So we're always willing to discuss ways to solve problems. Certainly appreciate Representative Dutton going back and reworking this language, and we'd certainly be happy to continue talking about that. But we're also always very cautious about changing the tort reform that's been so important to helping fix the medical liability crisis that this state suffered from previously. Thank you, Mr. Chairman.
Okay, thank you. Members, any questions for Mr. Jackson? Okay, thanks, Brian. Is Mr. Parsley here? All right, I did see him. Does anyone else wish to testify on, for, or against House Bill 955? Seeing none, the chair recognizes Chairman Dutton to close.
Thank you, Mr. Chairman and members. I close and I leave it to this committee what this, some of the testimony I just heard, that's the first time I ever heard a lawyer didn't know the value of a claim. I mean, at some point we all do. In fact, the rules require that you, to some extent, identify the value of the claim. And I leave it to this committee, but I just, this bill was intended to simply take unnecessary costs out of the whole system when it came to these small cases. And so with that, I leave it with you all.
Okay, thank you, Chairman. Members, any questions? All right, thank you, Chairman Dutton. The chair withdraws the committee substitute to House Bill 955 and leaves House Bill 955 pending at this time. The chair lays out House Bill 3401 and recognizes Representative Orr to explain the bill.
Thank you, Chairman and members. Historically, county clerks have had a minimal requirements regarding the format required to produce a certified copy of a court record. There are currently no requirements regarding the format of a certified copy produced by a district clerk. Certified copies of court records are frequently filed in the county clerk's open public records and may be submitted as evidence in a trial without supporting business records affidavit, and are frequently required for completing transactions such as claiming Social Security benefits. Fraud and altered copies are always a concern when these documents are used for transferring ownership of property and proving entitlements to other benefits. The intent of this legislation is to provide a method by which certified copies of court records can be submitted in a congruent fashion. HB 3401 sets out a method by which certified copies of court records shall follow the same format. Each certified copy must include the clerk's signature or initials and seal on every page, include an attestation of authenticity in the last page of the document, and the total number of pages and the date the copy was issued. Substituting pages of a multi-page document will be more difficult, as will altering a document. With this process in place, judges, clerks, and other governmental officials will be able to more quickly and easily identify a true and unaltered certified copy, thus making their jobs easier and allowing the process to work more efficiently, benefiting all Texans who must partake in it. I welcome any questions.
All right. Thank you, Representative Orr. Members, any questions? All right, thanks for bringing this bill. And you've reserved your right to close.
Yes.
And so we've got two witnesses. The chair calls Patty Henry. You can sit tight there if you want. Patty Henry and Louis Tomasetti. Hi, Patty, how are you?
Good afternoon, Chairman Leach. How are you today?
I'm good. I've got you here registered on behalf of the County and District Clerks Association of Texas and yourself, registered for House Bill 3401. Is that correct?
Yes, sir.
All right,
My name
go
is
ahead.
Patty Henry, and I am for this bill representing the Clerks Association. I want to thank Representative Orr for sponsoring this bill for us, and she laid it out so well. I'm going to respect Chairman Leach's and this committee's time and just allow for any questions. I'm here as a resource.
Okay. Ms. Henry, thank you. Members, any questions? All right, thank you. Chair calls Louis Tomasetti from the Office of Court Administration testifying on the bill. Is that correct?
That is correct.
Did I say your name correct this time?
Tomasetti.
Tomasetti, but I said the first name correct.
Lewis.
I did not. I got both wrong. All right. Louis Tomasetti. All right.
It's all right. I'll be here enough.
Oh, shoot. Okay. On behalf of the Office of Court Administration testifying on the bill, is that correct?
That's correct.
All right, great.
I'm here as a resource as well. Happy to answer any questions.
All right. Thank you, Tom. We appreciate it. Members, any questions? That was a joke. Members, any questions? You don't have any testimony? Okay.
No, sir.
All right. Thank you both. Appreciate you being here. Does anyone else wish to testify on, for, or against House Bill 3401? Seeing none, the chair recognizes Representative Orr to close on her bill.
Thank you, Mr. Chairman, and with that, I close.
All right. Thank you. Well, y'all could just sit tight because you're the witnesses on the next bill, too. I apologize. Okay. The chair now lays out. The chair will leave House Bill 3401 pending at this time. The chair now lays out House Bill 3403. There is a committee sub. Representative Schofield lays out the committee substitute to House Bill 3403, and Representative Orr is recognized to explain the bill.
Thank you, Mr. Chairman and members. HB 3403 is a follow-up to House Bill 3774 and SB 41 from the 87th legislative session regarding uniform processes for the transfer of cases from one court to another, and the court cost structure in place for civil cases to standardize costs in all counties and ensure fees were used for their judicial purposes. HB 3403 further clarifies some of these fees and expands the fee structure to apply to certain family law pleadings, including the creation of a $40 jury demand fee, which was repealed in error last session in SB 41 and HB 3774. HB 3403 also expands the transfer process to include cases governed by the Estates Code. It mandates that the clerk send an original copy of a will to the receiving clerk when jurisdiction changes. HB 3403 also repeals the juvenile justice fee and other fees associated with the juvenile court service. The previous bill, Transfer Bill HB 3774 in the 87th, set out a method of transfer cases between courts in a more efficient manner. It created a transfer certificate and an index, which is the only document to be file marked, ensuring each document retains its original integrity. It eliminates the need to certify each document, which made the documents cleaner and the methodology uniform. HB 3403 expands the same method to probate and guardianship matters governed by the Estates Code. It also clarifies that the same transfer method applies to cases transferred between the county and district clerk in the same county. HB 3403 also clarifies certain court costs, such as electronic certified copies, clerk's record of transfer, motions with fees, localized courthouse security fees, records management. It also repeals the document filing fee. The passage of HB 3403 further clarifies and cleans up language regarding case transfers and will improve the process for both clerks and their constituents. I welcome any and all questions. With that, I reserve the right to close, please.
Okay, Representative Orr, thank you. Members, are there any questions? All right. With that, the chair calls Patty Henry. Patty, again, I've got you here testifying on behalf of the County and District Clerks Association of Texas and yourself, registered for House Bill 3403. Is that correct?
Yes, Chairman. Patty Henry for the bill on the behalf of the Clerks Association. Again, I want to thank our sponsor, Representative Orr. Again, she laid out the bill impeccably, and I am here as a resource and can answer any questions that you might have.
Okay. Very brief question. Yes, Representative Schofield.
How are you doing? Thanks.
I'm good.
Thanks for coming here. Help me understand this, because I don't do any wills and estates or any of that stuff.
Okay.
I just handle big companies suing each other. So when we are transferring the case, we are henceforth going to transfer it electronically. But these are cases that deal with hand-signed documents like a will. So
Correct.
What happens to the original version of the will when we transfer this case this way?
That is a great question, and I knew you were going to ask it because you asked it last session.
Oh, well.
So
I have a great analytical mind. I have no memory
we
at
think
all.
alike. No, we think alike. It's wonderful. We did initially have that the original county was keeping the will, but after speaking with Judge Herman and the probate judges, they want the original will to go with the paperwork. So the paperwork will be transferred electronically through e-filing as laid out in the bill in last session, and the original will be mailed to the receiving clerk. But there is a clause in this that states that the party requesting the transfer will pay to send that will, either certified return receipt requested or a third-party carrier, to make sure that that clerk receives the original will. And they will docket that in the case that they've received it. So we're making very sure, being very careful that the original will reaches its destination as requested by the probate judges.
Now, for the last 160 years or so, when we transferred the entire file, we just took all the paper and did court personnel drive it to the next county and give it to them? How did they physically get there?
Well, I'm not that old, but
No, for the last
since I've been in
160 years ago. Last week.
They did at one point mail paper in bulk. They would put it and pack it in boxes and send it. But it was very...
These days, let's say.
Yeah. Nowadays, we do, sometimes they send it through e-filing, sometimes they send it in the mail, sometimes they'll ship it in a box. But the advantage of doing it this way is the electronic copy is sent to the receiving clerk. The originals are still held with the sending clerk, with the exception of the will, although they will keep a copy of the will. They send the original will, and then both clerks have those documents in their systems. So in some cases, cases can go bounce for 2, 3, or 4 counties. So in this situation, each clerk will have those records up to the point where they transfer the case and be able to issue certified copies, give copies to whoever needs it, and they'll be able to give the transfer certificate and index that shows from this point forward, it was transferred to the next county, and then that county will be able to do the same. So we will have a constant, consistent record of exactly where every document went, which is what we want to do, is avoid losing anything.
I also, yeah, exactly. I also noticed that although this is a transfer bill, and we do increase the transfer fee from $45 to $80, we also increased the filing fee from $15 to $80. What's behind that?
Well, actually, if you look a little closer, the motion to transfer has been struck from the Family Code. We're not going to charge any fee because we don't charge any motion to transfer fee on any other type of case. So we're trying to be consistent. The $80 is it's going from $15 to $80, and we recommended that to be consistent with the civil fees that were passed last session. All the subsequent filing fees went up to $80, $35 to local, $45 to the state.
Were any of them as low as 15? Did they get raised that high in one fell swoop?
No, they did not. But in this case, again, we're trying to fix a problem. So let me explain the problem. The problem is we'll have a family case and we'll have a post-judgment action filed. Well, per the Family Code, the person opening the case and filing that post-judgment action is going to pay $15. But the person who responds and files a counter petition, it's automatically, then it moves into the civil world and it's an $80 fee. So you have a husband and a wife fighting because one of them was able to pay $15, the other one was able to pay $80, and why didn't they both get to pay the same thing? So again, for consistency, we suggested we change that, and the pass-through monies that we collect on that $15, we will also be able to collect the increase to the $80, and that actually the OAG was consulted as well, and I believe they were here as a reference if you need that, but that's all been approved by them, and there is a note on that federal money, but it's pass-through money. So the fee on the half of the state, the $45 of that $80 is new money for the state. And of course, if someone can't afford their fees, they just file an affidavit of inability to pay.
Yeah, my more important question was I just want to make sure that we were not drastically altering how we get the stuff there to the point where we're going to be losing wills. But you seem to be, if the clerks are fine, I'm sure it's fine. I just wanted to make sure I knew what it was that we were planning to do.
No,
it's nothing substantially different from what we do now.
Yeah, we wanted to make sure that there is a trackable source for that original will and that it's not just thrown in regular mail and no telling where.
Very good. Well, thank you very much. I appreciate it.
You're welcome.
All right, thank you, Representative Schofield. Members, other questions? All right, thank you, Ms. Henry. All right, Mr. Tomasetti, I've got you here on behalf of the Office of Court Administration testifying on House Bill 3403.
That's correct. Okay. I'm here as a resource, happy to answer any questions.
Members, any questions? Do you have any? Okay, all right, thank you.
Thank you.
Does anyone else, thanks to both of you, does anyone else wish to testify on, for, or against House Bill 3403? Seeing none, the chair recognizes Representative Orr to close on the bill.
Thank you, Mr. Chairman, and members. With that, I close.
All right, members, any questions? All right, seeing none, the chair will withdraw the committee substitute to House Bill 3403, and we'll leave House Bill 3403 pending at this time. Thank you, both of you. Okay. right, the chair lays out House Bill 2541, recognizes Representative Garcia. Representative Garcia to explain House Bill 2541. How are you?
Oh, which way do I sit?
Wherever you want.
Good afternoon. Thank you, Chairman Leach and members. Today, I'd like to introduce House Bill 2541. It would directly implement recommendations from the Senate Bill 1575 report, which brought together the Children's Commission of the Texas Supreme Court, DFPS, advocates, and stakeholders to improve the care of foster children placed in residential treatment centers. Placement in residential treatment centers is meant to be temporary. It does not provide a stable environment, as in a family-like environment, which children need to thrive. As a result, placement in these centers does not always meet the psychological, emotional, or developmental needs of a child. Not only is placement a traumatic event, but impacted children have some of the worst outcomes. They have an increased likelihood of being impacted by the juvenile justice system, and tragically, victims of human trafficking. It is my honor to advocate for this very important issue because I was once placed in one of these residential treatment facilities as a child. House Bill 2451 seeks to address these issues by standardizing practices for court-appointed guardians and attorneys who advocate for foster children placed in residential treatment centers. This bill ensures that guardians and attorney ad litem review all relevant psychological and needs-based assessments, as well as recent incident reports for the child, so that both individuals are working together to make an informed recommendation as to what the best placement of the child would be. It also requires attorney ad litem to meet with children that they are going to be representing prior to any court hearings so that they can have a voice by being able to advocate for their own needs. House Bill 2451 gives both court-appointed attorneys and guardians the ability to request a conference with DFPS to discuss a child's placement and to ensure that it continues to be in the best interest of the child. This is critically important to create another avenue for advocates and attorneys to ensure that children are getting their needs met. For example, if a child becomes suicidal while in residential treatment, their attorney or guardian ad litem could use this committee conference time to determine whether the care and services the child is currently receiving are adequate enough to keep them safe and to promote long-term well-being. I welcome any questions and reserve my right to close. Thank you.
Okay, thank you, Representative Garcia. Members, any questions? All right, thank you. You've got a few witnesses who want to testify for the bill. The chair calls Kate Murphy and Sarah Crockett. And just as a reminder to the witnesses in the room who are going to testify on this bill or any others, although the dais may be relatively sparse up here, be assured that members and their staffs are paying attention. They're in other committees, laying out other bills. It's a busy time in session, but don't confuse the absence of their physical absence up here with their lack of care and concern about this legislation. So you're being listened to, and we're glad you're here. With that, the chair, and Jamie Bernstein as well. Is Jamie here as a resource? All right, Kate Murphy, let's start with you.
Right, good afternoon.
Just a sec, sorry.
Yes, sir.
Kate Murphy, I have you here on behalf of Texans Care for Children, testifying for House Bill 2541. Is that correct?
Yes, sir.
All right.
I'm Kate Murphy. I'm the Director of Child Protection Policy at Texans Care for Children, and we are grateful to be here today to talk about this very important bill. One of the things that we love about this bill is not only that will it improve legal representation for some of our most vulnerable youth in foster care, but it will also ensure that youth in foster care are spending more time in loving homes instead of in really impersonal institutional settings or foster care facilities. Residential treatment centers are supposed to be short-term, high-quality interventions for youth in foster care, but too often they become a place where youth languish and actually experience more abuse. Only about 5% of children in foster care need this level of intervention, but a third of children who experience abuse, neglect, or exploitation in foster care experience it while in a residential treatment center. And we know, and as you heard from the rep, children tend to have the very worst outcomes in these settings. They're less likely to graduate high school. They're less likely to find a permanent home. They're more likely to age out of foster care without additional support. And we know that they've had serious safety issues that have been highlighted in the federal lawsuit and in the media over the years. So this report really brought together experts from all over the state to figure out how we can better support these kids. And one of those strategies is by making sure that the legal representatives of the kids in court, the CASA volunteers, and the attorneys are really paying attention to what the children need, that they have the ability to access that information, and that they have some more duties to make sure that they're doing their job really well for this population. So we hope you support this bill, and I'm happy to answer any questions.
All right, thank you, Kate, for the testimony. Members, any questions? All right, the chair calls Sarah Crockett. Sarah, I have you here on behalf of Texas CASA, registered for House Bill 2541. Is that correct?
That's correct, Mr. Chairman. Thank you so much. And thank you to Representative Garcia for authoring this bill. I'm Sarah Crockett, the Director of Public Policy for Texas CASA, here in support of House Bill 2541. Texas CASA is a statewide membership organization for the local CASA programs around the state. And in all but 9 of the counties that we serve 219 of the 254 counties. We are appointed as guardian ad litem. And we actually helped to create the recommendations that are in this legislation. A lot of these recommendations and new duties for us are just really codifying best practices. But the ability to request a placement conference is a new and important power for guardians ad litem and attorneys ad litem. And it's really important that both of these, both attorneys ad litem and guardians ad litem have these new powers and duties, because especially our kids in permanent managing conservatorship whose parental rights have already been terminated, those kiddos don't always have an attorney and a guardian ad litem. They're only required to have one of those roles. And so it's important for consistency and effective advocacy that either the guardian ad litem or the attorney ad litem is able to request a placement conference. And I think ensuring that we have the ability to review all this information and participate in placement conferences will really keep the urgency of getting kids out of these settings and into appropriate settings is really crucial. So we want to make sure that we're being transparent with the court. And we really believe that the challenges that we're seeing with our children without placement and the challenges that we're seeing with young people in residential treatment centers are not just a result of some of the placement capacity crisis that we have and some of the challenges that we have with our placements, but it really is a systemic issue, and it's going to take all of us, whether we're representing the child in court or working with them in their placement, to address this crisis. And I think this legislation gets us a lot closer to that. It keeps the urgency of getting kids out of these facilities there, and make sure that the young people that are in residential treatment centers actually need to be there, and we need to be able to document why we believe that. So this is great legislation. We're in support, and I'm happy to answer any questions.
All right, thank you, Ms. Crockett. Members, any questions? Okay, thank you. The chair calls Jamie Bernstein. Jamie, good to see you. I have you here on behalf of the Children's Commission as a resource witness testifying on the bill.
That's correct, Chairman Leach.
Go
Thank
ahead.
you. My name is Jamie Bernstein. I'm the Executive Director of the Supreme Court of Texas Children's Commission, and I'm here as a resource on House Bill 2541. And I'm basically here to provide a little bit of history and context about the process for the Senate Bill 1575 work group that led to these recommendations. So Senate Bill 1575 passed during the 87th legislative session and charged the Children's Commission with creating a work group to consider the appropriate use of and improved transition into and out of residential treatment center placements, including proposed statutory changes regarding appropriate judicial findings, evidence required to be gathered by the department, and recommendations for information to be gathered from the child's attorney or guardian ad litem. The proposed changes in House Bill 2541 reflect the recommendations made by the work group, so I just want to provide a little bit more background on the process. This work group was chaired by Judge Rob Hoffman of the 452nd Judicial District in Mason County, is his lead county, and the work group members included subject matter experts from around the state representing DFPS, TJJD, HHSC, single source continuum contractors and service providers, judges, attorneys, and advocates. There were two subgroups. The most relevant one for today's purposes was the legal subgroup that developed these recommendations related to legal representation and advocacy around RTC placements. That group also included a representative from the Foster Care Ombudsman's Office because we thought that was an important perspective to consider. I also want to mention we consulted young adults with lived experience throughout the process, which spanned from September 2021 to July 2022. And the approach of this legal subgroup and the Senate Bill 1575 work group was to try and take existing duties and responsibilities for attorneys and guardian ad litem to be checking in with their child clients to see what their desires were around their placements and add more specificity to the inquiries when we're talking about an RTC or Qualified Residential Treatment Program placement. And I'll just note that the large distinction between the GAL and the attorney ad litem provisions in this bill really relate directly to the court advocacy and direct representation that's inherent to the attorney ad litem role. I'm available if there are any questions.
Okay, thank you, Ms. Bernstein. Members, any questions? All right, thanks to each of you for being here to testify. Does anyone else wish to testify on, for, or against House Bill 2541? Seeing none, the chair recognizes Representative Garcia to close on her bill.
Thank you so much, Chairman Leach, Vice Chair Johnson, members. I'd like to take a moment just to say thank you so much to my witnesses today. These are women who have dedicated their lives to other people's children. Having 8 children of my own, and adopting my 3-year-old brother when I was 19, I know that when you have a passion to save children from traumatic situations, that it weighs heavy on your heart. A lot of times, you know, I'm sure they wake up and they're so just exhausted from giving to other people that sometimes they don't have enough to give to themselves. And so I just wanted to take a moment just to say a genuine thank you from a child who was previously impacted by these systems. And we're just really, really grateful to have these advocates and guardians who often love us like their own. And House Bill 2541 would simply standardize best practices for court-appointed guardians, attorneys, and it will just ensure that these residential treatment centers placements are definitely in the best interest of the child. It will give them a little bit of autonomy for themselves. Being in these situations, it's extremely traumatic. And speaking of my own experience, being an 8-year-old who was in there with teenagers who were fighting, and, you know, oftentimes I was afraid of being victimized, as was mentioned by our witnesses today. This is just a way for us to be able to give foster kids a voice for themselves, a safe voice for themselves when oftentimes our voices are taken from us. This bill gives us the opportunity to make sure that during their most traumatic times of life that they know that people care about them and are ready to support their needs. If there's no further questions, I close and I request a favorable referral to local and consent calendars. Thank you.
Okay, great. Great, Representative Garcia. Members, any questions? Appreciate you sharing some of your story, and appreciate you bringing this bill.
It's an honor.
Yeah, well, it's our honor. Thank you. Members, any questions? All right, seeing none, the chair will leave House Bill 2541 pending at this time. Mono? Where is he? Oh, all right. Didn't see you over there. The chair lays out House Bill 2770 and recognizes Representative Diallo to explain the bill. There's a committee substitute. Representative Flores lays out the committee substitute to House Bill 4381, and you're recognized to explain the bill. What?
Yes, thank you, Mr. Chairman, Vice Chairman, Representative Flores. Honored to be here to lay out this bill.
Hold on, Representative. I just stumbled over myself. We're on House Bill 2770.
That's what you said.
All right, so let me make sure the committee substitute, Representative Flores lays out the committee substitute to House Bill 2770, and you're recognized to explain House Bill 2770. Go ahead.
Yes. Perfect. The Texas Citizen Participation Act, also known as the Anti-SLAPP statute, created in 2011 by this legislature. It's primarily a procedural tool to dismiss early on in lawsuits defamation claims where the speech was constitutionally protected. Despite its stated purpose, the courts and litigants have tried to expand on this over the years, and it's had problems with judges and litigants alike. So much so that in 2019, this body again came together to try to narrow down the purpose and intent of the anti-SLAPP statute, the TCPA. This bill basically adds, there have been 12 exceptions that these things the TCPA doesn't apply to. This is to add a 13th one. Yeah. And the 13th one is legal actions authorized by or to enforce any provision of the election code other than Title 15 of the election code. So that would make the 13th exception. And let me tell you why this is so important to have. The TCPA is a procedural tool. It's not a substantive law. It's basically a way to dispose of what would be otherwise unmeritorious claims because the Constitution would prohibit that claim from going forward. And what we have now in statute is once you file the motion, you can have a hearing on it up to 120 days after the motion is served and another 30 days for there to be a ruling. And if the ruling is to the TCPA motion fails, there's an automatic interlocutory appeal. And that, even though it's accelerated, that's only dealing with briefing. So we can have a case that's on file and sit for well over a year with nothing being done on an unmeritorious TCPA motion. And the reason this is problematic is because this thing has been abused historically. For example, if you're successful as a defendant bringing a TCPA motion, you're entitled to attorney's fees, costs, and some other things. There can be some sanctions. If you're a plaintiff and you're successful in defeating a TCPA motion, you only get attorney's fees if there's a finding that it was brought frivolously or just for the purposes of delay. So this tool now has been used as a weapon, as a sword in litigation. Now, why is it important to exclude election code violations and the like? And that's because some of these cases are very timely. And if you just bring a TCPA motion, you can win the case just by running out the clock. Election claims have nothing to do with First Amendment free speech rights. Whether a county runs an election well, whether there's an election contest, whether those sorts of things have nothing to do with First Amendment rights. Counting votes and not counting votes or running the process of an election, if there's litigation that ensues dealing with that, those aren't the things that the TCPA motion was intended to protect. All this bill does is make it explicit in the statute. And that's all it's intended to do. And with that, I'm happy to take any questions.
Okay, Representative, thank you. Members, any questions? All right, appreciate it.
I have to add one more thing, if I may.
No, that's fine.
There are some stakeholders on this issue that just recently I've spoken to. Now, in the TCPA, in this section, there is a B, and this is under Section A of 27010. There is a B that says, notwithstanding subsection A, certain of these 13 exceptions that this chapter applies to, and then it goes on and makes some qualifications, kind of exceptions to those exemptions. This would be number 13, and we're hoping to and planning to modify the bill again to include this number 13 exception, this election code exception to that provision as well. And with that, I'll take any questions.
Okay. All right, that makes sense. Members, any questions? Okay. Okay, thanks. If you've got your right to close. You've got one witness who's registered to testify against the bill. The chair calls Laura Prather. Hi, Laura. I've got you here registered on behalf of the Texas Press Association, the Freedom of Information Foundation of Texas, and yourself, testifying against House Bill 2770. Is that correct?
Yes, except I'm also testifying on behalf of the Texas Association of Broadcasters.
Okay, we'll add that here. So Texas Press Association, Freedom of Information Foundation of Texas, Texas Association of Broadcasters, and yourself registered against the bill.
That's correct.
Okay, go ahead.
Okay. Thank you, Mr. Chairman, Madam Vice Chair, and committee. Appreciate your time here today. We actually have been working with the sponsor of this bill, who has been lovely to deal with, and I think that our issues are addressed through the committee substitute, assuming the committee substitute comes out the way that that we have discussed, then I believe that we are fine with the bill.
Wait, so you're fine with the bill?
If the committee substitute
Okay.
against us filed,
I just
that
want
we've
to be
been
careful in terms of the record here, because
Understood.
We do have a committee substitute in front of the committee, but you haven't seen it yet?
We've talked through it.
Okay.
It's not back from Legislative Council yet in the form in which it was presented.
So what we have is not what you've seen? I'm sorry.
So let me recognize Representative Diallo to explain. So has the witness seen the committee substitute that we have in front of us, or is there an additional committee substitute coming?
The witness has seen the committee. The committee substitute is basically a ledge counsel right of our original bill, which was not a ledge counsel right. But as I testified, or as I presented, this carve out in B of this 13 is the issue that we were talking about, and that's how I laid it out, is that we were going to make that addition to the bill as well, which is not currently reflected in the committee substitute.
Okay, so so you have an additional committee substitute coming in.
Correct.
Okay, so Ms. Prather, you're against the bill as filed.
As filed, yes.
Okay, so I'm going to keep your testimony. With your permission, I'm going to keep your testimony as against the bill.
That's fine.
Okay. All right. Did you have any testimony remaining? Or are you good?
No, we're working through a committee substitute.
Okay.
And I appreciate the sponsors working with us.
Good. I always like to hear that. Great. Thank you for your testimony and for being here. Does anyone else wish to testify on, for, or against House Bill 2770? Seeing none, the chair recognizes Representative Diallo to close.
Again, thank you all for the opportunity to present this bill. I think it's important to our process.
Make sure that microphone is on. You might just touch it. There you go. Touch it again. Well, talk into it.
Hello, hello.
Touch it one more time. Now talk.
Hello, hello.
There you go. All right, go ahead.
Thank you for the opportunity to present this bill. Again, what it will do is substantially reduce the improper use and the intent of the TCPA, and it'll help our litigation process in the state of Texas. With that, I have any questions?
Okay, members, any questions? All right, thank you, Representative. The chair withdraws the committee substitute to House Bill 2770 and will leave House Bill 2770 pending at this time. The chair now lays out House Bill 4381. There's a committee substitute to this bill. Representative Johnson lays out the committee substitute, and the chair recognizes Representative Diallo to explain House Bill 4381.
House Bill 4381 is a little bit of a different animal. Thank you, Ms. Chair, Vice Chair, and representatives for hearing it. This deals with supersedious bonds. Currently, a party seeking to appeal a judgment for money damages has to file a bond in the amount of the judgment. There's some exceptions. If the maximum a bond can be, depending on net worth, is half of a company or entity or individual's net worth, or up to $25 million, whichever is greater or lesser. I've got to look back at the statute. This is somewhat of a carve out to that, and this bill just applies to businesses and individuals with a net worth of $10 million or less. And what it does is it says, if in order to meet that bond requirement, that up to $25 million or 50% of net worth, that business or individual has to liquidate its income-producing, necessary business income-producing asset. If it's a single apartment complex owner and it has to sell the apartment complex to post a bond, meaning I can't afford the ride, so I can't afford the appeal. What it does is it allows for the defendant, the judgment debtor, to post another form of security that also satisfies the bond amount and the judgment without having to liquidate that necessary business asset. So it's kind of a fine, narrow, tailored statute that both protects plaintiff's judgment creditors and defendant judgment debtors. With that, I'll take any questions.
Okay, thank you, Representative. Members, any questions? Okay, all right, you've reserved your right to close. You've only got, you've got one witness who wants to testify for the bill. Chair calls James Holmes. Mr. Holmes, good afternoon. I've got you here registered on behalf of yourself testifying for House Bill 4381. Is that correct?
Testing. Yes, sir. I'm here testifying for myself in favor of the bill. Thank you.
Okay.
May I proceed?
Yes.
Chairman? Mr. Chairman and Ms. Vice Chair and everyone else on the committee, I appreciate your time and your consideration of this important bill. I appreciate Representative De Ayala for authoring it, sponsoring it. It's a very important bill. I want to be respectful of your time. I know you've been here a long day and you have further business. I'm really here to field any questions you may have about the bill. I also add that I prepared my testimony and put it in written form, and it's been submitted to this committee. And rather than me taking up 3 minutes reading that, you all have it. So I really am just here for any questions you might have.
Okay. But just to be clear, you're for House Bill 4381?
Yes, sir.
All right. Members, are there any questions? All right. Thank you for your testimony. Does anyone else wish to testify on, for, or against House Bill 4381? Seeing none, the chair recognizes Representative Diallo on the bill.
Thank you again for the opportunity. I'm happy to answer any questions, and if there are none, I would like favorable recommendation out of committee.
Okay. Members, any questions? All right. Seeing none, thank you, Representative. The chair will withdraw the committee substitute to House Bill 4381 and leave House Bill 4381 pending at this time.
Thank you.
Thank you.
Thank you, Chair.
All right. The chair lays out House Bill 5179 and recognizes Representative Plisa to, you ready?
I'm ready.
Representative Plisa to explain the bill.
Thank you, Mr. Chairman, Vice Chair, distinguished members. I'm honored to lay out House Bill 5179, the Texas Anti-Stealthing Act, before you today. Members, I like to keep my layouts short, so I apologize that this one is more in depth than normal. I feel a responsibility to share the stories of those who've come forward and those who have reached out to me and believe that I will value this and believe it will be of value to this committee when considering House Bill 5179. Before we begin, I would like to offer a disclaimer to the attendees and those streaming online that this bill covers topics of sexual assault. We will be discussing anatomy and medical devices and topics that may not be suitable for children. Mr. Chairman, I'd like to start off by telling you a little bit about a young woman named Rebecca and her story. Rebecca is a doctoral student living in a university town. When she's not working on her dissertation, she volunteers at a local rape crisis center. In that role, she often hears from undergraduate students at a nearby state college. A significant number of callers describe upsetting sexual contact that they struggle to name. Their partners have, during sex, removed a condom without their knowledge. Their stories often start the same way. I'm not sure if this was rape, but these accounts resonate with Rebecca because during her freshman year of undergrad, her boyfriend did the same thing to her. He removed his condom during sex without Rebecca's knowledge or consent. While Rebecca struggled to name what happened to her, it is a problem so prevalent it has its own name, stealthing. An online subcommunity of perpetrators has dubbed non-consensual condom removal as stealthing. 1 in 3 women and 1 in 5 men globally have been victims of stealthing. Some of their victims' hesitation stems from society's general misconceptions around sexual assault. A lot of us picture someone jumping out of the bush and raping us. The reality is, 8 out of 10 sexual assaults, the victim knows the rapist. It is often a friend, an acquaintance, a classmate, or a colleague. The other misconception around the elements of consent. It is not a free-for-all pass to do whatever you please. Consent is freely given, reversible, informed, enthusiastic, and specific. As I was made aware of this atrocity occurring in our state and around the world, I started combing through research articles, videos, and the internet to understand what was out there on this topic. I became aware of an online community centered around this topic. I'll briefly describe 2 of those to you. One group I found was a support group for survivors made up of mostly women drawing attention to this offense that shared information and resources to survivors on preserving evidence and getting a rape kit. The second group I found was rather disturbing and consisted of men who were fetishizing and bragging about stealthing. They posted written confessions and some even posted graphic pornography that was recorded covertly. There was even a website, iblastinside.com, that instructs offenders on how to commit this assault. And gives tips and encouragement, by the way. They assume that it is a natural right for men to dominate and inseminate women, and that this right is so inherent that consent and free will is irrelevant. These offenders are brazen, they're emboldened, and they have not faced any repercussions or punishment. No one has stood up to them or dropped the swift hammer of justice upon them. And by God Almighty, I hope their time is up right now. I hope that Texas will lead on this issue and stand with survivors against assailants. I hope that you will join me in providing a legal avenue to those victims who have been forced to endure unprotected sex against their will. I hope that they find the courage to come forward and that prosecutors crack down on this offense, and that with the passage of the Texas Anti-Stealthing Act, we give survivors a meaningful avenue to redress. This isn't something online. The American Academy of Family Physicians and National Domestic Violence Hotline believes that stealthing is a serious public health issue. Survivors, interviews, and online accounts indicate that this action is most common among college-aged adults, but is not regulated to that population. This practice puts partners at risk of unwanted pregnancies and for contraction of sexually transmitted infections. Survivors explain that they feel like a violation of trust and a denial of autonomy and free will. I hope that you will join me in affirming the feelings of these victims and sending a clear message that they have been indeed violated. And the Texas House will provide redress to these victims, that we will hold these assailants accountable to the letter of the law. House Bill 5179 seeks to help victims become survivors by creating a civil cause of action for non-consensual condom removal. Rebecca's story is one I read in a study published by the National Women's Law Center at Yale Law School. But let me share with you a story from one of my constituents, a young college student in my district and her encounter with stealthing. Lily had been dating her boyfriend since high school when they decided to go to college together. Lily's boyfriend continued to pressure her into having sex even though she wanted to wait until marriage. Finally, one day, Lily gave in to the pressure, but she asked her boyfriend to wear a condom and he agreed. Lily did not realize that her boyfriend had removed the condom without her consent until after it was too late. She felt violated. She knew something was wrong that had happened to her, but she didn't know it had a name. Her boyfriend grew more sexually aggressive and started forcing himself on her regularly, creating an environment of sexual violence in their relationship that became routine. Members, that's what I want to impress upon you today. Stealthing is a form of assault. In the plainest terms, it is one person forcing another person to have unprotected sex. It is a tactic used by abusers to make decisions over the victim's body, to transmit disease, to coerce pregnancy. For abusers, it's about control and denying the victim's ability to make decisions. It's about depriving freedom. The Journal of Health Psychology published a peer-reviewed study in 2019 and found that more than 10% of the participants reported engaging in non-consensual condom removal. Researchers found that those offenders had a history of sexual aggression, hostility, and violence towards women. They were more likely to have partners with unintended pregnancies, and they were 30 times more likely to spread disease. I've gone through so much research but this is what sticks with me, the personal accounts from those who have experienced this offense. That's what I hope sticks with you. Please don't let these survivors be reduced to a statistic. I hope you remember Lily's story and highlight how stealthing is a precursor and indicator to more disturbing behavior and sentiments. Her boyfriend first violated her consent by forcing her to have unprotected sex. Then he continued to violate her and subject her to violence, coercion, and rape. I hope you keep Louisa's story in mind when considering this legislation too. Louisa was also violated by her boyfriend in the same manner as Lily. A few weeks after her boyfriend assaulted her, she learned she was pregnant. When she told her boyfriend, he demanded that she abort her pregnancy immediately. Louisa refused, and he insisted she would carry the pregnancy to term. Her boyfriend threatened to beat her up if she refused to get an abortion. This offense isn't relegated to college campuses. It's happening all over Texas in each of our districts, even in this building, the People's House. Members, if you will review the written testimony that's been submitted to this committee, you will come across Daisy's testimony, a former staffer. Mr. Chairman, if I may, I'd like to read a portion of her submitted testimony for the committee. When she was 22 years old, she was a victim of stealthing, didn't realize there was a name for it, but she knew she had been violated. These are her words. My story is not unique. I was on a date with a person who I thought I could trust. I had no idea what had happened until it ended. Once it was over, I realized that the condom was no longer there. To my shock, my partner blew it off like it was no big deal. I had to ask and demanded, "Did you take the condom off?" He answered casually, "Yes, I thought you knew. I thought you could feel the difference." No, I couldn't. I had no idea. I felt rage, anxiety crept over me. I questioned myself. I was devastated. This is a story that happens too often. This experience at an early age left me with lasting effects concerning consent. Stealthing is not okay. Stealthing is sexual assault. Women who've experienced this are left with confusion and a lifelong trauma affecting their ability to trust and form healthy relationships in the future. Survivors have a right to seek redress and deserve to recover damages for injury done to them. House Bill 5179 creates a legal avenue for survivors of stealthing to seek justice from their persecutors. We have created a cause of action that hones in on the specific elements of this offense. 1, the removal of the condom without the person's knowledge. When someone puts on a condom, there is a reasonable presumption that that will remain on for the duration of the activity. After the removal, the defendant continued to make sexual, number two, after the removal, the defendant continues to make sexual contact with the individual, in the plainest terms, force the individual to have unprotected sex. I've consulted criminal judges and prosecutors in North Texas, and they've advised me that we can already prosecute under the aggressive offenses. A civil case will allow victims to recover damages and have a voice and some control over these cases. The evidentiary standard for this case would be the preponderance of evidence and allows a judge to provide appropriate injunctive relief and allows a jury to award claimant who prevails actual damages, including mental anguish, court costs, and reasonable attorney fees. A jury may award exemplary damages when appropriate. The reason that so many are hearing of this for the first time is because of the confusion I described earlier. Our laws should reflect the sentiments and reality of today's society, and I hope that you will join me in sending a message through action and law that we will make these offenders think twice and provide survivors meaningful relief. What they've experienced will stick with them for a lifetime, and not just mentally, physically as well. These could leave victims with permanent PTSD. We need to send a clear message that stealthing is hideous, immoral, and an illegal act for those suffering, and those suffering can seek redress. I see we have over 4 dozen witnesses who have registered in support of this bill, and oddly enough, there are 2 people registered in opposition. I'm truly perplexed by this, as no one has reached out to our offices with concern or opposition, and I'm very curious to know who these 2 people are that support sexual assault being perpetrated in our great state. Members, as I mentioned, over 4 dozen groups and individuals have registered in support of this legislation. I hope to earn all of your support for the Texas Anti-Stealthing Act, and I'm honored that Ms. Lavinia Masters herself has come down here from North Texas to testify before this esteemed committee. Members, many of you may remember Ms. Masters, after whom the Lavinia Masters Act, which was passed in the 86th legislative session and was a priority bill HB 8 for the House. Ms. Masters knows how sexual assault leaves a lasting impact on survivors and how hard it can be to seek justice through the criminal court system. I'm happy to answer any questions for the committee, and after Ms. Masters' testimony, I respectfully reserve my right to close.
Okay. Thank you, representative members. Any questions? Okay. Thanks for bringing this bill. The chair calls. Thank you, and you've got your right to close. The chair calls Lavinia Masters for the bill, and then I have Adam Kahn, who's registered against this bill. Adam Kahn, who's registered against this bill. Is he here? Okay, I guess he just didn't want to testify. Okay. Ms. Masters, it's great to see you again. The chair calls Lavinia Masters. I have you here on behalf of Hope Saves and yourself, registered for House Bill 5179. Is that correct?
Yes, sir.
Good. It's great to see you again. And you're
Thank you. Great to be here. Thank you, Chair. Thank you, everyone, for listening, and thank you for House Representative Placer for bringing this important bill, House Bill 5179, to your attention about stealthing. Those of you that know my story, I am a survivor of a heinous sexual assault at the age of 13 years old. Although I did know my perpetrator, I did live for years with the fear of, did I have, and to this day, I still take HIV testing, even though I've been married 33 years, but that was one of my triggers was a disease, or would I become pregnant from not having a condom, and that was being a victim of a stranger. But me working as an advocate now for survivors of sexual assault and just being an advocate, period, I do a lot of speaking at schools, and at the Plano School District, I did an event for this past August, and sharing with the students about consent, because that's what this takes us back to, is to consent. In other words, mutual respect for one another when you decide to engage in certain activities such as sex. And what I've learned, or what I taught them, was when that condom is removed, it is no longer consent. That young man had made the decision on his own that he was going to take another route when it comes to that sexual activity that they were engaged in. I also told them, now go home and make sure you're not telling your mamas that Miss Lavinia said we can have sex as long as we have a condom on, but just to be safe, because we know young folks will do what they want to do anyway. But when it comes down to consent, that's disrespectful, that's deceitful, that's unethical, and it's unacceptable. And what happened is, after my event with Plano School District, I had a lot of young folks reach out to me on my website and say, Miss Lavinia or Mrs. Masters, I think I was raped. I think this happened to me. I was violated because he told me that he would wear a condom, and I later learned that that condom was removed. This was very traumatizing for them. This was very frustrating for them. It was very frustrating for me to hear that, because once again, we are back to consent. And what does consent mean to an individual? How do we train our young folks? How do we train society? How does the state of Texas look at what consent is? And House Bill 5179 lays that out. No one has a right to make a decision on whether or not you're going to impregnate someone or possibly give me a disease without me being involved in that. A lot of them are already pressured into that sexual activity, and some are not, but still, we still have to draw that line of what consent is. So mutual respect is why we're really here today when it comes to survivors of sexual violence. If I decide that I'm going to be engaged with you sexually, and we decide that we're going to use protection, you should respect that as an individual. You should respect me as an individual. You should respect my rights as a person. You should see me for who I am. And if we say we're going to use protection, we must use protection. But if you make that decision to remove that condom during that act, you have now committed a crime against me. You have now violated me. You have violated my space. You have violated my trust. You have violated me as an individual, and that is no longer consent. And there should be some kind of action that I should be able to take against you if I decide, if I'm not filled with so much fear or uncertainty because my state or people don't understand what consent is. And in closing, we have to get to that point of what consent is. That it sounds redundant, but we don't hear it enough when we say consent. And so I want to make sure today that we understand what we're really focusing on, and we are protecting survivors of sexual violence, and we're training our young folks the proper way, even our older folks, when it comes to what consent is, and removing or stealthing in this instance is against the law, and there should be some kind of punishment for it. Thank you. Have any questions, feel free to ask me.
Thank you, Ms. Masters. Members, any questions? All right, thank you for your testimony, as always.
All right, thank you.
Anyone else wish to testify on, for, or against 5179, House Bill 5179? Okay, seeing none, the chair recognizes Representative Placey to close on our bill.
Thank you. Members, I know we've used some uncomfortable language today, but these are medical and legal terms, and if it seems graphic, that's because the nature of this battery is graphic. In the plainest of terms, victims have been forced to have unprotected sex, and they deserve a legal avenue, meaningful relief. I'd like to thank those who testified, Dr. Masters, who is on the governor's sexual assault task force, those who have been brave enough to submit their written testimonies, and those who have confided in me with their experiences. Thank you to Chairman Moody for joint authoring this bill with me, and for the chairman for bringing this up for a vote. This issue is widespread, prevalent. Creating justice for survivors is a topic worthy of our time and worthy of debate by the whole House. Members, I ask that each of you will carefully consider the merits of this legislation and vote aye. And with that, I close.
All right, thank you. Representative Slauson.
I have just a question here. Thank you for bringing this, and hard conversations, we have them all the time. My question is, in the damages section, when it talks about the potential for appropriate injunctive relief, I just wasn't sure what might be contemplated that when we're dealing with something that has already occurred.
Yes. So I am not an attorney. I'll be honest, I had to consult numerous attorneys, both civil and criminal, to get a grasp on what the need is and how the nuts and bolts of this procedure would work. As you know, injunctive relief can typically only be granted when there is no other remedy under the law, and that irreparable harm will occur in the absence of relief. It is up to the judge to make this determination and determine the appropriate injunction. One example I've heard was a situation in the Panhandle region. Multiple women came forward with enough evidence that the same individual had spread gonorrhea to multiple women. The women claimed that the disease was intentionally spread by the defendant, and the judge granted injunctive relief as the case proceeded. The injunctive prohibition that The injunctive prohibited the defendant from engaging in sexual activity until the court could determine that he no longer had gonorrhea and it would no longer pose a threat and cause irreparable harm.
Okay. And when we're specifically talking about purposeful removal here and not
Accident. This is intentional. This is an intent to deceive the person that you're having this act with.
Thank you.
Thank you.
Representative, who, obviously, we know that the situations that you've described where it's the person not wearing the condom that has the cause of action, but what about a situation where, and I've heard and I've read, I'm just reading a couple instances now where that person might unknowingly to the person wearing the condom actually, put a hole in it or remove it during.
Yeah, so that actually happened in Germany. There was a woman that was found guilty of purposely poking holes in condoms. That would not be covered under this, but I would love to work with you on a committee sub if you wanted to do something like that.
Are we sure that wouldn't be?
I don't believe so because of the way the bill is written, but it has been.
Because it's removing?
Yeah, because the word of removing. So, but I have that has been weighing on me, honestly. And so but I just don't know how we would.
Yeah, I think there's some, because I understand the intent of the bill, and it's obviously a growing problem that we need to be serious about and try to address. But I think that there's more there's more to it situationally, and we have to be clear in terms of who has the cause of action, who's the plaintiff, who's the defendant, who's liable to whom, and I just am seeing some. Parts of the bill that I think can be strengthened, and I'll talk.
Well, I would love to work with you to make this an even stronger bill.
All right, members, any questions? Any other questions? Okay, thank you, Representative.
Thank you so much.
Appreciate you laying this out.
I appreciate your consideration. Thank you.
With that, the chair will leave House Bill 5179 pending at this time. Let's go through. Schofield. Mike, are you ready? Sure. Okay. The chair lays out House Bill 5010 and calls on Representative Schofield to explain the bill.
Thank you, Mr. Chairman. It's always fun when you have 5010 and 5101.
5010 is the one we're on.
Gotcha. Okay. Thank you, Mr. Chairman. House Bill 5010 would require that a person who files a grievance against a lawyer with the state bar actually have a cognizable interest in the matter, much like for much like a malpractice claim. You have to be the person who is the client or somebody who actually has a cognizable interest, as opposed to just letting frankly, the weaponization of bar grievances where somebody who doesn't like somebody can just start filing claims against their license that have nothing to do with any representation. For example, we're all potentially could have claims filed against us for our votes here in the House or for other performance of our official duties. And so that's basically what the bill would do. It would require that the person who submit the grievance have a cognizable interest. And with that, I would be happy to hear from any questions.
Okay, thank you, Representative Schofield. Members, any questions? All right, we've got three witnesses here. We've got Larry McDougall, Murtaza Sudarwala, and Trey Apfel. Larry, let's start with you. I've got you here registered, and again, we're on House Bill 5010. I've got you here registered on behalf of yourself testifying against the bill. I'm sorry, testifying for the bill. Is that correct?
I'm testifying for the bill, yes, sir.
Go ahead.
Thank you. Let me introduce myself to those who don't know me. I'm a retired police officer. I am the past president of the State Bar in 2020, 2021. I've served as a member of grievance panels, and I was also the district chair for the number 5 district grievance panels with the bar. I'm in favor of this. I will start off by saying there's a lot of frivolous grievances that are filed with the State Bar. By placing this in place, it will eliminate some of those State Bar grievances. I will state that the CDC does a great job in trying to eliminate these, but some get through. And the problem we have is a lot of lawyers have to take 1, 2, 3, 4 days of their time to respond to these grievances. They're highly stressful. And usually when they're filed by third parties, they wind up being an inquiry or they're dismissed in a summary disposition. What I'm asking for is for you to approve this bill to prevent those type of grievances from happening, and also to lay out a procedure so that the lawyers don't have to respond to these type of frivolous grievances. And that's really all I have. If you have any questions, I'll be glad to answer them.
All right. Thank you, Larry. Members, any questions? All right. Thank you for that. Chair calls Murtaza Sudawala. I've got you here on behalf of the Muslim Bar Association of Houston and yourself testifying for the bill. Is that correct?
Yes, that's correct, Chairman.
Go ahead.
Thank you, Chairman, and members of the committee for having me here. I am for this bill, and my organization also is for the bill. We believe as attorneys that bar grievance reform is important. I think this is a very important first step that the legislature is taking in this regard in modern developments. I would say 3 points in support of the bill. First, it inserts fairness and due process in the system. It limits what we would call bad grievances or improper grievances, frivolous, not related to the matter at hand. This would mean that limited resources that the State Bar through the CDC has can focus on good or proper grievances and stopping up the system. And finally, with more proper grievances in the system and less frivolous ones, this would also mean that the cost of legal services would go down and that the access to justice for Texans would improve. I have in front of me the report issued by the Commission for Lawyer Discipline. This is the most recent one available, the 21-22. They say 7,000 grievances have been filed, of which 5,000 were dismissed as inquiries, which is the lowest level, usually allocating that no violation has happened. That means time and effort is spent. We would take this out by taking out those members of the public who are just complaining with no connection to the matter at hand. And standing is important. This concept it relates to standing and cognizable interest. We have that concept throughout our legal system. You can't just file a divorce if you're not the husband or the wife. And I think this equates the bill to that. And I yield to questions.
Okay. All right. Thank you. Can you tell me how to pronounce your last name again?
Yes, Chairman, it's Sutarwala.
Sutarwala.
Yes.
Okay. All right. I just want to make sure I got it correct. Okay. Mr. Sutarwala, thank you. Members, any questions? All right. Thanks for your testimony. Chair calls Trey Apfel. Trey, I've got you here on behalf of the State Bar of Texas testifying against this bill. Is that correct?
Correct.
Okay.
Chairman Leach, Vice Chair Johnson, members of the committee. There are two principles that guide us at the State Bar of Texas. And every decision we make, we rely on those two principles: self-regulation of the profession and protection of the public. Let me take a step back and give you a little bit of background about me. I've served as executive director of the State Bar for 5 years. Prior to that, I was a practicing trial lawyer for 35 years. During that time, I also had the privilege of serving as vice chair of the Commission for Lawyer Discipline, which oversees the disciplinary system. As the administrative arm of the judicial branch of state government, the State Bar is fully committed to protecting the public through our attorney discipline system. The last time that the State Bar went through sunset review in 2016-2017, the legislature at that time was concerned that the number of grievances filed against attorneys was relatively flat in comparison to the increase in attorney population over the years since the previous sunset review. A number of changes were instituted at that time to make sure that our system was accessible by all persons who had been harmed by attorney conduct or who were aware of harm inflicted on an unsuspecting client. It's important to note that the attorney discipline system has undergone additional reviews since that 2016-2017 sunset review. Over the course of 2 years, 2020 through 2022, And under the direction of President Larry McDougall at the time, he formed a task force to study the grievance system from top to bottom. That task force studied it for 11 months, and then the State Bar Board of Directors studied it for another 13 months. At the end of that process, the board approved minor modifications to the attorney grievance system, but neither the task force nor the Board of Directors believed changes to the standing requirement were needed. And then most recently, the Supreme Court asked the Grievance Oversight Committee, which is a Supreme Court appointed committee independent of the bar, to review the issue of standing, and the committee concluded that a standing requirement would, and I quote, be disruptive and inconsistent with a self-regulating bar's goal of protecting the public. I brought copies of the Grievance Oversight Committee report for this committee. Currently, anyone who believes that any attorney committed misconduct may file a grievance, and there are good reasons to keep it that way. Briefly, first, and citing the GOC reference to a client who is capable and willing to complain, a client may not be aware of an attorney committing a grievable offense. Depending on the case, only opposing counsel or the judge presiding over the case may be able to recognize a grievable offense, and they may be the ones in the best position to know that that's occurred. Also, lawyers owe a duty to their clients, yes, but more importantly, a lawyer owes a duty, and that duty extends beyond just clients. I'll cite to you Part 1501 of the Texas Disciplinary Rules of Procedure, and it says, the purpose of lawyer discipline proceedings is to protect the public and the administration of justice from lawyers who have not discharged, will not discharge, or are unlikely to properly discharge their professional duties to clients, the public, the legal system, and the legal profession. So as you can see, the breadth and scope of the disciplinary system is much broader than just the attorney-client relationship perspective. I want to recognize and thank Representative Schofield for the opportunity to have discussions with him previously about this bill, and we certainly are willing to continue those discussions moving forward.
Okay. Members, any questions for Trey?
Mr. Chairman, and I do appreciate your meeting with me. I will say the only people who have complained to me about this bill are state bar staff. I haven't had a single person out there say, if we have a standing requirement that, and we can't weaponize these attacks anymore on a practicing attorney, that something bad will happen or that I won't be able to do anything. No one has come to me and said that's an issue that we need to deal with. If the idea was, well, we haven't had enough numbers of complaints, so let's just open it up and let anybody complain, why don't we just say there aren't enough malpractice suits against lawyers? Let's let anybody who doesn't have privity with the lawyer sue them. I don't think that is a really cognizable interest that somebody has in filing in basically threatening somebody's license to make a living. And so, I mean, we've met before, and we'll probably continue to meet as we go through this, but I think this is a serious issue. And before we get too far down the road of attacking people's way to make a living when we have no cognizable interest in it, we ought to really think about whether that's necessary. You can come back and hit me.
I hear what you have to say, and I respect that comment.
Okay. Members, any other
Thank you,
questions?
Mr. Apple, and thank you all for being here.
Thank you. Representative Flores?
Having been a former staffer at the State Bar once upon a time, I can understand the importance of protecting, the public's right to bring a complaint, as well as the bar gets put under a lot of pressure by the Sunset Committee as well. The standards that they hold them to are high. And that is part of this legislative process. And so I understand what you're trying to fix, but at the same time, they're under the gun. I mean, the legal profession, in order to protect self-regulation, needs to be, walk a tightrope, and needs to make sure that they are, giving the public enough opportunities, to feel that they have, redress. So I think that's the fine line that needs to be walked. And I may be misspeaking, but I think that's from one past experience and what I recall, that's why it's important.
Members, any other questions? All right, thanks to each of you. I appreciate you being here.
Up next.
We're going to take up some pending business, but why don't y'all go back to your seats, and then I'll call you back up. The chair recognizes Representative Schofield to close on his bill.
Mr. Chairman, I close.
So let me ask, does anyone else wish to testify on, for, or against House Bill 5010? Seeing none, the chair recognizes Representative Schofield to close on the bill.
In that case, I close.
Where's she going? Where's she going? Okay. Okay, members, any questions for the bill's author? Okay. With that, the chair will leave House Bill 5010 pending. Members, we're going to wait on Representative Flores to come back in just a second, and then we're going to take up a few matters of pending business. Yes, I do.
Which bill number of yours is the Penske bill?
Hang on just a second. You want to go fast? All right, members, before we take up our pending business, the chair lays out House Bill 525 and recognizes Representative Vasut to explain the bill.
Thank you, Mr. Chairman. Members, if you practice law, maybe you've had the situation where you've got your motion on file and you're waiting on the court order to be issued, and then you keep waiting and waiting and waiting, and you just never know when the court order is issued, and then all of a sudden you go check online and they issued it 2 weeks ago. And it can be frustrating. And this has happened to me many, many times. And we as attorneys are required to e-serve. And I just would like to have the court orders served as well. We may look at some substitute language in the future to kind of shore this up, because I know that district clerks right now don't have access to the same e-service platform that we do. But the general concept is if attorneys have to electronically serve documents, then we ought to have the same thing for orders as well. Reserved the right to close.
Okay, members, any questions for the bill's author?
I like it.
All right, seeing none, does anyone wish to testify on, for, or against House Bill 525? Seeing none, the chair recognizes Representative Vasut to close.
I close. Thank you, Mr. Chairman.
All right, thank you, Representative. The chair will leave House Bill 525 pending at this time. Members, we're going to take a few matters of pending business, and then we'll get to our few remaining bills of the day. Members, the chair lays out House Bill 200 as pending business. This is my bill reestablishing the Prosecuting Attorneys Coordinating Council. I want to give you an update, members, on this bill. I understand there's some concern. I grasp those concerns. In fact, I agree with several of those concerns. I am and have been over the past couple weeks since I laid this out, been working aggressively with interested stakeholders, with interested parties, with many of you, with the Prosecutors Association, communicating directly with them and with other prosecutors across the state who have good faith, legitimate concerns about prosecutorial discretion and about the state exercising any form of oversight over prosecutors. There's another bill that's moving through the process that I'm proud to support and was proud to vote for out of committee, out of Chairman Moody's committee yesterday. I believe very strongly that we need state oversight of our prosecutors. I am hopeful that this can be, as it should be, a bipartisan issue. This is about the rule of law. This is about holding elected officials, especially political officers of the state, accountable. All prosecutions in Texas, every single one of them, in every county across the state, all of them, are carried out in the name and by the authority of the state of Texas. all of them. And for any prosecutor or any group of prosecutors to say that we don't want and we're going to resist any form of state oversight is to me disingenuous at best. The state absolutely has, my strong opinion, absolutely has the right to exercise oversight over our prosecutors and their offices, to hold them accountable where necessary. And that's the intent of this bill, recognizing that the vast majority, over 99% of contractors, prosecutors, will never be affected by this bill. But where there is misconduct that should be actionable and our existing laws and processes and procedures are not enough or not sufficient or don't work to remedy those situations, I believe that the state, through this bill, should exercise oversight. That said, the bill in front of you now is the original bill as filed that I'm going to ask you to vote on today. I have been working, members, many of you know that the labored negotiations and discussions that I've been having with the relevant stakeholders, proposing language, making major concessions, almost entirely neutering the bill, but yet still being effective to a certain extent. And I've gotten resistance and not stonewalled, but resistance, strong resistance at every step of the way. And so my purpose here is to move this bill forward, committing to you that there will be a substantial floor amendment that will do my best to respect the will of the concerns, I should say, of many of the prosecutors who've expressed those concerns, but also achieving what I believe to be a really important opportunity for us to exercise state oversight. And so I'm going to ask members for you to vote favorably on this bill. With that, I'm happy to take your questions. Chairman Moody.
I don't have questions, just comment. I want to, man, you mentioned obviously the conversation's been a part of, and I just want to thank you for having those conversations earnestly and working through those issues. And I know there's still things to be talked about. And this is a broad conversation, lots of different ways to tackle this, and certainly I respect your approach to it. I know that, and I just want to be clear, that the bill we have in front of us is the bill without some of those conversations that we've built around it. I know that's for timing. And so for me, procedurally, because we don't have those changes in front of us now, I still am not comfortable supporting it, but I want to let the rest of the committee know this is a bill you have spent an enormous amount of time on, working with folks and addressing those concerns, and I'm going to continue to have those with you. I just want to make sure that I don't want to conflate that conversation with the language you have in front of us. So procedurally, that's where I'm at, but I wanted to explain that before we move forward. So I appreciate all your work.
Thank you. Thank you, Chairman Moody. Members, other questions? All right, thank you. And I look forward to working with you. Members, I have an open door as always. I try my best. I think all of you who've worked with me for a while know I try my best to not move forward without not just a consensus, but a strong consensus of stakeholders who are affected by the legislation that has my name on it. And this is I don't want to move too fast, but I need to move this bill, but the conversation will continue. Representative Murr.
Mr. Chairman, I just want to add on to that. I appreciate the work that you have put into it and the work that you are going to continue to put into that. By my count, I have 19 elected prosecutors that I represent, and I know that some of them are listening, and I have assured them that there's a work product that you're going to put out that's going to address some concerns that have been raised, and I have every ounce of faith that you are working on that. So I'm reassuring them by saying I'm voting for this now, knowing that your product work continues.
Thank you. Thank you, Chairman. And I know others are in that same position. I want to communicate to you and I mentioned this to another member on the phone last night, share my cell phone, my personal cell phone, with any single one of those prosecutors. If they would like to talk to me directly, if they have ideas or concerns, I'll be available 24/7 to listen to them and to talk to them, or to meet jointly with them along with you. Yes, Representative Flores.
I'm going to look forward to voting for your bill on the House floor. However, at this point, I'm going to have to reserve the right to withhold that vote. Thank you.
Thank you. Members, other questions? Okay, with that, Representative Vasut moves that House Bill 200 without amendments be reported to the full House with the recommendation that it do pass and be printed. The clerk will call the roll.
Leach?
Aye.
Johnson?
No.
Davis? Moody?
No.
Murr? Schofield?
Aye.
Vasut?
Aye.
Slauson. Flores.
There being 5 ayes and 3 nays, the motion prevails. Thank you, members. The chair lays out House Bill 653 as pending business. This is Representative Allison's bill relating to guardianship of the persons of wards with profound intellectual disabilities who are or were minors when their guardianship proceedings commence. There is a substitute. Representative Johnson, Vice Chair Johnson offers up that committee substitute. Do any members have questions about the committee sub? All right. Is there objection to the adoption of the sub? Seeing none, the sub is adopted. Representative Schofield moves that House Bill 653 as substituted be reported to the full House with the recommendation that it do pass and be printed. The clerk will call the roll.
Leach.
Aye.
Johnson. Davis. Moody. Murr. Schofield. Basute. Slauson. Flores.
There being 8 ayes and 0 nays, the motion prevails. Members, the chair lays out House Bill 2139 as pending business. This is Chairman Burrow's bill relating to the construction of codes, laws, and statutes. There is a substitute. Representative Slauson lays out that committee substitute. Members, are there any questions of the substitute? About the substitute, I should say. All right, seeing none. What? It's a ledge council draft of the bill. Additionally, it changes the definitions of shall and must. One on page 1, line 6, and then page 8, line 8. Okay. Are there any questions, or is there any objection to the adoption of the sub? Seeing none, the sub's adopted. Representative Chairman Moody moves that House Bill 2139 as substituted be reported to the full House with the recommendation that it do pass and be printed. The clerk will call the roll.
Leach.
Aye.
Johnson. Davis. Moody. Murr. Schofield. Basute. Slauson. Flores.
Representative Floor, was that a no? Okay. There being 7 ayes and 1 nay, the motion prevails. Members, the chair lays out House Joint Resolution 107 as pending business. This is Representative Price's resolution proposing a constitutional amendment to increase the mandatory age of retirement for state justices and judges. I want to recognize Representative Basute to explain what he and Representative Price have discussed on their 2 very similar joint resolutions.
Yeah, just thinking about what has the highest potential to pass in the body politic. And so I think all things considered, I'm willing to be very practical, even though age is just a number. Thank you.
Wait till you get to be my age, then tell me that.
Okay, so we're on HGR 107. Appreciate you, Representative Basute, working with Representative Price on this. Representative Basute therefore moves that HGR 107 without amendments be reported to the full House with the recommendation that it do pass and be printed. The clerk will call the roll.
Leach.
Aye.
Johnson. Davis. Moody. Murr. Schofield. Basute. Slauson. Flores.
There being 8 ayes and 0 nays, the motion prevails. The chair lays out House Bill 2266 is pending business. This is my bill relating to judicial review of certain local laws applicable to state license holders. Are there any questions? Representative Basute moves that House Bill 2266 without amendments be reported to the full House with the recommendation that it do pass and be printed. The clerk will call the roll.
Leach.
Aye.
Johnson.
No.
Davis. Moody. Murr.
Aye.
Schofield. Basute. Slauson. Flores.
There being 5 ayes and 3 nays, the motion prevails. Do you want to vote on 31? Do you want to vote on 31? Okay. All right, the chair lays out. You want to vote on 39? The chair lays out House Bill 3952 as pending business. Members, this is Representative Schofield's bill relating to the jurisdiction of courts in cases of forcible entry and detainer and forcible detainer. Are there any questions? Seeing none, Representative Slauson moves that House Bill 3952 without amendments be reported to the full House with the recommendation that it do pass and be printed. The clerk will call the roll.
Leach.
Aye.
Johnson.
No.
Davis. Moody.
3952.
Murr. Schofield. Basute. Slauson. Flores.
All right, there being 5 ayes and 3 nays, the motion prevails. Okay, members, I am going to ask that you bear with me real quick. That's all we have in terms of pending business, but I am going to lay out, as a matter of new business, the Omnibus Courts Bill. And I'm going to do so relatively succinctly, and then I'm going to ask that we vote this bill out today. We need to get this bill moving. As you know, members, the Omnibus Courts Bill every session is typically, historically, carried by either the chairman of the House Judiciary Committee and then the Senate Committee on Judiciary or State Affairs, one or the other. This is a bill that yes, will have my name on it as the bill author, but as the Committee on Judiciary and Civil Jurisprudence, you each will have a key hand in crafting this bill. This bill will include many of your own ideas and perhaps some of your own individual standalone bills. There will be a massive floor amendment that we will present when this gets to the floor that will take into account many of the members' local bills and other issues that we could possibly get off the other calendars and get into the Omnibus Courts Bill. We've worked really hard on this. I want to thank all the stakeholders, OCA, the judges, all the stakeholders. You know who they are, who've had a hand in this bill. I want to thank each of you, and I especially want to thank my Chief of Staff, Lauren Young, and Cassidy Skyby, who this is truly this is hard work, and this is a true labor of love for them, and we've got a really good bill in front of us. The committee substitute in front of you, okay, so I do need to lay out the committee sub. I will lay out the committee substitute to the bill. It's therefore in front of us now. The committee sub in front of you creates 12 new district courts. This is all in your notes. I'm not going to go through them unless you want me to. You can stop me if I need to, but I won't. The committee substitute creates 12 district courts, 3 county courts at law, and 2 probate courts. That's, of course, based on members' own district information, caseloads, case backlogs, population growth, workload measures, and then an expression of county support. Furthermore, it adds a number of additional judicial administration provisions to ensure efficiency and uniformity in civil processes and procedures in our state, as well as requests from members that fall into this category. Many of these provisions are bills that we've heard in committee already. With the author's permission, we've included it in the Omnibus Courts Bill, and will, of course, as I mentioned, continue to perfect this. I am happy to go through some of the changes unless y'all, someone give me a signal if you want me to go through specifically what's in here. I'm happy to, but okay. And then there's another specific section that I want to mention. Do you want me to do that before your question? Okay. Members, I want to mention today, I, along with a couple other members, including a couple on this committee, attended the Chief Justice's State of the Judiciary address in the Supreme Court. It was a remarkably compelling message from our state's longest serving Chief Justice. I hope that you will go listen to it or get a copy of his written remarks. We, of course, this committee has great respect for our Chief Justice, and it was great to hear from him today. The State of the Judiciary address is currently statutorily required to be delivered by the Chief Justice at the commencement of every legislative session, and that's basically all that the statute currently alludes to. This session, for various reasons that to this point have not been made abundantly clear to me, the Chief Justice was not, as he has historically been, for as long as I can remember, and Megan could probably give us the exact data, but it's been a long time that the Chief Justice has historically been invited to come into the chamber in front of a joint session of the House and Senate at the commencement, near the commencement of every legislative session, to deliver his State of the Judiciary address. For reasons unknown to me, that did not and was not allowed to happen this session. And frankly, the reasons why don't really matter at this point. But when I listened to his State of the Judiciary address today, I thought to myself, this is, and I put this on Twitter earlier, this is a message that the people of Texas, especially the legislators on both sides of the aisle, need to hear. It was an incredible review of what the judicial branch has done in times of crisis, in times of emergency, how we've served our growing population, how the courts have been wide open to litigants all across the state, how we've improved access to justice. We've ensured that folks, no matter where they are, what side of the bar that they're on, that they have access to our courts. We also talked about many of the present challenges facing our judiciary, and the Chief Justice presented an aspirational, I believe, vision to us, and he talked about specific items of legislation that we need to pass this session. I thought to myself, this is a message the people of Texas need to hear, and a messenger that we should be proud to hear from. And I regret that it wasn't delivered in the House chamber. So as part of this omnibus courts bill, I've included an amendment to the government code to require that in future sessions, the Chief Justice of the Texas Supreme Court will be required to orally deliver the state of the judiciary to a joint session of the legislature near the commencement of every legislative session. And members don't have to attend. No one's forced to attend. No one's forced to listen. But I think that it's important for us, the executive and the legislative who work in this building, to hear from the co-equal branch of government, our judiciary, at the beginning of every legislative session. And I just wanted to mention that because I think our Chief Justice did a remarkable job today. And I just wanted to mention that specific part of this bill. And I feel pretty strongly about it, I should say. So with that, I'm happy to take your questions.
Mr. Chairman, if I may just echo your comments, I was over there with you, and this is the first time I can remember, and I've been following the legislature for a long time, and I'm old. I think that it is something that needs to be done, and I'm disappointed that we didn't invite the Chief Justice. I understand the governor chose to go out on the road and do his, but the governor has a bully pulpit the Chief Justice doesn't have. And I think that the message that we heard from the Chief Justice and that we all should have heard was important. And I think that it's a shame we didn't invite him, and I'm fully in support of your amendment to the bill to require it to happen. And so thank you for bringing that.
All right, thank you.
Ditto.
Okay, thank you. Members, any other questions about the bill? Okay, with that, we've got a few witnesses. We do have, I'm going to ask these witnesses to come up. Trey Duhan, Elton Mathis, Gail Fiasco, and Megan Lavoie. I want to ask you witnesses to try to keep your testimony as brief as possible. I want to vote on this, and we've got members with immediately pressing scheduling issues. And so if you can, we're gonna vote on this, members, right after this testimony. So is it Ms. Mathis? Ms. Fiasco. All right. Gail Fiasco, I've got you here on behalf of the Texas Court Reporters Association and yourself testifying for House Bill 3474.
That's correct.
Okay, go ahead.
Thank you, Chairman Leach and committee members. TCRA, Texas Court Reporters Association, is here in support for House Bill 3474. We appreciate all of the hard work that has gone into this bill. I'd also like to thank the chair and committee for your service and your dedication to the citizens of the state. And with that, thank you.
Thank you. Thank you, Ms. Fiasco. Members' questions for the witness. All right, thank you. Chair calls, are you Elton or Trey?
I am Elton.
All right, Elton Mathis, I've got you here on behalf of Waller County and yourself testifying for House Bill 3474. Is that correct?
Thank you, Chairman Leach, Vice Chairman Johnson. I'll be quick. I'm going to cut it in half. Judge Duhan left, so you can take him off of there. Right. My name is Elton Mathis. I've been honored to be the district attorney of Waller County for 17 years now, and I just want to thank each and every one of you. I concur. This bill is great. I also need to give a shout out to, I'm assuming here, Senator Hughes and maybe Senator Huffman, that were a part of getting our specific concerns to the House in conjunction with Chairman Leach to get our County Court at Law number 2 in here. Depending on who you listen to, we're the fastest growing county in Texas, Waller County. We are the last county that hasn't been completely paved over with concrete outside of Houston, and so we're very popular. We've got thousands of houses under construction right now, and we are served by only half of a district court that we share with Grimes County. As DA, I've got about 1,200 felony cases. We're lucky if we get to try 2 a month. So your inclusion of this court in this bill gives us a hybrid county court at law with felony jurisdiction that's going to go a long way to alleviating the needs of our quickly growing county. Thank you. And I've submitted one minor housekeeping change. I believe it's already been tendered to the chairman's office, just the way that the bill was set up, you were going to make my county clerk the custodian of all the felony records, and she was not happy about that. So anyway, if that one change could be made, I think it's great.
Okay, all right, thank you. Members, any questions for Mr. Mathis? Yes, Representative Schofield.
Thank you, Mr. Mathis. I know I talked to Judge Duhan earlier. He actually came up and he's going to testify on one of my bills as well, and I appreciate it. Waller County is 60,000 people, and you're going to have 3 times that in the next 12 to 15 years. So we're going to be hearing from them again on this.
Yeah.
I appreciate it, and I talked with Representative Kitzman, and he wanted to be doubly sure that the court had felony jurisdiction because it's a whole new game out there. When my district grows by 50,000 people, we can absorb them. When a county with 60,000 grows by 80,000 and then 120,000, God bless you. We're going to see you in the future. But thank you so much for coming up here.
All right, yes, thank you. Members, other questions for the witness? All right. Our final witness, the chair calls Megan Lavoie, Office of Court Administration, on the bill.
Good afternoon, Chairman Leach and members. My name is Megan Lavoie. I'm the Administrative Director for the Office of Court Administration, here as a resource on the bill. As Chairman Leach did say, the Office of Court Administration does do a workload analysis to determine where judicial resources are needed for each court that is in this bill, and happy to work with your office as this bill moves through the process, and happy to answer any questions you have.
All right, thank you. Thank you. Give the Chief Justice our best. Members, any questions for Megan? Okay, thank you. Thanks to each of you. Does anyone else wish to testify on, for, or against House Bill 3474? Seeing none, the chair will close public testimony. Members, in my closing, I want to reiterate to you and to other members, I remain open. My office remains open for additional changes. There will be a pretty major and substantial floor amendment, and I welcome you to work with me on that. Thank you for that. And with that, the chair moves that House Bill, I'm sorry, we do need to adopt the sub. The chair moves that the sub be adopted, or is there any objection to the sub adoption? Seeing none, the sub is adopted. The chair moves that House Bill 3474, as substituted, be reported to the full House with the recommendation that it do pass and be printed. The clerk will call the roll.
Leach.
Aye.
Johnson.
Aye.
Davis. Moody. Murr. Schofield. Pursuit. Slauson. Flores.
Thank you, members. There being 8 ayes and 0 nays, the motion prevails. Thank you. Thank you. All right, the chair lays out House Bill 5101 and calls on Representative Schofield to explain the bill.
Thank you, Mr. Chairman. While this bill has a similar number to one we heard earlier and is about bar grievances, it's a totally different topic. This bill is about concerns that a lot of lawyers have had, including several in the legislature, that there's been a weaponization of bar grievances, not only from the outside, but they're concerned from the inside, and that some of the political stands and political views that members have, or that the Attorney General or other people have, can be used against them in bar grievances, and that is very concerning. Right now, there's no way out. There is no appeal. There's nobody else to go to. This bill would allow a lawyer who thinks he has good grounds to go to the Supreme Court and say, there's nothing here but my political views or my stands or my social views or whatever it is, and to give the Supreme Court a chance to look at it and decide whether or not this thing ought to go forward. It's great to have a self-regulating bar as long as they focus on bar-related stuff. But if we're going to start shooting at each other over what our policy views are on things, I'm not willing to have my license put at risk because people don't like my views and the way I vote. And I think a lot of other members are the same. So with that, Mr. Chairman, I'd be happy to hear from the witnesses.
Okay, thank you.
I would reserve the right to close, although I don't know anybody's ever been denied the right to close for not saying that.
There's a first time for everything, Representative Schofield. You got your right to close, though. Members, are there any questions for the bill's author? All right, seeing none, we've got a few witnesses here. Chair calls Murtaza Sudarwala. I get it right? That's right. All right. Larry McDougall and Trey Apfel. All right, Mr. Sudarwala, let's start with you this time. I've got you here on behalf of the Muslim Bar Association of Houston and yourself testifying for House Bill 5101.
That is correct. Thank you, Chairman and members of the committee. Again, I'm in support of this bill. The previous bill that we mentioned, Representative Schofield, this goes to bar grievance reform, which we feel is much needed. I think 2 points I would take away is that there is a balance of power, as Chairman Leach was mentioning just a few minutes ago about the co-equal branch, and that is the Supreme Court and the judicial branch. Here, the bar grievance on a technicality, it is issued, the license is issued by the Supreme Court of Texas for lawyers to practice, and bar grievances, when they get to the point of a just cause determination and they're actually docketed in the Supreme Court. However, though it's a docket of the Supreme Court, as practicing attorneys know, it does not initially go to the court which has docketed the matter. I've counted the steps in the grievance process where eventually it does get to the court that issues, that initiates the case. And it can be 8 or 10 steps, which can mean, and that 8 to 10 steps means time, resources, and a lot of stress on the parties. And I think this bill is much needed because it allows a safety valve to come in very early on for the Supreme Court to say basically, not in our name, or at least let's pause the situation and allow the parties to sort of have cooler heads to prevail. And for those reasons, I'm in support of this bill, and I'm open to any questions.
All right. Thank you, Mr. Studerwala. Members, any questions? Yeah, Representative Schofield.
Mr. Studerwala, I didn't thank you the first time because we were trying to get to a vote, but I want to thank you for taking the time to come up here. I know you're from my area. I'm from West in Katy. But thank you for your support of the bill, but also thank you for making your views known, and I appreciate it. Thank you for coming.
Thank you, Representative.
All right, members, any other questions? Okay. Chair calls Larry McDougall.
Thank you, Mr. Chair.
Larry, I have you here registered on behalf of yourself testifying for House Bill 5101.
Thank you, Mr. Chair. As you can probably tell, during my time as president and others, I've been very pro-lawyer, trying to figure out things to make lawyers' lives better, take the stress off so we can best represent our clients. I did form the task force, like Mr. Apfel said, and we did make a lot of series of recommendations where we believe drastic changes were needed to the grievance process. And that's in the record, and that's in the report. This was forwarded to DCAP to take action in there. And I'm not wanting to start a he said, she said, but what Mr. Apfel stated a while ago was very misleading. I will say that what we did in our committees, though, in our task force, while we looked at standing, it was not one of the priorities that we had because we thought there was much more egregious issues going on. We did not look at the issue of this appeal. And when I saw your bill, I studied it and looked at it and kind of went, why didn't we think of that? I mean, you know, we had all these lawyers together doing this. And I'm speaking in favor for it because it does give the lawyers an opportunity or a place to basically head off the grievance process in a way to stop frivolous grievances. As many of y'all know, I mean, nobody got persecuted like I have by the state bar. And so I think this would be a good step in the right direction to prevent a lot of miscarriages of justice and political prosecutions of lawyers for their political views. And with that, I support this bill.
Members, any questions?
Mr. Chairman.
Yes, Representative
So,
Schofield.
Mr. McDougall, today under current law and current process, what is my appellate right if I get sanctioned by the state bar?
Only if you lose. If you go to a panel, you get to go to BOTA. If you go to a district court, then you go up through the appellate process through the courts, and that's your only appeal. A citizen making complaint has an opportunity if the CDC rules it as an inquiry. They have an opportunity to appeal it to BOTA, and then BOTA can overturn it. If they turn around and basically show just cause and require you to respond to it, you have no means to appeal that. Your only position then is to go to, basically, they call it an investigative hearing, and that's one of the issues where we had a lot of problems with the way the CDC conducts its business. And then after that, if just cause is found, then you have to choose a jury or a grievance panel to go to. So the only opportunity you have, really, is to fight it. And there is no appeal unless you lose, and then, of course, that you have those appeals, but you have to go all the way through the process.
By that time, you've been fairly besmirched, your reputation and your ability to practice, even if you don't end up with the sanction on your record.
Exactly.
And under today's law, anyone can file that grievance against me. Anybody.
Anybody can file a grievance
They
against
don't even have to have ever met me, much less have been on the receiving end of any of my practice.
They can turn around and read a newspaper report and not like what you did and file a grievance on you. That's simple, with not having any connection to you or the case.
And again, as you say, I don't get any appellate relief until after there's been a ruling.
That's correct.
Thank you, sir.
All right, members, any other questions? All right. Seeing none, the chair calls Trey Apfel. Trey, have you here on behalf of the State Bar of Texas against House Bill 5101?
Correct. Chairman Leach, members of the committee. First of all, we are totally against frivolous complaints. And if there were a way that we could fashion a remedy to handle frivolous complaints, we're all for that process. Secondly, the task force that undertook its review in 2020, there were no limits on that task force. That task force looked at everything. Standing was not one of the shortcomings that was found by the task force. Second and third, there were no findings by that task force or the board of any egregious conduct by the Chief Disciplinary Counsel's Office, Commission for Lawyer Discipline, or otherwise. Without Bill 5101, there are appellate remedies available to respondent attorneys who have been sanctioned. The ultimate review is with the Supreme Court. Yes, there are many steps in the process to get there, but instead of looking at those steps as being steps that delay the process, we feel those steps are critical because in most instances, that gives the opportunity to settle those claims early on in the process. So what 5101 basically does is create original jurisdiction in the Supreme Court of any grievance, because we believe that any respondent or any respondent attorney worth his salt is going to file that appeal to the Supreme Court for review. And what that's going to do is increase the Supreme Court's docket annually by about 500 cases. And the Supreme Court is going to have to review those cases basically de novo, or from the beginning, even after we've had an investigatory panel hearing where that panel of volunteer lawyers has heard testimony from witnesses, reviewed records, and reviewed files of attorneys in connection with that complaint. So again, the sunset review of 2016-17, the legislature approved a standard process and criteria for conducting those investigatory hearings, and the purpose of that was to achieve earlier resolution of non-complex cases involving the most common violations. So we feel like this bill would add to frustration of complainants in the system in terms of having their grievances heard by the system. So,
Mr. Chairman?
Yes.
And thank you. And again, when we met on the other bill that we talked about earlier, you and I and Kaylin met on this bill as well. I think we probably spent more time on the other one, but we did talk about this. So I appreciate you doing that. I think we may have a different view of what a frivolous claim is. And I think there are members of the legislature who've come to me and said, I'm concerned if we get together and file an amicus brief in a hotly contested public issue out there, that we're going to have a claim filed against our license. And it's kind of hard for me to tell them we're not going to, given what got filed against the Attorney General for his actions on the election stuff. And so I don't see where granting somebody the opportunity, and perhaps we need to work on the language so it's not everybody gets to go to the Supreme Court and fill up their docket, but there has to be some way that we know if one side's firing at us, that we have some way to get some relief before we've gone all the way through the process and have our license acted on or our character besmirched. So that's kind of where we are on this. That's the purpose of it. And I'd certainly be willing to, and again, we didn't get to talk about this as much mostly because I told a bunch of stories and
yes, sir.
We got late. But if the process needs to be changed, I think that's one thing. But I think it's really important that we keep grievances against somebody's license to their actual practice of law and not to other things. And I think, I hope the bar has heard that loud and clear today. But that's kind of where I'm coming from. Normally, I'm the first one to criticize lawyers who abuse their position or abuse their license and all that sort of thing. But we're also seeing the reverse. People trying to make a living who are being attacked for things that may not have anything to do with their competency or the way with which they handle the case. And again, this kind of plays into the fact that anyone can file this claim. Somebody who is not my client, someone who has no cognizable interest, just doesn't like me and doesn't like the stand I'm taking. And we have a whole anti-SLAPP law to avoid that in litigation. We need something to avoid it in bar grievances. And that's kind of where I'm coming from here.
Right. And I would just remind the committee that we do have some built-in checks and balances in the grievance system, including BOTA, or the Board of Disciplinary Appeals, which is the board appointed totally by the Supreme Court, the Grievance Oversight Committee, which is an independent committee also appointed by the Supreme Court. We also have the Ombudsman that came out of the 2016-17 Sunset Review. So we have checks and balances within the system. I feel like they're working well. I understand Representative Schofield's concerns, and again, we would welcome the opportunity to work with you moving forward.
Thank you.
Members, other questions for the witness? All right. Thanks to each of you.
Yes,
appreciate it. Does anyone else wish to testify on, for, or against House Bill 5101? Seeing none, the chair recognizes Representative Schofield to close.
Mr. Chairman, thank you for hearing this bill on this important issue. And with that, I close.
All right. Members, questions for the bill's author? Seeing none, the chair will leave House Bill 5101 pending at this time. Chair lays out House Bill 2846 and recognizes Representative Kane to explain the bill.
Good afternoon, Chairman, members. Thank you for allowing me to present House Bill 2846. This bill addresses the critical issue of discrimination against or burdening the constitutional rights of lawyers of faith or applicants for holders of a license to practice law in our great state. So the First Amendment to the U.S. Constitution, of course, states that Congress shall make no law respecting the establishment of religion or prohibiting the free exercise thereof. Of course, through the 14th Amendment, the federal courts have made this restriction of power on Congress or restraining the powers of the states and all government entities. As well, though, furthermore, Article 1, Section 6 of the Texas Constitution not only provides protections for religious worship, it goes further than the free exercise clause of the Federal Bill of Rights by providing a textual safeguard for the rights of conscience by declaring that all men have a natural and defensible right to worship Almighty God according to the dictates of their conscience. No man shall be compelled to attend, erect, or support any place of worship, or to maintain any ministry against his consent. More importantly, that no human authority ought in any case whatever to control or interfere with the rights of conscience in matters of religion. In 2016, the American Bar Association created a model rule for state bars to adopt that would limit the free speech of many lawyers of faith. If Texas would adopt this overreaching rule, attorneys could lose their license based on statements that were not actually known to be or intended as harassing or discriminatory, simply because someone might construe it that way. Such activities that could entail losing a license include participating in a panel discussion or controversies that touch on controversial political, religious, and social viewpoints, serving on boards of various religious or other charitable institutions, and speaking at public events. So while discriminatory behavior by a lawyer is already prohibited in Texas, a pattern is forming where individuals with certain sincerely held religious beliefs are facing expulsions from their careers and their livelihoods. These troubling situations have sparked fear in persons of faith, and they could eventually lose their ability to make a living based on their religious beliefs. You might have some questions. I keep going if you'd like, though, but the bill is preemptive in action to address this current cancel culture of growing attacks on our freedoms of speech and expression, religious beliefs. The bill prohibits the state bar from adopting any rule, policy, or penalty that unreasonably limits person's exercise of religion or burdens their free speech. The bar does that. The person may bring an action for injunctive relief. The person comes before the state bar based on a complaint regarding their speech or conduct or even judicial proceedings. This bill would provide a defense to losing their license. This bill does not permit any individual to violate a state or federal law or current Texas disciplinary rule of professional conduct for lawyers, nor does this bill protect a person from being fired, sued, or arrested. Members, I believe our rights of speech and religion rights are the cornerstone of our democracy, and we should always ensure that they're protected. So with that, I'm happy to allow you to go to some witnesses first and go back to close, however you like to handle it.
All right, thank you, Chairman Kane. Members, any questions for the bill's author? All right, you've got your right to close. We've got several witnesses here. I'm going to call you in panels of 4. Chair calls William Russell, Jennifer Allman, Charlotte Russell. Okay, I'm going to stop there. I'm going to let the two of you do this together so that mom and dad can get a picture. Okay. Let me see. Charlotte, should you go first or should I let your brother go first?
Let the ladies go first.
Okay, there you go.
I am older.
All right, Charlotte. I have you here testifying on behalf of yourself, registered for House Bill 2846. Is that correct?
Yes, sir.
All right, go ahead.
All right, like you said, my name is Charlotte Russell. Thank you, committee and chair, so much for your time here today. I'm here representing myself and to testify in support of HB 2846. I encourage the committee to vote in favor of this bill in order to protect constitutional freedom of speech and religious liberty. This bill protects attorneys' constitutional rights, meaning that they don't have to agree to ideas that are against their convictions in order to continue practicing law. Bills like HB 2846 protect people like my dad, who went to law school in order to get a good job to support our family of 9. Currently, this right is under attack. There's movement currently in the State Bar of Texas and in the Texas legislature to infringe on these rights. Without preventative bills like this one, bills that prevent the encroachment on our First Amendment rights, my father and people like him would be in danger of having their livelihood stripped away because of religious convictions that should be protected. When the government becomes the one who decides what you can believe and what you can't, they've moved from protecting your rights into violating them. Passing this bill would protect attorneys of any viewpoint on the religious or political spectrum. Lawyers who act as legal advisors to churches, who serve in religious schools and colleges, who are part of religious ministries, and many others. HB 2846 protects against bills that could do immense harm at the expense of our legal professionals. It would protect religious liberty, and most importantly, it would protect freedom of speech. Thank you all for your time.
Well, thank you, Ms. Russell. We appreciate your testimony. Members, are there any questions? Thank you so much for being here. The chair calls William Russell. Mr. Russell, I have you here on behalf of yourself testifying for House Bill 2846. Is that correct?
Yes, sir.
All right, go ahead.
All right. Quote, "It is vain to fight totalitarianism by adopting totalitarian methods. Freedom can only be won by men unconditionally committed to the principles of freedom. The first requisite for a better social order is the return to unrestricted freedom of thought and speech." Texas representatives, I encourage you to consider the profound words of Austrian historian Ludwig von Mises. "The greatest freedom that we have in America is the freedom of speech. In Article 1, Section 8 of the Texas Constitution, it says that, quote, "Every person shall be at liberty to speak, write, or publish his opinions on any subject." House Bill 2846 is further protecting lawyers who are registered with the Texas Bar, one of whom is my dad, from being discriminated against because of sincerely held religious beliefs on sexuality and critical race theory. Everyone in Texas, including lawyers, have the right to express their opinions, regardless of how much we like or dislike those opinions. Everyone has the right to express their sincerely held beliefs without fear of having their job or means of supporting themselves taken away from them. This is common sense. If I'm in charge of a cake shop, for instance, I'm not allowed by law to fire or take away my employees' ability to work because they disagree with my opinions on political topics. If this bill is not passed, a lawyer could lose his bar card for something as simple as serving on the board of his church. It may seem like there's no danger of this happening in Texas due to our provisions on free speech, but a few years ago, my dad, Brian Russell, almost lost his bar card because of his religious views on sexuality. If we do not have the freedom of speech or thought, none of the other freedoms matter. Texas representatives, I would urge you to pass this bill. Protect jobs, protect freedom. Thank you.
Awesome. Thank you. Thanks, Mr. Russell. Members, any questions for the witness? Okay. Thank you both. Well done.
Thank you.
Thank you. The chair calls, is Jennifer Allman here? Okay.
Mr. Chairman, I have sent a message to her.
Okay, hold on. Okay. All right. Chair calls Jonathan Sines. Andrew Hendrickson and Megan Behoon. And Murtuza Sudarwala. Is Megan here? Okay. Chloe Goodman. Chloe Goodman. Okay. Are you Andrew?
Yes.
Andrew, okay. Andrew, let's start with you, if you don't mind. I have you here on behalf of the ACLU of Texas registered against this bill. Is that correct?
That is correct.
All right, go ahead.
Thank you, Chair Leach, committee members. I know it's been a long day, and I know tomorrow won't be any better, so I'll try to keep my comments brief and focus on two of our concerns with the bill. First, we believe that HB 2846 is unnecessary. Freedom of worship is a fundamental right protected by the U.S. Constitution, and the protections of religious liberty provided in the First Amendment are fortified by the Texas Bill of Rights, as the bill's author noted. What's more, the Texas Religious Freedom Restoration Act, or TRFRA, states explicitly that a government authority may not substantially burden a person's free exercise of a religion unless it furthers a compelling government interest and is the least restrictive means of doing so. Accordingly, our robust laws protecting the free exercise of religion apply equally to all Texans, including lawyers, and the protections provided in this bill are duplicative. The same applies to the U.S. and Texas Constitution's protections of speech and free expression. I'd say it's also worth noting the bill is unnecessary because the State Bar has had 7 years now to adopt the ABA model rule that the bill author mentioned. And it has chosen not to do so in those 7 years. I don't think at this point there's a big risk that that's going to happen anytime soon. Our second big issue is that while the existing law affords attorneys protections to affords these protections to attorneys, to borrow a phrase used I heard a lot in this building, HB 2846 is not a belt and suspenders situation. Enacting it could be extremely detrimental. The bill modifies the well-established legal strict scrutiny standard articulated in TRFRA by requiring that a rule be adopted be essential to enforcing a compelling government interest. That essential part is not in any of the other strict scrutiny standards and doesn't appear anywhere in Texas law currently. Enacting this new standard for the State Bar Association rules arguably diminishes religious liberty protections for non-lawyers. Rules governing the practice of law would be subjected to a heightened standard for a higher standard for legal review than those enacted or enforced by other government actors or agencies, suggesting that infringing on a non-lawyer's free speech, expression, and religious exercise rights is a less serious matter. To ensure these rights are guaranteed to all Texans equally, regulations burdening them should be subject to the same level of review regardless of the subject of the regulation. Thank you, and I am available to answer any questions.
Representative Schofield.
Andrew, let me get this straight. The American Civil Liberties Union is testifying against the bill to protect the civil liberties of lawyers to have their own religious or political views.
I wouldn't say that. I would say that we're against the bill because it creates a new legal standard that doesn't currently apply to anyone else. And in doing so, would potentially diminish the protections of religious liberty for non-lawyers.
You've been around this building a long time. You know, sometimes you dip your toe in the water. Maybe the first time we heightened the standard is in this case. Now we've got it on the books and we start moving to heighten it all over the place. The fact that it's a higher standard than strict scrutiny doesn't necessarily mean lawyers are going to be favored over other people. It might mean now we've got this on the books, we got the legislature to buy in, we can start applying it in other places. I don't think that's much of a reason to be opposed to an extension of civil liberties.
Well, I think one of the problematic parts of that is that that doesn't impact the federal jurisprudence on the matter. So the U.S. Supreme Court cases are not going to change because the Texas legislature applies a new standard that doesn't align with the strict scrutiny principles that have been laid out by the U.S. Supreme Court since the Korematsu case.
But they will keep the state bar from going after people's license based on the fact that they may not like the views they espouse, they may not like the causes they take up, they may not like who they vote for. Why would a civil liberties organization fight against that?
Because I think you're talking about a two-tiered system right now of protections for religious liberty. We have a very robust law with Tirifra. We have very robust protections in Article 1, Section 6 of the Texas Constitution that provide those protections. We believe those protections are adequate, and that the creation of this two-tiered system without a lot of jurisprudence around what that essential standard would actually require is problematic and could in fact diminish other religious liberties in the name of trying to protect lawyers specifically.
Whose religious liberty would be diminished if I give somebody else religious liberty?
Well, the implication, I think, is that that any law, any regulation related to a profession other than being an attorney would not be subject to the same level of scrutiny, and therefore would be a less serious matter, which I don't think it would be.
But it's certainly not diminished. They get the same level of scrutiny they get today. So we're not going to diminish anybody else's civil liberties by giving these people protection from losing their law. And by the way, the lawyers are the ones who get to go and fight for the liberties of other people. And if we see a whole segment of society we don't want to have rights, let's just start taking their lawyers out because we don't agree with them. Andrew, you know I have a lot of respect for you. We've worked together, and I think y'all ought to go back to your people and really think about whether you want to oppose this.
Well, I can appreciate the perspective of Representative Schofield, and obviously, yes, we have worked together a lot in the past. I think again, I see the issue here as having the bifurcated standards, not having the same protections apply across the board when it comes to such a fundamental right. And I think, when we're talking about strict scrutiny, we are talking about what is currently the highest level of review that can be applied by the courts. And so when you create a tier above that, it would essentially say that there are a lot of fundamental rights that the court is reviewing, which they're not applying the highest possible level of scrutiny to, because this would be a whole new standard.
I would say if we're having lawyers have to defend their license over their religious beliefs, then the standard they're using isn't high enough currently. Thank you very much, and I do appreciate your position.
Thank you, Representative.
Representative Suit.
I haven't gotten to work with you, and I hate to put you on the spot. So what I'm saying is more of an organizational comment, not to you, just an organizational comment. But I have deep concerns, like Representative Schofield, about the ACLU opposing a religious liberty bill. I'm trying to understand. Your arguments are, number one, you don't think it's necessary. Well, if you don't think it's necessary, then it can't be bad because it would be what we colloquially refer to as a nothing burger, in which case, why would you be opposed? Maybe you testify on it, but why would you be opposed? And then we go to the next thing, which is, well, no. It is something, it's heightening a standard. But the standard that it's heightening is more protection of liberty as opposed to less. How on earth could the ACLU be opposed to protecting liberty better? You might have stepped in an ant pile on this one.
You can change your testimony.
You can. Are you for this bill?
I am not.
Oh gosh. All right. I think that's gonna cause me to have some very different views about what the ACLU stands for. If this is an American civil liberty bill that you're opposing, it makes no sense. Thank you.
Thank you, Representative Suit. Members, other questions? All right. Thanks for being here, sir. The chair calls Jonathan Sines. Jonathan, I have you here on behalf of Texas Values and yourself registered for the bill. Is that correct?
That is correct, Mr. Chairman. Mr. Chairman and members of the committee, my name is Jonathan Sines. I'm president and attorney for Texas Values. Texas Values is the largest faith and family nonprofit law and policy organization in the state of Texas. We have supporters in all 254 counties of the state. Myself, I've been licensed to practice law in the state of Texas for almost 20 years. In fact, the work that I've done over my career has almost completely been related to defending religious liberty, not only in the legislature, but in state courts, in federal courts, in cases all the way up at the U.S. Supreme Court. And furthermore, some of the subject matter that relates in some of those cases is the exact same subject matter that motivated the American Bar Association to come up with its rule. So if we don't have protections like we have with House Bill 2846, which I'm testifying in favor of, it may make it difficult or almost impossible for lawyers like myself to continue to practice, or there would be a lot of more scrutiny on them as we see this issue moving through the State Bar Association. Now, that may be what some people want. That may be what's motivating this effort by the American Bar Association and others, but that's not right. Whether you're on one side or the other, the religious freedom that we have and that it protects with this law should reign supreme. And this issue is not over at the State Bar of Texas. I think it slowed down a little bit a few years ago, but that's likely because this body passed a bill in the Senate and in the House and almost got final passage, through committee, almost got final passage by both chambers. This issue's already moved through the Senate. It has bipartisan support with an almost identical bill from Senator Hughes coming over from the Senate. So we see growing support and concerns. Our Attorney General has spoken on this issue. Kim Paxton has put out an opinion on this issue a few years ago, and he makes the point. He puts the language out there. It's not just about the conduct of lawyers and the practice of law. It goes even further. It goes to what you're doing at your own law firm, your law practice, participating in a bar association. What is that? Having a robust debate about what religious liberty is on issues of sexuality, because we know that's what's been motivating the American Bar Association to change their rule. It goes even further. Business, social activities in connection with the practice of law. I don't know how many conversations, meetings, and robust discussions I've had at my church where people ask me, what is the law on these issues? What do you think it should be? And what's the latest on these type of subject matters? That's what lawyers do. And that's what I've been doing for close to 20 years. Now, some people, again, may want that to end, but that's not a good reason for this bill. Furthermore, the Supreme Court's been very clear about not having professional speech regulated. And as a matter of fact, there was a case that came up in Alaska where there was a law firm that was representing a female facility that was female only. It was a women's shelter. And there was a man that wanted to be in that women's shelter. There was a law firm that represented this shelter because they didn't want to allow that to happen. Well, the lawyer that was a part of that case, and this is a case out of Alaska, and I can give you the citation of this case. The lawyer in that case got a lot of scrutiny over and publicly, and as a result of that, the Anchorage Equal Rights Commission filed charges against his firm because of this type of representation. Now, thankfully, our good friends at First Liberty Institute, which I know you're familiar with, Chairman Leach and other members of this committee, stepped in and got some relief. But that's more of the things that we'll start to see happen. Christian lawyers and other people that hold specific views about issues of sexuality and life that are biblically based, it's not only going to impact their practice of law, it will impact that type of representation in our state if we don't have this type of protection. We've seen these growing concerns at the State Bar of Texas on these issues. It's not a hypothetical. The time now is to act and pass 2846.
Okay. Thank you, Mr. Sines. Members, any questions? Okay, thanks for your testimony. The chair calls Murtuza Sudarwala. I have you here on behalf of the Muslim Bar Association of Houston and yourself testifying for the bill.
Thank you, Chairman and members.
Is that correct?
That is correct.
Okay, go ahead.
Thank you, Chairman and members, for having me here. I know it's been late today. I am a practicing attorney, and I am the Vice President of the Muslim Bar Association of Houston. We are in support. I'm in support of this bill. It protects religious freedom, which is important for all faiths, Christian, Muslim, Jewish, and others. I believe this bill will allow us to protect people who are of a practicing faith or who are not. who are willing to be, outspoken in their legal practices, who are willing to associate or not associate with others. This will protect them. I, like other lawyers should, and on all elected officials in the state of Texas, we take our oath to the Constitution seriously, and our most important rights are enshrined in the First Amendment to the U.S. Constitution and also to the freedom of religion enshrined in the Texas Constitution. Causes change, and by this I mean today a lawyer may be representing a popular cause or representing an unpopular cause in the eyes of public opinion or the mob, quote unquote. I have represented all individuals from all walks of life, from many different faiths, and I believe that to be a part of my religious identity to do so. However, I respect those who believe that certain representation goes against their morals, and they should not be forced to represent such cases, and I think this law protects the ability for lawyers to choose who they ultimately represent and choose not to represent. And that echoes the Baker Shop case that the Supreme Court heard a few years ago from Colorado. The sponsor of this bill mentioned ABA Rule 8.4G. That is pending. It is prescribed as a model rule that, if implemented in the state of Texas or any other state bar, would cause a finding of professional misconduct if you were in violation of that, which talks about forcing certain values down the throats of attorneys. It is important to note that Rule 8.4G from the Attorney General's office was found in the prior opinion to be unconstitutional in their opinion. Also, at least one court around the country has found the rule to be unconstitutional. If we wait for the rule to be implemented here, it'll be too late. And this is why this statute and the change in law that it advocates for is important today. I will say I have practiced overseas in Saudi Arabia. There, a very common tactic is for the government to go after the lawyer if they're representing an unpopular cause, if they're representing a human rights activist or a member of a minority faith. While I don't believe that this country has come to that level, from the examples that previous witnesses have testified to, we have seen unsettling examples that this could happen. Two other points, and I'll conclude my remarks. The Texas Citizens Participation Act exempts disciplinary proceedings from an anti-SLAPP motion or a motion to dismiss, which is used as an early way to dismiss frivolous lawsuits which impact First Amendment rights. This law, by coming into the government code, would allow attorneys to establish their constitutional rights and allow such action to be dismissed, and balances the need for the state not to have to pay sanctions and attorney's fees to the winning party. And I believe this provides a good compromise in that direction. And finally, if Rule 8.4G or a similar rule is implemented by other state bars around the country, those members of the Texas bar or also members of another state's bar would be subject to discipline in that other state, which would then cause mandatory discipline in the Texas bar. I have witnessed conversations, unfortunately, amongst people plotting to do that to other members of our state bar, and it caused horror to me that this would be the weaponization of the bar grievance process. So I advocate again for this bill to be passed in its current stance. Thank you, and I open up to questions.
All right, members, are there any questions for Mr. Sudawalla? All right, seeing none, thank you to each of you. Appreciate you joining us. Chair calls Jonathan Covey. This will be our final witness. Jonathan Covey, is Chloe Goodman here? Okay, great. And Larry McDougall. Chloe, let's start with you. I'm glad you could make it back. I have you here on behalf, is it Chloe, is that right? Mm-hmm. Okay, Chloe Goodman, on behalf of Equality Texas and yourself, testifying against House Bill 2846, is that correct?
That is correct.
Okay, go ahead. Thanks for being here.
All right. Thank you, Chair and members of the committee. My name is Chloe Goodman. I am an LMSW, and I have another master's degree in public affairs. I'm here today on behalf of myself and Equality Texas in opposition to this bill, and that is in part on behalf of rural Texans. According to the 2020 census, Texas has the largest rural population in the U.S., with over 4.5 million people living in rural areas. And that's 4.5 million people with already limited options for attorneys. As a constituent services manager for Equality Texas, I've heard from a same-sex couple living in rural Texas that has been discriminated against on the basis of both race and sexual orientation, and have been systematically banned from pretty much all establishments in their town. They've had public officials turn against them, they've had local law enforcement turn against them, and at this point, the only option for them is to leave their town. People should not have to flee to cities for equal protection under the law or due process, and the state should be ensuring these constitutional rights for all of its residents. We have seen several bills this session that are intended to shrink the public space our community, the LGBTQ+ community, can occupy, and this bill does the same. Regardless of the author's intent, the impact of this bill would be to shrink the public space that LGBTQ+ people can occupy, and it will be discriminatory against LGBTQ+ Texans. But the thing is, wherever we are, we belong, regardless of other people's opinions.
How does this shrink the space that LGBTQ Texans are able to occupy?
So, like I said, the case that I mentioned earlier of a couple that that is being denied their rights in a small town, the only option they have is to leave. And so if we do not have access to resources in rural Texas, then we have to leave. And so that shrinks the spaces that we can occupy.
I'm having a hard time understanding why you're stating to the committee that the only option for that couple is to leave. Help me understand that.
I would, but I will maintain their confidentiality at this time.
No, not that specific couple. Please, that's not what I'm asking. A couple in that situation where you say that their only option is to leave that small town. I want to help me understand that.
As I said, they have been systematically barred from all of the establishments in their town. So I would implore y'all to think, if you could not go to any establishment in your town, what would you do?
But I'm trying to understand how this bill limits the spaces in which LGBTQ or any Texan can occupy. I want to understand your opposition to this specific bill.
Yes, this specific bill means that an LGBTQ+ Texan living in a rural town who already has limited options, if the attorneys in their town refuse to work with them because, say, they're transgender or because they're a woman with a wife, they have no option for an attorney in their town. And therefore, what are they going to do?
Okay, members, other questions? Members? Okay. All right, thank you for your testimony. The chair calls Jonathan Covey. Jonathan, I have you here on behalf of Texas Values registered for the bill, is that correct?
Yes, sir, Mr. Chairman.
All right, go ahead.
Jonathan Covey, Policy Director for Texas Values. I don't want to be duplicative. I had some background information I was going to give you, but Representative Kane, Chairman Kane covered that very well. I want to address a couple things. Previous testimony. Texas RFRA has some protections, but this bill makes it much, much better. Texas RFRA was enacted to prohibit government agencies from placing a substantial burden on a person's free exercise of religion unless that agency shows that the application of this burden is the least restrictive means of furthering a compelling governmental interest. So this is a balancing test. Basically, it's a four-part balancing test, and it's based on a case out of 2009 called Barr v. City of Sinton. This bill is a really good belt and suspenders approach, which it takes away the balancing test on the issue of religious freedom so that activist courts are absolutely required to protect religious freedom for lawyers. So I would say it's better to be proactive and protect future discrimination when the opportunity is afforded to you. And Andrew and I go way back, and I appreciate his testimony, but organizationally, I'm also just shocked about the ACLU's position on this. Like Representative Schofield was saying, this bill will ensure that the state bar doesn't go after attorneys' license if they don't like what a lawyer says, or if they don't like their verbal conduct. If lawyers are having to defend their free speech rights, and they are, because we've heard about that already, the standard is not high enough, and we need a bill to heighten this standard. So I would ask you to just please support this bill. It's an excellent bill, and we appreciate the author bringing it.
Now I'm confused. Can I ask a question?
Yeah, sure. Representative Flores.
I'm sorry. Maybe I don't know enough about how a lawyer was about to lose their license because of what they said. Can you tell me how, or how that would, how it manifests?
Sure. So this is based on protecting against ABA Model Rule 8.4G, which was a model
doesn't
rule.
exist in Texas, so there is no opportunity for that to happen.
Well, like we said, this would be a proactive.
I know it's preemptive, but tell me how a witness said that their father could lose their law license because of what they feel is their right to free expression. That's not the case right now in Texas, correct?
So this is protecting against and being preemptive. And like a witness said previously, by the time that a rule gets implemented, it'll be too late to do anything about it. This is making sure that lawyers are protected because, for example, if you're on a church board or you're a legal counsel for a religious organization and you say something, Model Rule 8.4G would have said that your verbal conduct might require you to be disciplined.
Okay, but it's not the case here in Texas currently. So I sit on lots of boards, and I don't feel threatened at all by the State Bar of Texas saying that I don't have the opportunity to, serve on whatever boards I want or feel that, align with my beliefs. So, so I wanted an example of how this could occur.
Right.
Like if a lawyer said what, for example?
Sure.
Like
did that answer your question?
No,
or
not really, but that's okay. I have to
for example, if a lawyer were to be talking in a
talk show,
in a seminar or a CLE course or something like that, and they were to say something against same-sex marriage, then if 8.4G were in place, this might actually threaten their ability to say that and their ability to have a license, and they could be disciplined for that.
Because it's an inappropriate forum to be saying something like that, expressing their views about somebody else's individual rights to
Well, 8.4G talks about regulating verbal conduct based on sexual orientation.
So a lawyer would be disciplined for saying something pejorative about a same-sex couple?
Could
be. Is that what you're saying?
Yes.
In a public setting?
It actually goes further than state and federal law protections that are in place.
But you do agree it's not currently the case, so the argument that it's not necessary at this point.
This was revisited by the bar, I think, as late as 2020. So they've considered it in the recent past.
But not approved it.
Members, other questions? Okay, thank you. Chair calls Larry McDougall. Larry, I have you here on behalf of yourself testifying for the bill. Is that correct?
Thank you, Mr. Chair. Yes, sir. I'm for the bill. I'll give you a little background that this gentleman just brought up. In 2020, there was a very strong movement within the State Bar of Texas to adopt Rule 8.4G of the ABA model rules. There was a lot of committee meetings, a lot of discussions, and actually it was moving forward in a direction where it looked like it was going to be passed with a matter of a few of us trying to stand in its way. But what happened was, in addition, I believe, as Representative Kane said, there's been a series of Attorney General opinions around the state that have around the states, not state, that have held it unconstitutional, including our Attorney General here in Texas. What put the death knell on it with the State Bar of Texas was a federal court out of Philadelphia ruled that 8.4G in and of itself was unconstitutional. And when that ruling came out, the State Bar put the brakes on it, and there's been no further movement at this time to implement 8.4G. 8.4G is one of these ABA rules that could basically punish a lawyer for any statements he makes that people consider offensive or out of line. And that's where the problem came with 8.4G. I mean, you couldn't sit there and say, I'm pro-police. You couldn't sit there and say, I'm a conservative, or I support General Paxton without having agreements filed on you on the way that 8.4G was drafted under the model rules. And why I'm in favor of this is, while the bar has put it to bed right now because of the federal court, and understand, I was present when that occurred, so I was in all the hearings and all the committee meetings. I encourage the passage of Senator Kane's bill, or not Senator Kane, he wishes, Representative Kane's bill, because what it does, it puts this to bed. It puts the issue to bed. I don't want the state bar membership, the board trying to resurrect it, raise it again in the future. And if we had this in place in our State Bar Act, that would put this issue to bed and prevent it from being resurrected. That's why I'm in favor of it.
Okay, thank you, Mr. McDougall, sorry. Any questions, members? All right, thank you. Thank you, each of you.
Thank you, Mr.
Does
Chairman.
anyone else wish to testify on, for, or against House Bill 2846? Seeing none, the chair recognizes Chairman Kane to close on the bill.
Hello again. All right, members, sometimes we talk about things. What are we trying to solve here? And this hasn't happened before, so why do we need it? I'd have said maybe 50 years ago we wouldn't have seen some of the rights that have become constitutional rights, and I wouldn't say that we might be one Supreme Court justice away from the 10 Commandments being taken off the Capitol lawn. It's a real issue. I think the bill could go even further and protect more things. I think our judges need protected as well. And so, with that, I ask for your favorable consideration, and I close.
All right, members, any questions for the bill's author? All right, seeing none, the chair will leave House Bill 2846 pending at this time. The chair now lays out House Bill 4128 and recognizes Chairman Murr to explain the bill. Did I everybody think committee sub? On 4128. Almost there, members. The chair lays out the committee substitute to House Bill 4128 and recognizes Chairman Murr to explain the sub.
Thank you, Mr. Chairman. Last session, I had the opportunity to pass House Bill 79, which established a system of regional specialized guardianship courts, similar to our child protection courts, with associate judges and adequate court staff. The current statute states that the associate judges and their staff of the specialized guardian courts are county employees. This bill would amend the appropriate section of the government code to transfer associate judges and their staff from being county employees to state employees and provide more duties to the associate judge, court coordinator, and court investigator that will enable them to better serve these specialized courts. These duties include to hear contested cases, oversee and monitor guardianships and well-being concerns, set dockets, and perform audits. The committee substitute amends the proposed legislation to reflect a legislative council draft version, and there are no substantive changes to that. And I'm happy to answer any questions if anyone has them.
All right. Thank you, members. Any questions for Chairman Murr? Okay, seeing none, will open public testimony. Chair calls Belinda Carlton, Drew Farmer, Terry Hammond, and Jim Locke. Belinda Carlton, Drew Farmer, Terry Hammond, and Jim Locke.
I think Belinda may have left early.
Okay. Drew Farmer. Am I saying that correct?
Yes.
All right. All right. Judge, good to see you. I have you here registered on behalf of yourself testifying on House Bill 4128. Is that correct?
That's correct.
Okay, thanks.
That's
Good to
correct.
see you.
I always testify on, in that I wouldn't want anybody to think I'm a lobbyist of any kind.
Oh, yes.
Because of
I get it.
judicial ethics.
I get it.
Okay.
Go ahead.
So, Chairman and the committee, thank y'all for allowing me to speak here today. My name is Drew Farmer. I am a recently retired county court at law judge.
Can you pull the mic up in front of you?
I'm a recently retired county court at law judge from Lubbock County. And so I've sat on the bench for 24 years. I'm also a member of the Texas Guardianship Association and was on the original committee of judicial work. We had a judicial workforce back in 2017 that put together the plan that is basically laid out in this bill. And I wanted to thank you for your time and giving the resources and the mission to the Office of Court Administration to look into our situation of guardianships here in Texas and the way that we protect our adults and the most vulnerable people in our communities and in the rural part of Texas. I want to direct your attention to an Office of Court Administration report that was done that Mr. Hammond has got in his testimony to show you how much work that the Office of Court Administration has done in this area to look at all of our rural and outlying counties as to how the guardianship system works and just be here as a resource for you. If there's any questions we can answer about how that plan was put together, but to point out to you how important it is that we take this particular population into consideration and protect their well-being, their health, and their property.
Okay. Thank you, Judge. Good to see you. Members, any questions? Okay, thank you. The chair calls Terry Hammond. Terry, I have you here on behalf of the Texas Guardianship Association and yourself registered for the bill. Is that correct?
That's correct, Chairman Leach. Thank you. Good afternoon to the committee, and thank you to Representative Murr for your work on this bill and in this effort, Senator Zaffirini as well, on the Senate companion bill. My name is Terry Hammond. My primary job is working at the Brazos County Courts at Law as the attorney who manages the guardianship docket. There are 2 county courts at law in Brazos County. We have about 250 guardian. Ooh.
That's not you. Take
All right, thank you.
I'm not that cruel. Go ahead.
About 250 guardianship cases in the county. And early in my legal career, practicing as an attorney, I was in the land of milk and honey, which is El Paso, Texas. Not frequently called the land of milk and honey, but to me it was because we had a statutory probate court. And we had an auditor, we had investigators, we had court staff that kept our cases in alignment and in good shape. And when I went to the Brazos County Courts at Law in Bryan, I saw life as it really is. And that is 2 county court at law judges, several thousand cases on their docket each, with no time to monitor the guardianships. I spent a year reviewing the guardianship cases in Brazos County, which is essentially what Office of Court Administration has done in their audits of the guardianship cases around the state. If you look at the attachment I've given you, page 6, that is the 2022 OCA report on their compliance review of the guardianship cases around the state. 26% of the cases in county courts at law and constitutional county courts miss annual reports. 46% are missing annual accounts. 46% are missing inventories. 34% altogether are out of compliance. That's a failing grade. When you look on the same exhibit at the statutory probate courts, which have these resources, only 17% of the cases are out of compliance. OCA has done the work that's needed to prove up the need for the specialty courts. From what I understand, there are about 12,500,000 Texans that do not have access to specialty courts in this state. 12,500,000 in 244 counties. These guardianships in these 244 counties are managed either by a constitutional county judge who may not be a lawyer or a general jurisdiction county court at law judge like the 2 we have that were on our judicial work group that made these recommendations who may and probably don't have sufficient staff.
30 seconds. Go ahead.
Okay, thank you. So House Bill 79 last session You guys did a good job. The legislature did a good job, got it over the finish line. No state funding attached. It's been 2 years now. If it was going to happen with county funding, it would have happened. None of these courts have been created. I want to finish by commenting on a lady named Rosamond Bradley, who went before the Senate interim committee hearing in 2016, who wrote to a judge, constitutional county judge, multiple times saying, I want my rights back. No response. We ended up having to bring people in from the outside who understood guardianship better to extricate her from that guardianship case. And I know Representative Schofield has said it can be a life sentence, and that is true if we don't have the right staff in place, the right courts in place. Finally, Chairman Leach, I would quote from the interim report that you issued, this committee issued in last October when we had the interim charges. Quote, your report, the legislature has an obligation not only to ensure rights are protected, but are actively enforced. And, quote, on the specialty courts, the legislature should continue to fund and utilize specialty courts where appropriate and where the efficiency and effectiveness of the judiciary can be improved. Thank you very much.
Thank you, Mr. Hammond. Members' questions? Okay, thank you for your testimony. The chair calls Jim Locke. Mr. Locke, I have you here testified on behalf of yourself, testifying for House Bill 4128. Is that correct?
That is correct.
All right, go ahead.
I'm afraid that I'm Exhibit A for the need for this bill. I am one of those county court at law judges who was in office when Terry came to kind of rescue us. We were not even aware to the extent that we needed rescuing because we did not have a good handle on the docket that was guardianship. I came out of private practice, then into the DA's office, and then on the bench, and I had handled civil and family and criminal and probate cases and some condemnation and appeals from Justice of the Peace Court before taking the bench. And all those are part of our jurisdiction. I had not done, to my recollection, a guardianship case. And occasionally we would try to go back through the guardianship files with an intern or somebody to catch up on that stuff, but that was wholly insufficient. And you probably don't have to work hard to imagine that constitutional county judges are not eager to spend money on a specialty court that does what they may think that they are doing already. But as important as the work is, because of the vulnerability of the people involved, the state, it looks like, really needs to step in and put in place what was passed 2 years ago. We appreciate your time and your attention to this.
Okay. Members, any questions for Mr. Locke? Okay. All right, thank you each for your testimony. Chair calls Lena Zupnet Zapata, Charmaine Wild, and Rick Ibarra.
I think Charmaine Wild had to leave too.
Okay, thank you. Charmaine Wild? Okay. Lena Zapata? I have you testifying on behalf of the Texas Guardianship Association and yourself. Is that correct?
Yes, sir.
Okay, go ahead.
My name is Lena Supnit Zapata. I am the owner and CEO of Mere Care Consultants, which is a certified guardianship program. And I work across the state of Texas in several counties, starting primarily where our business was born, which is in Nueces County. And we've had experiences where we've had to meet and address the concerns of the need for appropriate staff, judges, and the courts to manage the enormous caseloads that we have and the backlog that they have in that area in Nueces County and the surrounding counties. As you know, it has been stated that rural counties across Texas have minimal resources to manage the number of cases brought before them. We're seeing an increased need for oversight in the individuals that have severe mental health issues and more so with the elderly population, which is very vulnerable. I'm asking for support of HB 4128 that will meet the needs and the demands of those that are assigned to the courts for the protection through guardianship. So I thank you for your time. Appreciate you hearing me today.
I'd like to thank.
Are there any questions for the witness? Okay, thank you very much. Mr. Rick Ibarra, we show you as here for yourself and on behalf of the Texas Guardianship Association, and you are in favor of the bill, is that correct?
Yes, that's correct, Madam Chair. I apologize for slightly slipping up just a moment ago. Want to thank all the members of the committee for the opportunity to speak before you today. I also want to thank Lena for appearing as well. I've been appointed as guardian of the estate in several different counties throughout the state of Texas, including Travis County, which has a statutory probate court. I've appeared before Judge Herman, who was before this committee earlier today. I've also had the great fortune of appearing before Judge Locke's county court in Brazos County prior to him retiring just a few months ago. As Mr. Hammond testified regarding the OCA statistics, I was surprised about how many guardianships in the counties that do not contain statutory probate courts are out of compliance, because as someone who has to routinely work with my attorneys to submit the various documentation, the inventories, the accountings on an annual basis, that's something that a judge would normally call me up and have a status hearing. So as I started speaking with Mr. Hammond, he informed me a lot more about some of the rationale behind the statistics. I quickly came in support of wanting to testify before this committee and encouraging the committee to encourage the House and then hopefully the Senate to pass state funding, because as Mr. Hammond said, with 12.5 million Texas, which is about 40% of the population that resides in counties that don't have statutory probate courts, having that access to justice for those incapacitated individuals in those 244 counties is imperative. And it's imperative that the people or the organizations that have been appointed as guardians for those incapacitated individuals come into compliance with the requirements that they must meet. And so I'd like to encourage the committee members to pass in committee and hopefully on the floor of the House legislation necessary to approve the funding for these specialty courts. Thank you.
Members, are there any questions for the witness? Okay, thank you very much. Is there anyone else here who wishes to testify on, for, or against House Bill 4128? If not, the chair recognizes Chairman Murr to close on the bill.
Thank you, Madam Chair. I will make a couple of points. First, I appreciate the witnesses staying all day and offering your testimony. It means a lot. Second, we're talking about some legislation that we passed last cycle. Now, I've worked on that for 5 terms. And one thing we've omitted here, we've seen some maps. So I served as a constitutional county judge, and I can tell you that, you know, a lot of our constitutional county judges, they wear so many different hats. And they have probate, and they have jurisdiction over misdemeanors. And every so often, a guardianship will show up. but they're not that many. And so it's like doing your taxes once a year. It's not a familiar cycle, and there are absolutely no other tools in the tool belt to monitor, track, audit, and make sure things are done right. And we're charged with taking care of a person's property, their money, their estate, and their own well-being. And it's one of the few areas of law, and this is why it was so important to me, where a constitutional county judge above all, but all the judges we've heard, has personal liability. You literally sit back and you say, you get to rule on people going to jail or prison. You make determinations in civil matters, but this is a spot where if you're not paying attention to it, you can actually be on the hook for dollars as a judge. And none of these rural counties and bigger counties, I have one stoplight in town. So for me to compare that to Brazos or Lubbock, I mean, it's a lot. We don't have auditors. We don't have investigators. There's no way to keep track of that. And so we don't want that to be a liability that's there. And so this is all designed to be an accessory where counties will want this associate judge to come to town with the cavalry, with their helpers, and help keep track of things. And so every county is going to want to use this. So the changes we're making structurally will support the ability for the state to help fund this and not just counties. I'm grateful for y'all. I appreciate your support, and I hope that we move the bill. I close.
Thank you very much. At this time, the chair withdraws the substitute, and if there's no objection, HB 4128 will be left pending. Is there objection? Hearing none, HB 4128 is left pending. All right. The chair lays out House Bill 103 and recognizes Chairman Murr to explain his bill. We do have a committee substitute. Would you like to go ahead and take up this substitute?
Yes, Madam Chair.
Very good. Representative Schofield offers up a committee substitute to House Bill 103. The chair recognizes Chairman Murr to explain the substitute.
Thank you, Madam Chair. Recently, the Texas Attorney General issued an opinion that stated that a former constitutional county judge does not meet the definition of a retired judge in the government code and therefore could not be appointed as a visiting judge. And so what I'm doing and what we're talking about with this bill is we're talking about constitutional county judges. And so this is going to be in very rural counties. So we're talking about 160 to 200 counties in which the county judge handles judicial obligations. There is a provision under the government code in chapter 26 that allows that sitting constitutional county judge to actually appoint a retired judge as a visiting judge. So imagine if that judge is going to go out of town for training, has a family matter to attend to, is going to have a health issue or a vacation, then they want to make sure that somebody's available. Well, this ruling said that the definition of retired judge in a different section of code cannot be pulled in and does not mean the same thing. And what that did is that took available folks off the table that could fill in when needed. And really, when we look at that, that is our rural parts of the state, because we will have visiting judges in urban and larger suburban areas. So that is what this bill does. The committee substitute, and I drafted it myself, it's a ledge council version, very clearly adds a definition of former constitutional county judge. And so we're very clear that we mean that someone who has served in the capacity of county judge can then be a visiting judge under this specific section of the government code. And so I think it'll be very beneficial. And so I'm happy to answer any questions, and I believe that we do have one witness.
Are there any questions for Chairman Murr?
Awesome.
I'm trying hard to think of one.
Okay, very good.
Thank you.
Byron Ryder? Chair calls Byron Ryder. We show you here on behalf of the County Judges and Commissioners Association and on behalf of Leon County.
That's correct.
Is that correct? And you'll be testifying for the bill.
Right. Yes, I appreciate y'all. Thank you, Chairman, Vice Chair, Committee, everyone. Nice to be here. Yeah, I am Leon County Judge. I am a constitutional county judge, and I've been judge for a little over 20 years now. And I am for House Bill 103. And what it would do for a county my size or small to medium-sized counties would be astronomical, because lots of our counties do not have county courts at law. We don't have district judges that live in our county. And to ask another judge from another county or whatever that could cost us some money on travel or eating or whatever it might be. These Constitutional County judges, we're a real close family, and we like to help each other. And I've even got an order with the county judge right next to my county where she'll come over and do court for me if I need her, if we have a big docket, or if I'm sick, or if I'm out, or whatever, like the representative said. It's very important that you got to realize that in these small to medium-sized counties too, that the budget is very tight, and it's hard to fund something like this over a period of time. It'd be very easy to use a visiting judge or a former judge around your county, and that's what we'd like to do. I'm here in favor of the bill. I'd like to see y'all vote for the bill. It would sure help financially these counties that have to fund these kind of judges. Thank you.
Thank you so much. Members, are there any questions for this witness?
One question. As a constitutional county judge in a rural county, are you not also under statute the budget officer for the county?
I am.
And that means that you have an obligation to prepare the budget.
That's correct.
And so my point with that is every person who has served as a constitutional county judge worries about dollars day in and day out. And we're simply putting a tool that we thought was in the tool belt back on the table with this. And so we can lean on these retired constitutional county judges to help. And sometimes all we have to do is, bring them coffee in the morning, and that's it.
That's right. Pick up the phone, call them, and they'll be there. And most time they'll do it for no cost.
Fantastic. And again, this only applies to constitutional county court.
That's correct.
Thank you very much for being here today.
Thank you.
Thank you. Is there anyone here who wishes to testify on, for, or against House Bill 103? If not, the chair recognizes Chairman Murr to close on HB 103.
Thank you. I close.
Very good. At this time, the chair withdraws the substitute, and if there's no objection, HB 103 will be left pending. Is there objection? Hearing none, HB 103 is left pending.
Did Murray do 103? He did. Okay, the chair lays out House Bill 3473. This is a bill relating to establishing the, this is a bill relating to the Court Reporters Advisory Board. Excuse me. Currently, court reporters in Texas are regulated by the Judicial Branch Certification Commission. At the Supreme Court of Texas, they're represented by the Court Reporters Certification Advisory Board, which is currently comprised of 7 members, including 1 district judge, 1 practicing attorney, 2 official reporters, 2 freelance reporters, and 1 reporting firm owner. Members, this bill, House Bill 3473, is short and simple. It would add 1 captioner and an additional reporting firm owner to the advisory board, bringing the total to 9 members. It would require the Certification Commission to post upcoming vacancies to the advisory board, to accept resumes, and to conduct interviews for those interested in appointment. And finally, it would allow the Certification Commission to recommend to the Supreme Court 1 or more of the qualified individuals for appointment to the advisory board. Happy to answer any questions, and I will reserve the right to close. There are 2 witnesses who have been so patient. This is the problem when you sign up to testify on one of the chairman's bills, is you come last, but I appreciate you being here. Ms. Fiasco, and then my friend and constituent, Ms. Usher. Let's start with you, Ms. Fiasco.
Actually, if you don't mind.
Okay. Ms. Usher, great to see you. I have you here on behalf of the Texas Deposition Reporters Association and yourself testifying for House Bill 3473.
That is correct. And thank you, guys. I know it's late, so I'll be quick. Good evening, Mr. Chairman, members of the committee. My name is Karen Usher. I am the president of the Texas Deposition Reporters Association. I'm here testifying in support of House Bill 3473. I'd like to thank Chairman Leach for sponsoring our bill. House Bill 3473 proposes updates to the Court Reporter Certification Advisory Board. The advisory board was established to provide guidance for the JBCC, the Judicial Branch Certification Committee,
Yes.
and to, regarding matters involving the court reporting profession. The makeup of the advisory board was comprised to provide reasonable representation to freelance reporters, official reporters, and court reporting firms. However, since its inception, there has been blurring of representation as reporters change classifications, reporters retire, and businesses are sold. For example, a captioner currently sits on the board, but there is no provision in the statute for captioners to be represented. The captioner currently sits in or is occupying a position intended for a freelance reporter. So it's leaving freelance reporters with insufficient and unequal representation. The intention of this bill is to, this bill increases the board from 7 members to 9, and it will provide representation for captioners. Additionally, the statute, as it's currently written, provides no clear and equitable means for filling appointments to the various positions. The intention of this bill is to ensure that all classifications of reporting are represented at all times and provide clear and transparent guidelines for appointments, reappointments, and vacated positions. And I'm happy to answer any questions.
Okay, Ms. Usher, thank you. Members, any questions? All right. It's always great to hear from you. Thank you for your patience.
Thank you.
The chair calls Gail Fiasco. Gail, I have you here on behalf of the Texas Court Reporters Association and yourself, testifying for House Bill 3473.
That's correct.
Okay.
Again, I'm Gail Fiasco. I'm an official court reporter for the 59th Judicial District Court in Grayson County, and I'm also the president of the Texas Court Reporters Association. Thank you, Chairman Leach and committee members. The Texas Court Reporters Association is for House Bill 3473. The intention of House Bill 3473 is to ensure fair and equal representation by appointing CSRs who are actively reporting depositions, court proceedings, or providing captioning services. I'll just be very brief. Thank you very much for your time and your patience and your consideration today.
Okay,
Thank you.
Ms. Fiasco, thank you for your question or your testimony. Members, any questions? All right, thank you both.
Thank you.
I appreciate you. Does anyone else wish to testify on, for, or against House Bill 3473? Safe travels back home. Thank you for being here. With that, seeing no other questions, members, do you all have any questions for me? No? The chair will leave House Bill 3473 pending at this time. Members, the chair lays out House Bill 3157. Currently, a judge can order that any funds belonging to a decedent be paid directly to a funeral home to pay for funeral and burial expenses not to exceed $5,000. However, current law does not allow the estate to reimburse others who have paid for the funeral and burial expenses, including family members. This bill is a simple fix to address this issue by granting a judge the authority to order that funds belonging to a decedent be reimbursed directly to the person who paid for the funeral and the burial once they have provided the required documentation showing expenses. Members, I'm happy to take any questions. Okay. Does anyone wish to testify on, for, or against 3157, House Bill 3157? Okay, seeing none, the chair will close and leave House Bill 3157 pending at this time. What? Okay. We have one more bill. The chair lays out House Bill 2965. He's on his way. Yeah, I'm sure you can. Hang on, he's running over from right across the hall. All right, the chair lays out House Bill 2965. I'm going to lay this out for Representative Vasut. Members, during the 86th legislature 2 sessions ago, we passed House Bill 1999, which created Chapter 2272. The chapter was created to address the issue where on public projects, governmental entities would file lawsuits against contractors without really providing them the opportunity to inspect and remedy the concern. The chapter specifically required that the governmental entity provide the contractor with the opportunity to inspect and then repair the construction defect. I should know because I was the author of this bill. Unfortunately, some local governmental entities have been going around that law. They've been forcing contractors to waive the chapter either before filing a bid or after contracts have been awarded. This is an unintentional loophole that apparently I missed, according to Representative Vasut, that these entities are taking advantage of and has negatively affected the predictability of the business environment. This bill expands the scope of projects to which the law applies. Under the bill, civil works projects will now be included, which means that city and county roads and other types of infrastructure will be subject to the right to repair. Additionally, the bill will now prohibit governmental entities from forcing contractors to waive the provisions of that bill, Chapter 22272, in contract. Okay, there is a committee substitute. Representative Schofield lays out the committee substitute. And the committee substitute members clarifies what civil work projects are not subject to this section. We're adding river authorities back in because their infrastructure is different from some of the others that we're trying to pull in, such as roadways. The vast majority of their items will fall under chapter or section 2272.008 regarding emergency repairs by governmental entity. So with that, I'm happy to answer any questions, and I respectfully request the right to close.
One question.
Yeah.
Question for Mr. Vasut. When in his layout, the chairman said that this addressed an oversight of his from the prior bill. Is this bill a direct insult to the chairman's ability to legislate?
The exact words are unintentional loophole. Is that what's your explanation?
Well, it depends on what the definition of is. But I'm sure that the chairman wrote an excellent bill, and we're just going to make it a little bit better.
All right, members, any other questions? All right, seeing none, we'll open public testimony. The chair calls Craig Island, Andy Harris, Ryan McKee, and Jeffrey Tawaha.
It's Tawawa.
Tawawa. Look, after last week, yeah, and so
Andy Harris actually had to step home due with a family emergency, so he won't be here to testify.
What about Ryan McKee?
He's here.
Okay, Ryan, come on up. Yeah. All right, Mr. Tawaha, I've got you here, registered on behalf of the Associated Builders and Contractors of Texas, testifying for House Bill 2965. Is that correct?
That's correct.
All right, go ahead.
Good afternoon, Chairman Leach, Vice Chair Johnson, distinguished members of this committee. My name is Jeffrey Tawawa, and I'm here on behalf of the Associated Builders and Contractors of Texas to speak in favor of the committee substitute for House Bill 2965. ABC Texas is comprised of over 1,600 members across the state and represents all specialties within the Texas construction industry, including the industrial and commercial sectors. As Chairman Leach referenced, during the 86th legislative session, the legislature passed the right to repair law, which required governmental entities to require contractors to inspect and then repair potential construction defects prior to a governmental entity initiating a lawsuit. In the past, there was a segment of plaintiff attorneys who would go to school districts as the warranty was about to expire and provide the school district with a list of defects and then file a lawsuit against the contractor, subcontractor, and suppliers. The right to repair law was designed to allow the contractor the opportunity to inspect and then repair these defects. The lawsuits could later then be filed if the defect was not repaired properly or if there were still issues of concern. Unfortunately, despite the legislature's best effort to address this issue, governmental entities have been working to circumvent this section by requiring contractors to waive this right either through contract or after the bid had been awarded, or they require them to waive this to even submitting a bid. This is clearly a violation of the intent of this law and must be remedied. Lastly, there was an exemption for civil works project. HB 2965 will remove this exemption, and the committee substitute will preserve an exemption for a very specific governmental entity. Since the passage of this law, we've seen instances of city and county roads where our members will construct a concrete road, and then after a significant weather event, such as the ones we've seen recently, there may be some cracks, but rather than call the contractor to repair the road, they will repair it themselves or hire another contractor and then sue the original contractor to recoup the costs for repairs. Under the committee substitute, the projects will not be subject to this law, and the contractor will be allowed to inspect and attempt to repair the defect before the lawsuit can be filed. Thank you for your consideration. I'm happy to answer any questions.
Okay, thank you for your testimony. Members, any questions? All right, let's go to you, Mr. Island. The chair calls Craig Island on behalf of the Texas Trial Lawyers Association and yourself testifying against House Bill 2965. Is that correct?
Yes.
Okay, go ahead.
Thank you, Mr. Chairman. And I did visit with Representative Fasoot yesterday, and we are not against the provision that says you cannot waive this by contract. After coming here and talking to you on the RECLA bill, to get that bill not to be waivable, couldn't come in and say, well, it's okay to waive it here.
Appreciate it.
So we do not oppose that particular section. However, you remember, and I know Representative Fasoot, I don't think you were not here in 2019, whenever we passed 1999. And there was a reason that we did not include civil work projects in the bill, and it was a very hard-fought, negotiated bill, and this was specifically excluded for reasons. And those reasons mostly were the fact that in these civil works projects and critical infrastructure projects, there is already an elaborate right to repair, right to inspect that they go through. And so that's why they were excluded. And I think if you go back to that session and look at the testimony and look at this was not a mistake of carving out critical infrastructure projects and civil works projects. Perhaps there's something about repairing something that was already done. I don't know, but I just wanted to bring it to the committee's attention that this was not an oversight. It was a very hard-fought and negotiated bill, and there was a reason.
Is this being waived frequently? Is it common practice for folks to get around the bill by waiving it?
I have heard many instances reportedly of that. I don't know, I can't tell you how common, prevalent percentages or statistics, but
okay.
I have heard it.
Okay.
So like I say, we do not oppose that provision. Only the provision in section 1 that adds civil work projects back in, except for river authorities, which I believe is LCRA, and maybe some others, but there's a reason. That's because there's other processes in place already in such projects and in those contracts.
Okay. Members, any questions for Mr. Island? Two of you keep talking. All right. Chair calls Ryan McKee. Ryan, last witness of the day.
Yes.
For your patience.
No
I've got
problem.
You're registered on behalf of yourself testifying for the bill. Is that correct?
Yes,
All right,
that's
go ahead.
correct, and I pretty much am going to say what he said. So, Chair and members of the committee, my name is Ryan McKee. I'm a construction lawyer with Andrews Myers, and I'm here in support of House Bill 2965. 4 years ago, this body passed House Bill 1999, which created Texas Government Code 2272. This chapter was great legislation that simply allowed for contractors to be provided written notice and an opportunity to repair alleged construction defects prior to being sued by a public entity. Unfortunately, some public owners are circumventing this law by placing language in new contracts that waives 2272. Many of these contracts are publicly bidded work, and contractors have no choice but to accept this waiver. We believe the legislature's intent should be followed, and therefore in support of House Bill 2965.
Okay.
Thank you.
All right, thank you, Mr. McKee. Members, questions? All right, thanks for your testimony. Thanks to each of you. Does anyone else wish to testify on, for, or against House Bill 2965? Seeing none, the chair recognizes Representative Fasoot to close on his bill.
Thank you, Mr. Chairman. Members, we're going to keep working, and we'll bring you back potentially some other language. We'll let you know, keep you posted, and happy to field any questions now or offline.
Okay, members, any questions? All right, with not seeing none, the chair will close public testimony and let you close on you just closed on your bill. No questions. All right, we're going to withdraw the committee substitute to House Bill 2965 and leave House Bill 2965 pending at this time. Members, that concludes today's agenda. Is there any further business for the committee to address? If not, the chair moves to adjourn. Is there objection to that? Hearing none, the committee stands adjourned subject to the call of the chair.